When is the date given here? Yeah, come on, date idre list madi. If date had been given, it will get listed. They verify that.
This is a fresh matter, Your Lordship. It was before this honorable court, but it did not reach, Your Lordship. The urgency is that the respondent is constructing a trench, Your Lordship.
All fresh matters, preliminary hearing, some of the B group matters are also reaching.
Your Lordship, it was listed, it was passed over, then it didn't reach, Your Lordship. I filed an IA, early hearing. On that day also it didn't reach. Therefore, the urgency is that they're constructing a trench on the road which connects my property to the public road. The trench where it is constructed is a public road.
Yes, it was passed over for you to get instruction tomorrow. Yes, madam.
By submission, my lord. After your lordship order on 23/7, my lord, what the registry did is that they modified your order, my lord, and they reclassified the
registry
entire
cannot
petition.
modify our order, madam. Don't make.
Yes, my lord. May this file come before your lordship can make out, my lord. In that case, okay, I accept. They have all the power to reclassify as their wish, because first they only classified GMREs and put before your lordship. After your lordship order, they have classified it into EDURS and put it totally before another bench, my lord. So my problem is the procedural delay and the legal injury is causing to me because.
So it's been reclassified. It will go before.
Delinking to be done, my lord. Now. Delinking to be done because criminal petition for it.
If it is a reclassified matter, it won't come before us. There are a lot of matters where the classification is not done properly. We have been directing them to
no
do the
only for because the linking order done by your lordship, my lord. So kindly be de-linked that order, my lord.
Madam, if it is education matter,
education let that matter only be there before the education branch, my lord. Only I am seeking for the de-linking of the order because
yes,
of
just
the
give the
criminal
memo,
petition.
If you are not
kindly,
able to understand,
lord,
we can't help you.
Child's schooling is pending, my lord, and the criminal branch, it has reached in the order stage, my lord. 3 years I have fought. Now it is because the fresh petition, it is being
Madam,
linked.
can you have some patience to listen?
Yes, madam.
If it's a classification of education, it will go before the education
Yes,
roster.
yes, that petition, let it remain. Only I am seeking for the de-linking of the matters because criminal petition has been linked with this educational matters and posted before the education.
That your request that it was linked.
Yet I requested so that for the convenience of myself and the child, my lord, that convenience is not happening. Only for de-linking I am seeking, my lord. Kindly, my lord. Tomorrow.
If we don't have jurisdiction, it can't come before us. Please
no,
understand.
Only recalling your order for de-linking.
Even no, that can't.
Only for de-linking I am seeking, my lord. I am not asking for reclassification. Let it stay before educational. I will go before. Only de-linking of the criminal petition associated.
Yes, please.
Tomorrow, my lord. Kindly, my lord.
If it is a classification which comes before us, it will come before us tomorrow. Otherwise, it will go before the concerned judge.
For recalling the order also, because your lordship has passed the order.
Have you filed a recall application?
Yes, a recall application is pending.
You have filed?
Yes, I have already filed.
Then you should make that submission. Recall application and post it.
Yes. Apologies, my lord, for my submission made earlier. My lord, my only prayer in the writ petition, my lord, let the bank authorities keep the amount, mark the lien which is.
Mr. Counsel, there is a cyber command who is helping you out with that. We have set it up. If you don't want to go there, then we'll have to send you to Delhi.
My lord, there is 36 lakhs in the bank account. Disputed amount is only 1 lakh, my lord.
Cody, you want to wait here for eternity, please wait. Give it.
My lord, this is a pending matter from January 2024, my lord. It will not come.
January 24 will come very soon, don't worry.
My lord, I've moved multiple memos and it hasn't come up, my lord.
Yes, please. Even if you file 100 memos, it won't come. It will come in seniority. Next.
With your lordship's leave, may I make a small request? Serial number 86, my lords.
Wait till it is called out.
Well, I'll just explain the urgency.
You are in a hurry before it's been called out?
I'll just explain the urgency, my lords. It pertains to Archaka rights. I've been in
We are not going to make any exception in the seniority of the list. Please.
Last 4 occasions, it is making the list. It is not reaching the bench, my lords. My term expires in 3 days. In a calendar year, July 15 to 31st is
Turumadi.
List number 1, page number 5, serial number 32 to 36.
My lord, serial number 28, I informed the other side. I need to file my objection and connected matter is before
28.
28, my lord. This is that pipeline from the other side. You're not.
Hemavati pipeline matter.
I informed Shruti madam, I called her and I told.
She has no objection.
No objection. And quota connected matter is pending before the quota number 12 dictating orders and till today.
Madam,
order has
that
not
matter,
been
we also
passed.
made a submission before this court that there is a similar petition with regard to the land acquisitions that is posted for orders, my lord. So there is
If both of you make that submission, please make that submission. Let her be here and then we'll connect. Like the other matter, she asked her to be connected.
No,
Now
it cannot
she-
be connected
no,
because
not to
it's already
connect.
posted for orders.
Orders.
Already dictating orders, since from 2 weeks it is going on.
When both
Today
of you
also-
are here, then you make your submission, Mr. Bhima, not behind her back.
No, I informed the,
That you are going to connect it.
yes, madam.
Let her be here. Let us say no objection. We'll record both your submissions.
Yes, much.
Serial number 35.
Yes.
Signed. We have also-
You're for?
We are for ICC. For the respondent.
Have you informed the petitioner? Which respondent are you for?
Bank.
We are for the bank, my lord, ICC bank.
6 and 7. my lord.
Francis Xavier.
Francis Xavier.
At the request of council for respond number 6 and 7, relist on 27th August.
Page number 6, serial number 37 to 41.
Sir, 36 list number, 36. list number.
36.
Yes. So the other day it was a passover for linking with other matter. But link ಮಾಡ್ಬೇಡಿ ಅಂತ ಕೇಳ್ಕೊಂತಾ ಇದ್ದೀನಿ sir.
ಏನಮ್ಮ?
Sir, this is a case of river rafting.
My lord, this
And there
matter,
are cases of 2 cases, the subject matter is the same. But the content and the matter inside the case is different. So I request not to join the matter. So.
Nothing is joined here. It is
nothing
only
is
one
joined.
matter.
On the last date of hearing, we made a submission. There's another matter at serial number 81. This is with regard to the contract issued for the river rafting in Coorg district, the river Kaveri. Well, the deputy commissioner has fixed certain amount of raft to be owned by, there are several applications, my lord. He has divided. Now, he is a private landowner who wants to set up a private jetty in his.
We are at the mentioning stage. What do you want? You want adjournment? What do you want?
Absolutely no, sir. It's not linked. It's not linked as of today.
I just,
That can be decided when the
that
matter
day,
is
other
taken
day
up.
it was linked, so only sir.
See the cause list is not linked. Yes.
Page number 6, serial number 37 to 41. Page number 7, serial number 42 to 48. Page number 8, serial number 49 to 53. Page number 9, serial number 54 and 55. Page number 10, serial number 56 to 62.
Serial number 59, my lord.
Yes, madam.
Seeking for an accommodation, my lord. Senior has
59 at the request of
Lord,
the.
this matter, my lord,
Senior has
short date may be granted, my lord, because they said it's a medical emergency. This
He
is,
appeared yesterday
But he has his eye checkup today, my lords. That is the issue.
and he told us yesterday that he will be appearing regularly.
Yes, my lords, but yesterday he was available, today he has the
So only
checkup.
today. At the request of council for the petitioner, relist on 10th August. Interim order earlier granted is extended till 10th August. He can be here.
Yes, my lords, but the other matters regarding the same
no,
fertilizer
that
issue is
is,
posted
no,
on
the other matters are with related to the cancellation of
cancellation of license.
licenses. This is
This
Yes,
is
you finish
district
it.
license
confiscation.
only.
This is a confiscation matter, complete different matters.
10th August.
Obliged.
Page number 12, serial number 63 to 67.
Serial number 67, have taken up after 10 days, my lord, for the petitioner.
Have we informed everybody, Mr. Ramesh?
Not in this matter, in all these matters, my lord, interim order is granted.
Have you informed everybody?
No, my lord.
Then don't mention.
Please.
Page number 13, serial number 68 to 70. Page number 14, serial number 71 to 73.
Yes.
Serial number 76, my lord, she has been
76. Yes.
responding to.
Have you informed everybody? Then don't mention, please.
My lord, in this previous matters you have passed not before me, so when the respondent to is M.R. Sitaram.
R2,
R2.
RTR.
MR Sitaram.
Post before a bench of which SGRJ is not a party. Are they working?
Serial number 89, memo for withdrawal.
89. Memo for withdrawal, dismissed as withdrawn. 88, memo for withdrawal, dismissed as withdrawn.
Memo not filed.
Huh?
88, memo not
Memo not filed, but 89 months.
List number 1 for being spoken to, serial number 1, R.B. Sadashivappa.
Yes. Who will appear?
We haven't received the file.
There are only
One copy is kindly.
Devraj Jalli. There are only two things that to clarify. Okay. Pass over, let him come.
Lord, may I kindly pass it over?
Yes.
2:30 minutes.
He's coming.
He's coming, my lord.
Pass over.
2:30, my lord.
2:30 again.
Serial number 2, Satyanand B.S.
The matter has been moved for being spoken to learned counsel for the petitioner.
Prior
Seek
to-
permission to withdraw the above
Can I
petition.
make one submission? I'll just impress upon your lordships. One point I will just canvass it to your lordships. Prior to withdrawing it, my lord, if your lordships is
You
not
want-
convinced, my
We have
lord.
already passed the order. You want withdrawal is what you submitted.
Yes, yes.
We'll permit you to
ನಾನು
withdraw.
ಒಂದು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರ್ತೀನಿ, I will leave it to your lordships.
After that, we won't permit you to withdraw.
Very ಏನಂದ್ರೆ
After that, we won't
I
permit
do
you.
understand that, my lord. I do
You
understand.
choose. You are entitled to argue.
No,
We are
it is
entitled
not
to pass
that, my lord.
orders.
Public exchequer will be caused is the only, my lord, my concern is
That is your clause, Mr. Satyanand.
that
You have drafted the clause.
that is there, my lord. Appointment could have been done
You again,
At-
appa,
Bangalore also.
withdrawal,
Withdrawn
withdraw. Seeks permission to withdraw. Petition is dismissed as withdrawn.
with liberty, my lord, to urge all these grounds under
We are
section
not going to
16.
say anything of that kind.
16,
We are not going to say anything of
at
that.
least to that extent, at least. Adike, with that condition,
We are not going to say anything which can be misused there.
please. Please.
Fresh matter, serial number 3, Srikanth MP.
Mr. Srikanth?
Seems to be a service matter, my lord. I have to go with service roster.
There is classification.
Challenging the selection process.
Financial service and financial benefit. A perusal of the papers indicates that the matter relates to service roster, registry to verify and post before the appropriate bench.
Serial number 4,
This case, my lordship, Assistant Conservator of Forest passed an order against the dead person, my lordship. Improved order which is in Annexure A, page number 14,
14.
against VG Koila. And the death certificate I have produced as per Annexure B, page number 22, my lordship.
22. He
It was
expired in
died on 13 to
2015.
2025. Proceeding was initiated in the year 2014. Against which wife has preferred an appeal. Appeal also came to be dismissed on the ground that she has no locus standi to prefer an appeal.
Monday
Rising out of the same
they had filed
party,
a similar matter.
similar matter, your lordship has disposed of.
Same person.
Same person, between the same persons. So,
And AGA for respond number 1 to 4. Third. Yes, same order.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಗ್ರೌಂಡ್ ಆಫ್ ಡಿಲೇ ಅಂತ ಆಗಿದೆ ಫೋರ್ತ್ ಪ್ಯಾರಾದಲ್ಲಿ ಇಟ್ ಇಸ್ ನಾಟ್ ನಾನ್ ಮೇಂಟೈನಬಿಲಿಟಿ ಆಸ್ ಆಲ್ಸೋ ಆನ್ ದಿ ಗ್ರೌಂಡ್ ಆಫ್ ಡಿಲೇ ಅಲ್ಲ ಶಿ ಹ್ಯಾಸ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ಎನಿ ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡಿ ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ಅಪೀಲ್.
Non-maintainability as also delay. Both of them are there. Maintainability locus ಅಂತ ಹೇಳ್ಬೋದು ಅಷ್ಟೇ.
serial number 5, Murli M.
Petitioner,
Yes, Mr. Manjunath.
petitioners are agreement holders of the property, my lord.
Hmm.
Under sale agreement dated 24/1/2014 with respondent number 2 and 3, my lord.
Hmm.
Subsequent to the filing of the specific performance of the suit,
Hmm.
the respondents 2 to 4 file a petition before the Assistant Commissioner, collusive petition, and get the gift deeds quashed, my lord. And file written statement before the specific performance code saying that gift deed has been quashed and we don't have any right in that property. And now the mother has filed a impleading application in that suit, saying that I am the owner of the property.
Seek for damages now.
My husband has entered into a sale agreement, my lord, with respondent number 2 and 3. Mother has gifted the
But
property.
what
into-
is your locus to stand, challenge this order?
I'll just come in. On 5/3/2013, my lord, respondent number 4 gifts the property to respondent number 2 and 3, my lord. They have entered into a sale agreement with my husband on 24/1/2014, my lord. 24/1/2014.
You are only an agreement of sale holder, it's inchoate agreement.
1 minute.
Right.
After that, my
Under
lord.
section 54.
Yes, ma'am. After that, my lord, I issue notice saying that come and register the property. And I file a suit against the respondent number 2 and 3. That suit is pending, my lord. When the suit was pending, there is a collusive petition filed before the assistant commissioner.
You are repeating the same thing, Mr. Manjunath. We heard you first time.
Yes, ma'am.
What is your right? You are an inchoate, the inchoate rights and
My suit
agreement
will
of
become
sale.
infructuous, my lord, because of this order, my lord.
How can you challenge this order? You have no right.
I was not a party to that proceedings, my lord. Now the respondent number 4 also has got impleaded in their suit, saying that I have already got order from the assistant
You
commissioner.
can take up all the contention in the suit.
Unless this order is stayed, I cannot proceed with that suit now, my lord.
This is a very limited jurisdiction
Yes, my lord.
under Senior Citizen Act.
Yes, my lord.
If you are alleging fraud, that fraud will have to be alleged in the suit.
But until this order is stayed, I cannot proceed with that order because the trial court will say that already assistant commissioner has passed the order, you don't have locus standi.
You cannot challenge it in the suit.
Even in the order, my lord, the respondents have admitted the allegations made by the mother. It is apparent on the face of the record, my lord, in the order. They admit all the allegations made by the mother, my lord, in the objection statement. Within 2 hearing dates, it has been quashed, my lord.
You'll have to convince us on the locus. We understand your problem,
Yes, my lord.
but the act has a limited jurisdiction.
I
That's
know,
the
my lord,
problem.
but in the trial court, my lord, unless this order is stayed, I cannot proceed. Apparently, I can convince on the fraud played by the respondents, my lord. It is in the order itself, I can convince you, lord.
Let AGA accepts notice for respond number 1.
R1.
Issue notice to respond number 2 to 5, returnable by 8th September. Please do some research and see if we can look into that or not.
Much obliged.
If we can't look into that, it will get dismissed.
Until then,
No implement.
at least the order, my lord.
ಏನು ನೋಟಿಸ್ ಮಾಡಿದೀವಿ ಬರ್ಲಿ ಯು ವಿಲ್ ಹ್ಯಾವ್ ಟು ಕನ್ವಿನ್ಸ್ ಅಸ್.
Okay, ma'am.
Serial number 6, Janardana Ji.
Yes, Mr. Janardana.
That's my additional document, Lords may see, but on 10/8/23, but the first petitioner and second petitioner are having the SP account in first respondent.
Hyderabad. Canara Bank,
TP Mutana.
TP Mutrana for respond number 1. Notice to respond number 2 is deferred for now. Counsel for the petitioner is directed to appear before the cyber command tomorrow, 30th.
And it may be connected with, along with another matter, is Lords order notice, that is State Bank of India, 39,590.
39,000
39,590 of 25.
birth code.
Right.
Connect with source. Relist on 13th.
7, Pujita BP.
7, Ms. Pujita. Ms. Pujita. And AGA accepts notice for respond number 1 to 4. Council service ಆಗಿದೆ. Relist on 12th August.
Serial number 8, Vijay Kumar.
Yes, Mr. Vijay Kumar.
Final decree not being registered by the, final decree is passed by the trial court, that your lordships will get at annexure E at page 77. Now, when I present it, after the court gives me that,
11E sketch.
no, they don't ask for 11 sketch. What they say is you give me all the properties because what is allotted to me, my lords will get at page 99. Only one property is allotted to me.
Have they issued you any endorsement?
No.
They have not given any endorsement. They don't even, we can't even upload that document.
Your lordship may kindly see the prayer, my lord. Just read the prayer.
I'm seeking a mandamus directing them to register the document.
To register the original final decree in OS number so and so.
Physically. It's only e-registration now.
E-registration, it is not taking it.
What's the
Because
problem?
Problem is, apparently what they say is, the property which are allotted to my brother under the document, even those records I have to give. They're insisting, what I am allotted is only one property, which is in Sagar. That document I have given on municipal records and all that. Still it is not being registered.
But if at all a document has to be registered, my lord,
Get instruction as to what it is.
in the final decree proceedings, my lord, the decree that has to be registered, all that property, irrespective what he has been allotted, it's a decree that gets registered. Whatever properties that are there, all have to be uploaded. That may not be his share because all the parties who are the parties in the original suit are the beneficiaries under the final decree proceedings.
If there are,
He
in
can't say that I will
FDP, if there are
execute the
five
final
or-
decree partly.
If there are 5 or 6 parties,
Yes,
one of them comes forward for registration, the others are waiting, then one of them cannot be deprived of it.
It cannot be
He will
deprived.
he will
my
take
lord.
a
They are not
separate
telling
final
that-
decree. He will go there.
They have insisted that the e-khatas for uploading of all those documents. is
No.
required. Because he has not produced any documents. He says, I will not produce the documents of other people, only.
You tell him which
I will
documents.
secure the
he-
instruction, ma'am.
Insofar as the property allotted to him, you can ask for.
Yes, yes. ma'am.
Not as regards the allotment made to the other.
Then he has to upload only those documents that he is registering.
That's what we have done.
So
I
find,
will secure the instructions, madam,
to find out if, what are the documents.
to be uploaded.
From what Mr. Vijay Kumar is saying, what we understand is, since there are 5 properties here, all 5 properties have to be uploaded.
Yes, ma'am.
He doesn't have all those documents. He has only one
One which he is allotted.
which is allotted. So in your software, you'll have to check whether it will,
It will be possible. If it is there, my lord, I will see what best can be done.
and AGA accepts notice for response,
All the responses, 1 to 3.
for respondent. He seeks for the submission of Shri Vijay Kumar, learned counsel for the petitioner. Either the petitioner, when sought for registration of a final decree passed in OS number 319 of 2021 by the 24th Additional City Civil and Session Judge Bengaluru, in respect of the property allotted
Not
falling
to
to the
her,
share
only one property.
of the petitioner, the software software requires uploading of documents as regards all the properties covered under the final decree. And as such, the petitioner not having those documents is unable to register the final decree in respect of the property allotted to the petitioner. Then AGA is direct secure instructions and make a submission as to whether the petitioner could register the final decree drawn up in respect of the property falling to the share of the petitioner,
Falling to her share.
falling to the share of the petitioner. If so, what are the documents which are required to be produced, uploaded by the petitioner? Released on 19th August.
Serial number 9, P.N. Nandya Reddy.
Mr. Nanjareddy?
That appear for the petitioner. The petitioner blood is an institution. Running institutions blood of the
FIR. What are the allegations made?
Allegations blood is threatening with the rowdy elements and also Millard demanding Millard because the hostel is being constructed at the instance of
Complaint only.
complaint next year D and D Millard, page 20.
Page
20 Millard.
20.
In respect of other institutions, they have registered Millard. Next year, F Millard, in respect of other institution also filed complaint. The FIR has been registered and the case is pending. Millard. Next year, F Millard, page F.
Assault.
Global education.
Since the dispute is with regard to the accused whom they have filed a complaint against, they are constructing the commercial complex without the permission. That's why he has filed the RTA and he also has filed a complaint against them, telling they are threatening him since he has filed the RTA application. We are inquired and we have given the endorsement. After the RTA dispute, we cannot.
Not artists.
Because he has filed-
Annexure
he has
C
filed
photographs
RTA
also.
application against them to give their project details, which is under the government contract.
That is, here he is alleging in his complaint that he has been threatened and assaulted.
We have inquired about it.
Huh.
We have called and we have inquired about it and then we have given the endorsement.
Because this is all less than 7 years.
Yes.
So Lalita Kumari requires you to do a preliminary inquiry.
We have done the place.
So where is the preliminary inquiry and where is the endorsement?
No endorsement has been given.
Madam,
Third.
Copy.
Yes, there is an endorsement issued on 12/7/26.
But I have not been this.
Your client has
Ah,
not
of
given
course.
it to you, Ashte. There is an endorsement issue.
Tomorrow I'll find out. I've
You
got
have to
know yet.
challenge this.
I have not this.
Let AG access notice for response. And AG submits that since the offence alleged is punishable with imprisonment for less than 7 years, a preliminary inquiry was done when it was found that the dispute was civil in nature, and as such, the endorsement dated 12/7/26 has been issued by the respondent to the petitioner. He is directed to furnish a copy thereof to the counsel for the petitioner who seeks for and is granted a week's time to go through the same, obtain instruction and make a submission. Released on 19th August. Published.
Serial number 10, Shayan.
Because I appear for the petitioner in this matter, because this is connected with WPC 20105. Because has asked me in that matter that ozone should be represented by the IRP, and your lordship has issued notice for 5th of August. That's WPC 20105.
WP number?
20105 of 2026.
20105, same order, same date.
Your Lordship, I'll accept notice for R1 and R2 in this matter.
Mr. Aditya Singh for 1 and 2.
11, Gaurav GK.
For the petitioner. This is a matter which was listed yesterday, my lord. Order taking cognizance, my lord, against an elected office bearer of the society, my lord, under the Consumer
You'll have to go
Protection
to the
Act.
State Commission.
Lord, this is an order, my lord, only taking cognizance, my lord, in an execution, not the final award, my lord, which is under challenge.
The hierarchy is district commission to the district forum to the state commission to the national commission. Then you can come back here.
Please, certainly.
Go there and agitate
That
all
apart,
your-
my lord, there is a challenge to section 41 as well, my lord. As regards that, my lord,
If you are serious about it, we'll issue notice. We won't stay.
please, my lord.
You won't get any relief.
Certainly, I understand.
So what do you want to do?
But since there are other matters pending, my lord, with regard to the challenge to section 41, I will urge, my lord.
You want to urge.
Please.
So the challenge has been, have you made Union of India a party?
No, my lord. Permitted, I will pass.
I-1 of 26 has been filed to impede the Union of India, Department, represented by Department of Food, Civil Supplies and Consumer Affairs. Since the virus of Section 41 of the Consumer Protection Act 2019 has been challenged, IA-1 of 26 is allowed. The Union of India is brought on record as respond number 5. Anybody for central government? Vinay? Attorney General notice you will accept on his behalf.
I'll accept.
Since the virus of Section 41 of the Consumer Protection Act 2019 has been challenged, issue notice to the learned Attorney General.
Wires has been challenged, Your Lordship, say direct notice to the ASG.
Learned ASG accepts notice on his behalf. Learned AG accepts notice for respond number 1. Notice to respond number
2 and 4.
2 and
3,
4 is
4.
dispensed with.
Please. 3, my lord.
Issue notice to respond number 3, returnable by 15th September.
Serial number 12, Vishwanatha NS.
For the petitioner, my lord. My lord, this case regarding to the puja rights of according to hereditary family, my lord. To one Sri Lakshmi Venkataramana Swami temple situated in Konankuntlu village. According to since ages, my lord, the puja rights for performing was given to the petitioner's ancestrals, my lord, on rotation basis, yearly rotation basis.
Page number?
Annexure
G, my lord. Page 37.
Annexure G is impugned order, my lord. Annexure A is that order in which the rotational basis has been given.
Annexure A.
Annexure A, in page number 16, my lord.
Yes.
The operative portion of the order is in page number 19, my lord. Can I read that, my lord?
Yes, please.
ಚಿಂತಾಮಣಿ ತಾಲೂಕು ಕೋಣನಕುಂಟ್ಲು ಗ್ರಾಮದ ಶ್ರೀ ವೆಂಕಟರಾಮಲು ದೇವಾಲಯ ಅರ್ಚಕತ್ವ ವೃತ್ತಿಯನ್ನು ರಂಗಪ್ಪನವರ ವಂಶಸ್ಥರು 1 ವರ್ಷ ಹಾಗೂ ನರಸಪ್ಪನವರ ವಂಶದವರು 1 ವರ್ಷದಂತೆ ಮೇಲೆ ದೇವಾಲಯದ ಪೂಜಾ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ನಡೆಸಿಕೊಂಡು ಬರಲು ಆದೇಶಿಸಿದೆ. ಈ ಬಗ್ಗೆ ಪ್ರಭಾರ ವಹಿಸಿಕೊಂಡುವಿಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಹಸೀಲ್ದಾರ್ ಚಿಂತಾಮಣಿ ತಾಲೂಕು ರವರಿಗೆ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ನಿರ್ದೇಶಿಸಲಾಗಿದೆ, my lord.
Where is the
annexure A, my lord, was the order that was passed in 2011 and 12.
Tahsildar was directed to pass orders.
Yes, sir. Here, my lord, if your lordship could kindly see the impugned order, my lord, in end there. I may read the entire order.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಚಿಂತಾಮಣಿ ತಾಲೂಕು ಮಂಗಾನಹಳ್ಳಿ ಹೋಬಳಿ ಕೋನಕುಂಟ್ಲು ಗ್ರಾಮದ ಮುಜರಾಯಿ ಇಲಾಖೆ ಸೇರಿದ ಸಿ ಗ್ರೇಡ್ ದೇವಾಲಯದ ಶ್ರೀ ವೆಂಕಟರಮಣ ಸ್ವಾಮಿ ದೇವಾಲಯದಲ್ಲಿ ಗೋಪಾಲಾರ್ಚರು ಅವರ ವಂಶಸ್ಥರು ಲೇಟ್ ರಂಗಾಚಾರ್ಲು ಕುಟುಂಬಸ್ಥರು ಮತ್ತು ಲೇಟ್ ವರಸಿಂಹಾಚಾರ್ಲು ಕುಟುಂಬದವರು ಸರದಿ ಪ್ರಕಾರ ಅರ್ಚಕತ್ವವನ್ನು ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಸದರಿ ದೇವಾಲಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಸರದಿಯಂತೆ ಯಾವ ಸಾಲಿನಲ್ಲಿ ಯಾವ ಪೂಜಾ ಕಾರ್ಯಗಳನ್ನು ನಿರ್ವಹಿಸಬೇಕು ಎಂಬುದು ಬಗ್ಗೆ ಅಧಿಕೃತವಾಗಿ ಅನುಮೋದಿತ ಪಟ್ಟಿಯಲ್ಲಿ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಮತ್ತು ಸದರಿ ದೇವಾಲಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹಿಂದಿನಿಂದಲೂ ವಂಶಸ್ಥರೇ ಸರದಿಯಂತೆ ಪೂಜಾ ಕಾರ್ಯಗಳನ್ನು ನಿರ್ವಹಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದು ಸದರಿ ವಂಶಸ್ಥರ ನಡುವಿನ ವ್ಯವಸ್ಥಾವನ್ನು ತಪ್ಪು ತಿಳುವಳಿಕೆಯನ್ನು ಸದರಿ ಪೂಜೆ ಏರುಪೇರಾಗಿದ್ದು ವರ್ಷದ ಪೂಜಾ ಕಾರ್ಯಗಳು ನಿರ್ವಹಿಸಲು 3-4 ಅರ್ಜಿಗಳು ಸಲ್ಲಿಸಿಕೊಂಡು ಪೂಜಾ ಕಾರ್ಯಗಳು ಸಿಗದೇ ಇದ್ದ ಪಕ್ಷದಲ್ಲಿ ನ್ಯಾಯಾಲಯಗಳ ಮೊರೆ ಹೋಗಿ ಮೇಲ್ಮನವಿಗಳನ್ನು ಸಲ್ಲಿಸಿಕೊಳ್ಳುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. There are proceedings pending between the rival family members, my lord. So the Tehsildar, the executive officer also, my lord. Now ಅದರಂತೆ 25-26ನೇ ಸಾಲಿನಲ್ಲಿ ದೇವಾಲಯದ ಪೂಜಾ ಕಾರ್ಯಗಳಲ್ಲಿ ಯಾವುದೇ ಲೋಪದೋಷವಾಗದಂತೆ 14/4/2020ರಿಂದ ಈವರೆಗೂ ಪೂಜಾ ಕಾರ್ಯಗಳನ್ನು ನಿರ್ವಹಿಸಲು ಶ್ರೀ ಅನಂತ ನಾಡಾರ್ ಅವರಿಗೆ ಆದೇಶಿಸಲಾಗಿದ್ದು ಮುಂದುವರೆದು 26-27ನೇ ಸಾಲಿನ ವೃತ್ತಿಯನ್ನು ವಹಿಸಲು ಬಗ್ಗೆ ಹಿಂದಿನ 15 ವರ್ಷಗಳ ಪಹಣಿಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಶ್ರೀ ರಂಗಾಚಾರ್ಲು ಅವರ ಸರದಿಯನ್ನು ಪುನರ್ವರ್ತನೆಯಾಗಿರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಸಾರ್ವಜನಿಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ಜಾತ್ರಾ ಮಹೋತ್ಸವದಲ್ಲಿ ಅವಧಿಯಲ್ಲಿ ಹಾಗೂ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಪ್ರಸ್ತುತ ವರ್ಷದ ಸರದಿಯನ್ನು ಶ್ರೀ ರಂಗಾಚಾರ್ಲು ಅವರ ಮಗ ಪುರುಷೋತ್ತಮ ಆಚಾರ್ಯ ಇವರು ದೇವಸ್ಥಾನ ದೈನಂದಿನ ಪೂಜಾ ಕಾರ್ಯಗಳನ್ನು ಹಾಗೂ ಧಾರ್ಮಿಕ ವಿಧಿಗಳನ್ನು ನೆರವೇರಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. There is a dispute between the family members also.
And you have not made them parties to this petition.
Not made. Person who is the beneficiary.
If I may submit, this dispute arises from 1992, my lord.
You have not made them parties to
Yes,
this
my lord. In the Assistant Commissioner has clearly written that if there is any dispute between the family with respect to the rights of Archakatva, they need to go before the civil court. Despite that order, my lord, Tehsildar has given an endorsement which is at Annexure E.
Council,
Please.
you have not made the affected parties a party to this petition.
Please.
On that ground, only the petition will have to go unless you make them parties.
I'll array them as a party.
So file the application.
Yes.
Counsel for the petition, when AG accepts notice for respond number 1 to 4. Counsel for the petitioner seeks fund is granted 10 days time to implead all the persons who could be affected by any orders passed in the present proceedings. Relist on 19th August.
Grateful.
13, yes, Vivekananda.
Lords, a complaint under 138 came to be allowed, my lords. From the judgment, my lords, the accused went on criminal appeal. Lords, there was a settlement that was arrived at. Lords, but in the award, my lords, there is an observation, my lords, if I may directly draw your lordship's attention to page number 29, my lords. Page number 30 is the award. Lords, observation that it's a deemed decree, my lords, of a civil court. Lords, is now preventing me from pursuing it. The accused has failed to comply with the.
Is there a agreement arrived at before Lok Adalat that a fine levy warrant could be issued?
My lords, no specific this one, my lords, but if I may submit your lordship's order that it's an alter ego of the court from which the matter is referred. If I may rely on.
But only if that clause is there. Otherwise, under 21, it becomes a civil decree.
My lords,
Legal Services Act, Section 21.
my lords. Sorry, my lords.
Section 21 of the Legal Service Authority.
Yes, my lords, section 21.
So any order passed in the Lok Adalat will be a decree.
My lords, if I may submit, every award of Lok Adalat shall be deemed to be a decree of a civil court, or as the case may be, an order of any other court.
If it is mentioned there.
My lords, if I may submit, if I may, since the matter is gone from this criminal court, from the magistrate court, if I may quote, my lords, every award of Lok Adalat.
Vivekananda, that argument had been advanced, has been dealt with by the Supreme Court, dealt with by the Kerala High Court, has been negated.
Lords, if I may, give me the case clause. If I may persuade your lordships.
Third.
Super, sorry. Mogribiga.
That's why to tackle that this. Yes.
Lords, Shri Somshekar Reddy versus Srimati G.S. Geeta, my lords, if I may draw your lordship's attention to para 11.1, my lords, where
11 page?
Page, my lords, internal page 4708, my lords.
4708. Yes.
Page, running page 10, my lords. Lords, 11.1, whether a compromise arrived at before the Lok Adalat in a criminal proceeding can only be enforced as a civil decree, or can it also be enforced in terms of the applicable provisions of the CRPC, more particularly section 431 of CRPC thereof. Can this court or the trial court set aside the compromise arrived at before the Lok Adalat on account of default of the accused and restore the complaint? If I may draw your lordship's attention to para number 16, my lords.
Yes.
My lords, in fact,
Govindan
Kutty, my lords. The said decision in Govindan Kutty case does not in any manner relate or restrict the invocation of section 431 of the CRPC. There was no issue raised before the Honorable Apex Court as regards if the complainant who had settled the matter before the Lok Adalat could on default invoke section 431 of CRPC or not in respect of compromise arrived at in the Lok Adalat. Lords, if I may submit, in the case that is CD Govindan Kutty, lords, judgment is passed, lords, for purpose, and there is a settlement arrived at. For the purpose of enforcement of that award, lords, the complainant files an execution petition, lords, which is disallowed by the court, and then even the High Court of Kerala disallows it, telling it cannot be entertained. Lords, then it is held by the Supreme Court that if the accused or the complainant wants to enforce it as a civil decree, it is permitted under section 21. Lords, the aspect relating to the criminal court order being enforced under section 431 for recovery, lords, as a fine is not considered. If I may draw your lordship's attention further to paragraph 28, lords.
We have dealt with it extensively argued. Does your compromise have a clause which says that if there is a default, you will be entitled to enforce a fine levy warrant under section 431.
It does not say so, but in accordance with law, if I may just pursue it, para 28, my lords.
Yes.
My lords, merely because the settlement was arrived at before the Lok Adalat, it cannot be contended that the criminal proceedings have been converted into civil proceedings, revoking the right of the complainant to enforce his or her rights in terms of the applicable criminal law. The dispute which was referred to the Lok Adalat was one which was being adjudicated in a criminal proceeding. If not for the existence of that pending criminal proceeding, there would have been nothing to refer to the Lok Adalat. The Lok Adalat system is sui generis, my lords. If I may draw your lordship's attention to the next page, my lords, fifth line on.
We have come to page para 31, depending on the terms of the compromise.
My lords, 31.2, if I may draw, I fully get, my lords. In the event of a default of a compromise arrived at before the Lok Adalat, this court or the trial court can, on an application made by the complainant, set aside the compromise arrived at before the Lok Adalat, restore the complaint on its file and proceed with the complaint, or enforce the compromise as per the terms of the compromise, including by issuance of FLW under section 31 of the CRPC. So my humble submission is, in which case I will ask for setting aside of the.
What is the relief that you sought for here?
My lords, prayer at page number 25, my lords.
You are not asked for that.
May I seek for an adjournment? I'll file an amendment, my lords.
Counsel for the petitioner seeks for and is granted 10 days time to file amendment application, released on 19th.
Much obliged.
Serial number 14. Prakash Kihekar.
Appearing for the petitioners, my lords.
Yes.
Kindly pass over the matter, my lords.
Pass over.
Serial number 15. Harsha Swarup.
Yes, Harsha.
Appearing for the petitioner on this matter, my lordships. I am before this honorable court praying for a police protection on a family court order which has not been complied at all. The petitioner.
Page number?
Page number 15, my lordships.
15.
Yes.
15 is not the order.
The impugned order is in annexure B, my lordships, 21.
What is the order directing providing of police protection?
There's no order. I'm before this requesting for the.
You have to go there.
My lordship?
You have to ask for protection there.
My lordships, but see, we have been asking, my lord, time and again, but there has not been any relief. My lordships can look at annexure C, which is the order sheet, my lord.
Page number?
Page number 91, my lordships may look at. And before 91, where we brought to the notice of the court, page number 88.
You filed an application for police protection, Mr. Harsha.
My lordships, we also have filed execution. We have also filed contempt, but nothing.
Have you filed an application? Please understand.
Yes, my lord.
Where is that
In
application?
execution petition, my lord, my lordships can see page number 111, where we have filed the execution as well as in the prayer 114, my lordships.
Harsha, please understand the question. Have you filed an application for police protection? So where is that IA?
Not IA, my lord. We have filed execution. In the execution, we have asked for it. 114.
114.
Yes, my lord.
Where is the police protection that you sought?
Point 3, my to direct the
to execute the order that the execution court will consider. There's no application for police protection.
My lordships may in the execution we requested for.
You file an application there. If that court grant, because
My
the court
lordships,
sees only can decide that.
But the family court has repeatedly told, and in fact, I would take my lordships to the order sheet.
Yes,
where,
but you have not filed an application. Without an application, no court can consider anything.
File
an application, the court will consider and pass necessary orders.
My lordships, but if possible, this honorable court had considered a similar issue in question. I would just like to confirm this. where an intended to appoint amicus curiae as well. And then we came ahead and filed a joint memo.
Yes.
It's a similar case where I was part of the opposite party at that point in time. And my lordships was kind enough in that to even go ahead and appoint an amicus curiae in this matter.
That was a different issue.
Same issue, my lord. The issue was exactly same. The order was from the family court and no compliance was happening at all. And on the other side, when no compliance was happening, we approached the court. They approached the court, and my lordships was kind enough to consider.
So you already filed the execution proceedings. The execution court is seized of it. You can't maintain a parallel proceedings.
I'm not execution. I'm asking to execution proceeding goes on a particular date of execution, my lord. For every instant of execution, there has to be an execution petition filed into the court, where that was for only that. We are here asking for the future visitation, my lord. That whenever the visitation, it happens only, I get twice a month to pick up the child. And repeatedly, my lordships may see page 91, my lord, 91, where after that we filed an IA4 was filed in 90 behind. IA4 dated 24/10/2025, they have filed objection also. And then it was ordered for the child to be made present. And the court interacted in page 91, petitioner and respondent present, kept by petitioner and respondent present. The child is also present before the court, interaction held. The respondent has no objection to comply the visitation rights. There is no stay order. They had approached the High Court for stay on that order. Even the High Court denied in WP 31712 of 25. But still, they are hell-bent of non-compliance of the order at all.
Which is the order?
Order is in Annexure B, my lord.
Page?
Annexure B, page 21, my lord. If I may be 21, be permitted to read the operative portion of the order, my lord, which is in page 23, whether the petitioner is entitled for interim custody and visitation rights, or what's the order. It is admitted that the petitioner and respondent are staying separately. They both are very close to each other, my lord. They stay less than 3 kilometers distance. The petitioner has stated that he's ready to pay education. He's paying almost 7 lakhs a year as just the school fee, because this child is in TISB, international school. The respondent has taken contention that the petitioner is a doctor and residing separately. The child needs parental care. And para 11, my lord, the advocate for respondent submitted that the petitioner cannot claim more than one relief in the interim application. They come in the para 12.
Every second Saturday.
Yes, my lord.
And drop the child at 6 p.m. on
Monthly
Sunday.
once I get. And even that's not complied at all. Only once 8 p.m. every this one. And almost 27 days are lost.
You've been filing execution petition for every month.
I have filed one before this case came to me. There was one file. Even the contempt we filed actually, but none of them are moving at all. And this is for the future. Only once a week it is, and even 3 days holiday custody is there, my lord.
There's notice for respondent number 1 and 2. Who appeared for respondent number 3 in the trial court?
Respondent number 3 is Vani, my lordship.
Counsel for the petitioner is permitted to serve the counsel who appeared for respondent.
Vani is our counsel. I am not aware of
for
the
respondent
opposite.
number 3.
I'm not sure. 1 minute.
Serve the counsel who appeared for respondent
opposite
number 3
party.
before the trial court. Petitioner is also permitted to take out hand summons on respondent number 3, released on 11th August.
8th, actually, there is a
So
visitation.
your second
my lord.
Saturday is 8th. Released on 5th August.
Obligement.
Serial number 16, Manoj K.
IA2 of 26 is allowed. IA3 of 26 is allowed. Yes.
So the petitioners in this case, my lords, I'm here challenging the lien mark which has been filed on the petitioner's account.
Lien.
Yes, my lords. In a similar matter listed, I think this
Outside state or within the state? Within the state.
My lords, outside the state, my lords. In a similar matter, my lordships had directed the petitioner to approach the trial court.
Correct.
The same may be granted for this case also.
You not made the bank a party.
Yes, my lords. The similar matter was filed with the same crime number in the previous matter. The lordships I told us to approach the magistrate
Right,
court.
you should make the bank a party so that they can get the details there.
Yes, my lords.
Who will get the details? The police can't get the details by themselves. The bank will have to furnish what they've received.
Please, my lords.
So make the 3 bank accounts.
Yes, my lords.
Make all the 3 banks a party. File an application by afternoon. So you can go tomorrow. Yes.
17.
Yes, Mr. Nane.
No, the petition is a tenant, my lord. And on a monthly rent of rupees 70,000 rupees originally from 2008. Subsequently, 1 lakh and odd rupees rent is being paid. Abruptly, my lord, the owner.
There is no interim relief. And AG accepts notice.
CCTV footage. The CCTV footage. Swami?
Stitching page 1, 2, 5.
Permit, will make.
the 10. 9 there is no interim relief. 10 is here, interim relief. To preserve the CCTV footage.
Sorry.
And AG accepts notice for respondent number 1 to 4. Why do you want the CCTV footage?
Yes, sorry.
CCTV footage, why do you want?
There was a CCTV where it clearly indicates saying that they have criminally trespassed into the premises and removed the materials worth 1 crore 40 lakhs, which belongs to me.
FIR has been registered.
Not registered. There's a reason why they say you go for a civil litigation to get it evicted or whatever you want to position, you take it. Criminal trespass into the premises and removed all the valuable articles. Still they call, including Commissioner of Police also, like complaint is lodged. And endorsement is a civil litigation.
The trespass.
CCTV footage is not of the nation, that's for the scheduled property. The landowner is not a party.
Your page numbers are so this one that we can't even.
Direct evidence is available.
First you have to register, then you can secure it. House trespass. AG accepts notice for respondent. The allegation which have been made by the petitioner as regards house trespass and removal of the items in the house of the petitioner by certain persons against whom a complaint had been filed, as regards which an endorsement has been issued stating that the matter is civil in nature. When a trespass has been alleged, which is a cognizable offense, cognizable and non-bailable offense, it was required for the respondent to take necessary action by registering the FIR and investigating into the matter. In that view of the matter, the further submission of Shri M.T. Nanayal and Senior Counsel is that the CCTV footage of the petitioner of the premises would have to be secured by the investigating officer for the purpose of proper investigation. In that view of the matter, this court passes the following order. Writ petition is allowed. Certiorari is issued. The endorsement dated 15/8/25, 21/3/26 and 10 so on to Annexure B series is set aside. Respondents are directed to, respondent number 4 is directed to register an FIR in terms of the complaint filed and cause investigation into the matter. While so investigating, respondent number 4 is directed to secure the CCTV footage in respect of the subject property by issuing necessary direction as per the applicable law.
I was thinking whether should I remove same investigation officer should continue or different police officers, CCB or somebody can take. I will take chances. Please.
Serial number 18, Bharat here.
Petitioner, due to matrimonial dispute between the petitioner and his wife, a FIR came to be registered. That's it.
Lordship, may record my statement that there is no NOC pending as on date.
Petition may be dismissed.
Yes, my lord.
There's no LOC.
I've taken instruction.
Allah, my lords, because when I went to.
Why did you come
No,
out saying?
I was traveling to Poland, my lord. I was stopped in the month of February in Mumbai immigration.
Back then, there may have been an LOC, Lordship. Currently, my instructions are that there's no LOC. Lordship may record that.
In matrimonial matters, LOC.
Originator ಅದು ಕೊಡ್ತಾರೆ police ನವರು.
I think we are dealing with it another matter. Wait.
ಅಲ್ಲ ನನಗೆ LOC ರಿಮೂವ್ ಮಾಡಿ ಅಂತ ಅಂದ್ರೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್
Notice for respondent number 1 and 2, learned AGA for respondent 3 and 4. Petitioner is before this court seeking for the following reliefs. Counsel for respondent number 1 and 2 on instructions submit that the lookout circular is no longer in force insofar as the petitioner is concerned, and the petitioner is free to travel subject to any permission, travel abroad subject to any permission being received by the petitioner from the court seized of the criminal proceedings.
One submission. His proceedings against him is stayed, my lord. That is at page number 130.
But if you don't get the permission, you can't travel.
Judgment on that.
Subject to petitioner obtaining permission from the court seized of the criminal proceedings which are pending. Placing his submission on record, petition stands disposed.
19, Lata Shayan Murthy.
Appeal for petition for premature release, my lord.
And AGA for respondent 5th August.
Much obliged.
Varun J. Patil.
Yes.
This is pertaining to section 10A. Same, my lord.
Same order, relist on, will file 6th of August. Same we have recorded last time, same. I-1 of 26 is allowed. All the objections are ready. The more you delay, they'll continue in office.
Back in Garber also, there are stated matters now where your lordship said the model is being followed. Although there they've asked for stay of the legislation itself.
Of course, in all the cases, we have sought for that interim order, but
No coercive steps, but there we have actually sought for the stay of the act. The extent that we've challenged it.
File your objection, then we can consider. Yes.
interim order not to.
Same order.
Please.
21,
I appeal for the petitioner, my lord.
Yes, Mr. Adiga.
Yesterday, your lordship had disposed of 2 petitions, similar facts, my lord. Same, 4 petitions, that in 2023, they issued.
How did you manage to get 4 matters of the same facts?
No, 4 different petitioners.
4 accused.
4 different petitioners, only difference is 4 different petitioners, 4.
Same crime number.
Same crime number,
And AGA
4
for
different
respondent number
WP.
123. What was the number yesterday?
Yesterday's.
Same order. Same order.
20
Everything is same.
24. Yesterday's 29.
22, Shilpa Rani.
Yes,
The
madam.
petitioner in this case, my lord. Petitioner is a practicing advocate, my lord. He taken a case of double murder case, my lord. Petitioner is a practicing advocate, my lord. He taken one murder case, my lord. From after that, my lord, he received the fees as a property, my lord. He received the actually the fees which there does have money, my lord, since the accused, my lord, sold the property to the advocate. So after that, my lord, and he received the money, and the money has been given to the through DD to the accused, my lord. Later, when they got a bail, my lord, all accused got a bail. Then the case has been dismissed. The conviction order has been passed by the trial court, my lord. Now it has been appeal has been filed. Now now she came and asked for the NOC. Then we given a NOC, my lord. Now they are saying which is property sold to you to give it back. Hence they usually comes to house, office, everywhere, my lord. They are giving galata. Hence we given a police complaint, my lord. That is not registered, my lord. Not even NCR, not even FIR, my lord. Not even registering. They are influenced fellow. They are not even registering my complaint, my lord. I have given complaint, hence, my lord, for the direction.
What is the complaint that you give?
Complaint, my lord, they're coming. Even my wife is 2 months pregnant and my mother got operation, my lord. They comes to our house
What is the
trespassing.
complaint that you are given, madam?
they're trespassing my house and making galata, my lord. When we have given a NOC, my lord, then there is no, which is the sale deed is happened in the year of 2024. Now they says you give it back my property. Once I lost the case, then they seek for a return of my property back.
Why do you involve in these kind of things? A lawyer is supposed to be a noble profession.
Please, my lord,
Not
they
buying the
doesn't have a
property of
money.
your client to represent the client.
Please, my lord, they doesn't have a money, my lord. Hence, I have arranged the money. Then I taken that property.
Madam, do you
Then
even
that is for the
understand what you are
someone, my lord.
saying?
I sold it.
Do you understand what you are saying?
Please, my lord.
You make arrangement for funds of the client
Please, ma'am.
on loan.
Not my own, my lords. I have borrowed from
somebody else.
someone else. Then it was
Make
registered.
your payment of your fees.
Not my fees, my lord. They have given DD to them or their account only. I have received some fees, my lord. I accept, my lord. I receive some fees.
Why do you do these kind of things?
They doesn't
Bring
have a
the
money to
profession
run
to
the case, my
disrepute.
lord.
You are bringing the profession to disrepute by doing like this.
They given a complaint before the bar council also, my lord.
Yes.
For that, I have given a NOC. Now they taken
Return the
since I,
property, then everything sorts out.
my lord, I have run my.
The problem is you are retaining the property which doesn't
I am
belong
not
to you.
retaining the property, my lord. They who have financially supported, I have already given that property to them, my lord.
What kind of things?
No, they comes for the return the property, then it's already sold it to someone else, then I can't return it, my lord.
File
Only
a civil suit.
my lord, here, not civil suit, my lord. Here, my lord, I have given a complaint. Since they comes every day and making galata in my house, my lord, they're trespassing my house. My wife is a pregnant, my lord. And my mother is recently operated, my lord. The old aged parents are there for me. They comes to my office and they comes to my home, my residency. And then I given a police complaint for the protection, my lord. They're
Now
not
again,
giving.
you will take, borrow money and defend them in the criminal proceedings filed against them.
My lord, I have
What
not
kind of
borrowed.
this one is this?
I have not borrowed it, my lord. I have given. I taken my fees and run, my lord. Once the conviction order is passed, that is not my problem, my lord. Once even I have filed a appeal also, my lord. Appeal also pending before this honorable court, my lord. Then they come up for I taken NOC, my lord. I have given NOC also.
Get instruction as to what this is.
Even my
What-
lord, video is there, my lord, but the
What you are
trespassing
saying doesn't
CCTV.
inspire any confidence. And AG accepts notice for respond number. You made them personally. Respond number 1 to 5. Issue notice to respond number, emergent notice to respond number 6 and 7. Returnable by 19th August.
Machu.
Get the details as to what this is about.
Machu.
23, Harish MG.
Appearing on behalf of the petitioner, my lords. The petitioners had availed a loan from the first respondent society, my lords, which they have defaulted and now they have obtained an ex parte order.
The cooperative society, section 70.
Please, appeal is there, my lords, but
Well, section 70 will have to go before the cooperative jurisdiction.
the
The
case
peril of the case are ring baratapa cooperative society though.
please, in the branch.
A perusal of the papers indicates that what has been challenged is the order passed by a second respondent under section 70 bracket 2 of the Karnataka Cooperative Societies Act. Registry is directed to verify the classification, place it before the appropriate bench.
Date may be fixed before.
We can't fix a date for the other thing.
Before the other bench.
You move that court.
Please.
24,
Same as in serial number 21. Say 4 cases, 4 accused,
Yesterday 2, today 2. Over. 24, same as 21.
21 mile. Much of
25,
For the petitioner, challenges to an order under section 23 of the Senior Citizens Act, my lord, cancelling a gift deed. The case set up is one of fraud, my lord, not under 23 at all. Would your lordships be kind enough to please take the complaint filed, my lord, before the tribunal?
Page?
That my lords will find at page 276. Could I read the relevant portion at 278, my lord?
Yes.
Para 7.
Yes.
Petitioner further submits that petitioner, being the absolute owner, used to collect rent of the suit schedule property regularly from the tenant from the portion of the suit schedule property, and in the other portion, respondent was residing and was moderately taking care of the petitioner. Later on, recently, respondent started collecting rent of the house, neglecting and ill-treating the petitioner. When the petitioner questioned the reason for negligence and ill-treatment, he revealed that he is the absolute owner of the suit schedule property. The petitioner became shocked and surprised when he showed the gift deed. Immediately, the petitioner collected the gift deed and verified the gift deed, only to find that it was got executed illegally. The petitioner submits that when matters stood thus, the petitioner remembered in one of the occasions the respondent, taking advantage of the illiteracy and old age of the father, respondent manipulated and had taken the petitioner to sign as a surety for availing of the loan, and the respondent got the petitioner to sign on the alleged gift deed in the guise of surety with an intention to cheat the petitioner and grab the valuable property of the petitioner, and got registered as number so and so before the sub-registrar Gandhinagar in his favor illegally in collusion with the brother-in-law of the respondent, who has drafted the above alleged
What
gift
is the
deed.
relationship? Your father and son.
Father and son, my lord.
Very nice.
So this is the case that is set up of fraud. On the one, I'll read the next paragraph as well, my lord. The petitioner submits that petitioner was neglected and abused physically and financially on that account, the petitioner came to know about the alleged gift deed executed in the guise of surety for the loan and subjecting the petitioner to mental torture and scolding in filthy language without any respect, care or concern towards the petitioner. And further, this alleged gift deed has created a crater in the relationship.
Where is the gift deed?
My lord, the gift deed, your lordships will find at page 52, my lord. Of course, there's no condition that it is, and I know that an express condition may not be necessary, but I'm simply stating that there is no condition. Page 52 is the deed, my lord.
You presented the document, you made payment of all the fees.
Please,
The
my lord.
witness-
That is so.
witness is
My
his
lord,
wife.
But my respectful submission is that both
They
of these allegations are mutually destructive. On the one hand, if the case is that I fraudulently executed it, it cannot also be that I executed it on the condition that I would take care of you.
Not necessarily, that's the implied condition.
No, my lord. May I just
Take care of your parent. You want his property,
No,
but
my
you
lord,
don't want to
I-
take care of
No, my lord. In fact, in the objections also, it was stated that I would take care of him. I in fact said so, my lord. And I've produced, my lord, bank statements
How much
to
are
show.
how much are you willing to pay?
My lord, in the objections, I had said 5,000 a month, my lord. Anything
How much
above
is
that,
the-
your lordships may
How
put
much
me
is
to
the
terms.
value of the property?
Lord, I'll ascertain that, my lord.
How much is the value of the
What's
property?
in Yelahanka,
Yelahanka.
30, 40 my lord, and there is a
I'll-
residential.
I'll identify.
Yes,
My lord, I'll take
Lord,
instructions. I have.
The draft,
See, Maruti Nagara.
In fact,
Lord, gift deed is drafted by his brother-in-law. It is signed as a witness by his wife and his friend. Lord,
M. Nagesh is his brother-in-law.
brother-in-law, wife's brother. Lord, first witness is his wife. Second witness, we do not know, his friend or somebody. And Lord, entire rent, there is a 2 tenements deriving the rents in this property that is being appropriated by him. Lord, he is a grade 1 officer in the central government office and receiving more than 1,20,000 salary per month. And Lord, the wife died of the respondent in 22. But he was totally neglected. Now he is residing alone near Hoskote. And Lord, he has got one daughter, is married, and she is supplying food through porter on few days.
Lord, in fact, apparently, from what I understand, my lord, even there, my lord, they have own land in the village, my lord, which is joint family.
This is not your property, this is your father's
Your
property.
Lordship's,
What is, my lord?
Judgment in Venkategowda case.
Shri Vijay Krishna Bhatt was filed caveat accept notice for respond number 1 and AGA accepts notice for respond number 2. Shri Vijay Krishna Bhatt seeks for and is granted 4 weeks time to file a
Lord,
statement.
would your lordships, my lord, on the legal ground, may I just make a submission?
We are not staying anything.
My lord, would your lordships hear me on just, my lord,
squarely
on
applies to
on whether a case of fraud can be set up at all? May I just pass on one judgment?
We'll consider it after all objections are filed.
Would your
The
lordships
fact
put me
that
to
you are-
terms, my lord?
You are ready to make payment of a princely sum of 5,000 rupees per
No,
month.
no, I said that is what had been stated, my lord, before the court. Would your lordships then,
I will file my
would your
objections.
lordships pass it over, my lord? I'll seek instructions. I don't want to
Get
make
instructions.
make a statement off the cuff. Would your lordships pass it over, my lord? I'll,
Get us, what is the value of the property?
Yes, ma'am.
Both of you,
yes, my lord.
and how much you are willing to pay.
Please, my lord. I'll do that. Would your lordships pass it over?
But he will continue to stay in the property until his
Yes, my lord. In
life.
fact, he willingly left to, very well.
He will continue to stay in that property
Very
during
well.
his lifetime.
Very well. I'll get
Now
instructions.
it is
Make your
rented
own
out.
arrangements.
It is rented out. He is deriving the rent.
Or rented out.
My lord, they say that he is deriving the rent. I am told that the
Lord,
rent
he is
goes to him
taking the
directly.
rent.
I have not collected the rents, but be
Everything
that
is-
as it may, my lord.
Produce your income tax returns.
I'll do that.
We'll give you 4 weeks time to do that.
My lord, your lordships may pass it over. I'll get instructions on
Pass
this.
over.
Obliged.
Lord, I will file my
Please
objections.
advise your client properly. This is not fair to treat the parents.
No, of
like
course, my lord.
this.
I
Not-
take it, my lord. I bow
Not
down to
how
what
it
falls.
can happen. This kind of things have resulted in this act being passed.
Please, my lord.
Let him file affidavit, Lord,
I'll
I will
get
file my objections. Lord, your lordship judgment in Venkataya case.
Make it in one of the judgments to say parents are advised not to deal with their property during their lifetime. Let the children fight among themselves. Later, it's fine. Don't give it to anybody. Keep it to yourself. Do a reverse mortgage, get the money so that then you don't get it at all.
I
will
see
file
what
my-
falls from the court, my lord.
But I will file
Your
my
lordships may
objections.
pass it over.
Pass
I'll
over.
make those.
I will file my objections, Lord.
Let us see what amount he values his father for. If he is reasonable in that valuation, then at least you will get that money pending consideration of this matter.
Obliged.
26, Vinod Kumar.
Yes.
I am for the petitioner, my lord. Senior is out of station, my lord. He is in Kalburgi bench. So
Yeah,
it
but
may-
what is this matter?
It may be taken up tomorrow or next week.
Produce documents relating to 102 notice.
Yes, my lord.
And AG accepts notice for
My
respondent.
lord, before notice, it may be heard, my lord.
He's only asked you to give the document, nothing else. Released on 18th August.
Much obliged.
27, Abhijit Sharma.
My lord, I am
Sharma.
appearing for the petitioner. This is a ozone matter, my lord. The same matter where bank, we are seeking some protection against the bank. From
Which is this ozone?
Ozone, yes. Yes, madam.
Ozone is under CIRP, Mr. Sharma. You'll have
Yeah,
to go to the NC.
Yes, it is all, ozone has been declared insolvent. The insolvency proceedings are going on. And
So you'll have to go there. Keeping it here will
Yeah.
not help you in any manner.
we have filed
Go to
the
the
claims already.
You approach the NCLT?
Yes, we have filed the claims as directed by them. So all the creditors.
So even
the bank,
all the
financial-
things that you have agitated here will grant you liberty to agitate before the NCLT. So you could take it forward there. Otherwise, they will not consider if this writ petition is pending.
My lord, this is an
Petitioner is before-
additional protection, some protection, some relief. Still, the petitions are being filed here in spite of the NCLT proceedings ongoing.
They are being filed. All of them we are sending it to the NCLT.
So
Petitioner is before this court seeking for the following reliefs. The sixth respondent developer has been admitted to CIRP proceedings and CRP number so and so. ಅದು ಇದೆಯಲ್ಲಮ್ಮ ಇನ್ನೊಂದ್ರಲ್ಲಿ CRP number so and so. In that view of the matter, reserving liberty to the petitioner, raise all the issues raised in the present petition before the NCLT and CIRP number so and so. Petition stands disposed.
28, Shruti C.
For the hearing for the respondent 3 to 5, my lord. We need.
He wants this to be
time.
tagged to some other matter.
No, my lord, it is not tagged. my
Not
lord. What
tag,
my
tag,
query-
my lord. That has been,
No, that's a
what we
different-
submitted is before the quotal number
Not for
12.
orders.
You challenge the acquisition of the land with regard to the link canal. Here is the link canal project itself they have challenged. That is posted for dictation since from 2 weeks. Daily, today also it is there. So some bearing on that, this case. So kindly adjourn for 3 weeks, my lord, or file our objection.
We'll make submissions, my lord. Kindly pass it over.
No, you have had to file objection, my lord.
It is see what this.
Last question also urgent on the ground that the matter is posted there.
Was
We're waiting for
only
the orders,
ordership.
my lord. Yes.
Where-
Unless.
Last occasion has been adjourned for filing of statement of objections.
Yes, ma'am. That is what some
But
hearing
Of
on.
that.
But we mentioned that the other matter is also
Other
pending, which will have a
Yes,
bearing.
but if we remember
Very well.
correctly, it was opposed. Paso.
March.
29.
This matter should not have come to the court at all.
Under
One
the
issue.
aegis of the learned ASG yesterday, there
I'll-
was
I'll-
some matter.
I'll sort it out. Lordship may call this after 3 weeks.
One is a PSU, other is a government,
One is-
central government
One is under
organization.
Ministry of Petroleum, the other one is Ministry of Defense. My lord, I've spoken to the both officers. Lordship may call this after a couple of weeks.
Eviction
We'll get
procedure.
this sorted.
And AGI seeks for and is granted 3 weeks' time
Yes.
to
Sort it out in
To resolve the issue.
to use his good offices to resolve the issue in the present matter. Relist on 24th August.
Yes.
Great.
Serial number 30. A. Chandrachud.
Yes, Mr. Chandrachud. You have to make only one submission. Yes. What are the other connected matters?
In other connected matters.
Here are the numbers.
Yes.
Lord,
That
one-
AGA
one-
accepts
one
notice for
point.
respondent number 1 to 6. The submission of Shri H. Chandrachud, learned counsel for the petitioner on instructions of.
My lord,
Yeah, instructions
on the instructions of the chairman.
of the chairman of the
HMT.
of the petitioner is that the petitioner will not deal with the remaining extent of land in any manner, including by way of sale, lease, license, nor encumber the same by creating any charge or change the character of the said property. In that view of the matter, since this court is seized of other matters pertaining to the very same land, the respondents are restrained from in any manner dispossessing the petitioner till the next date of hearing. Connect with so and so.
May
Lord,
may I
one-
request this honorable court to add one line. Now, the state government itself has filed an application before the honorable apex court with this regard. I have just filed that particular application as an annexure.
Page?
No, that application is withdrawn.
I'll just convince your lordship. Your lordship is pleased to take page number 83, annexure L, my lord.
83.
83.
Yes.
The relevant portion may trouble your lordships to take a few lines out of that particular application, my lord. Page number 80, 88, my lord. 88, subpara 3 on the left-hand corner. However, there are government orders which are available on record to show that under the mentioned lands which are part of the Pinia plantation, Bangalore, are either gifted or granted. This is how the acquisition comes to the HMT. This is their application amendment. Furthermore, my lord, next paragraph. The applicant further submit that as per the records maintained by the government orders of handing over and taking over of the certificate of the documents is that around 443 acres and 6 guntas of Pina plantations were handed over to HMT after taking over the same from the forest department. This particular impugned order is contrary to the statement made by the state before the apex court. They are just pointing out a few points. What are
Let them file their objection. We'll hear you all of the matters.
Yes, my lord. Only my respectful submission is that if this application, now they have filed one more application seeking to withdraw this application. In the meantime, HMT has filed an application before the apex court that direct the state government to denotify this particular. If you are able to get out.
Apex court will be dealing with all those
Yes, my lord.
applications.
So
We'll
my
be dealing with
respectful
this
submission is my undertaking would be that if you are able to get an order there, I might be permitted to move this honorable court for seeking modification. That observation could be made out in the order, my lord.
No, my lord, one submission. Now, out of 480 acres, my lord, which was handed over, the state has now realized is 290 is left vacant with green cover, my lord. That is at the effort to preserve this as the lung space. So therefore, my lord, if my lord should also
That
be pleased.
aspect, the Honorable Supreme Court is seized. You
Yes,
can make your submission there.
Correct, my lord. If I can just say, they should not fell trees also, because the 290 acres has green cover. That's our submissions.
The petitioners, nim submission and nam order.
Some order ಆಗಿ
Not felling the trees.
ಅಲ್ಲ ಇವಾಗ you're
Felling the trees.
ಅಲ್ಲ felling the trees ಅಲ್ಲ I'm not going to come in way of that any order by
Is it, you have
You know.
undertaken this much?
No.
So you undertake that you also won't fell any trees?
that based on the
submission of the Additional Advocate General is that the petitioner may also undertake not to fell any of the trees in the subject land. Learned counsel for the petitioner submits that he has no instructions in relation thereto. In that view of the matter, the petitioner is restrained from felling any of the trees in the subject land till the next date of hearing.
one point to this point I would like to add up, Your Honor. In the impugned order itself, we have brought it to the knowledge of the officer who conducts the proceedings that it has been noted down in the order. If your lordship is pleased to take that particular
What is
portion.
pending before the Supreme Court?
Allah, 178 is already, we have already placed it on record that 178 is already been sold to government agencies, the private entities and other things, my lord. Even though that is brought on record in the impugned order, the officer goes on to pass an order with an extent of 440 acres. So the subject land will cover, if tomorrow, if the third parties who have already taken charge of, by virtue of the documents which are already completed. So we should not be put on.
Other than that which has been sold, already sold by the petitioner to third parties.
Yes, ma'am. Because tomorrow they should not come back if the third party entity starts doing some other work.
You should
I have
not be
taken
held
undertaking and the court has passed a reasonable order.
Should not be held
Yes, my lord. Yes, my lord.
That will clarify. Connect with someone to.
And there are certain properties wherein right now ED is being put on lease, Your Honor. The encumbrance, the enforcement director, we already leased it to encumber the enforcement director. They are in that particular one portion of the land already. And tomorrow leased also, which are already sold
Your
and leased.
business is gone. You return the forest land to the state government so that it can be maintained as
Lord,
forest.
That is the question which I would like to agitate before your lordship. That it's not a forest land. It has been with following the due procedure as contemplated in law.
There is no dispute about the land being forest land. Only issue is the revenue department has taken and given it to you. That's all.
Through the forest department. The order says so.
From the forest department and given to you.
Yes, my lord.
And there are enough judgment which says even Supreme Court is.
My lord, one more line, that depending if we are able to, this undertaking, subject to the Supreme Court, what orders?
Obviously, any order that we pass is subject to what Supreme Court
Because
says.
tomorrow there should not be that.
It won't even be proper for us to say that. Yes. Our orders are all subject to the Supreme Court orders.
Connected
And one more.
numbers, I will hand it over to the court officer.
And one more, my lord. There are certain places where there is already, we have just made, EMDs have been collected and agreements have been made. No, not for alienation. I'm not speaking about alienation. The rents, the rental aspects are, we have already made arrangements to give them on rent to that particular government agencies, not private entities.
Transfer include lease, license, everything, nothing. Don't do anything. Otherwise, they'll go and they have to use the land, they'll cut the trees.
Allah. So this order will hold good for only things which are already completed. For later on, what is balanced with us, we are not going to do any activities.
And no felling of trees
yes.
anywhere.
ಅಲ್ಲ ಅವ್ರು ಮಾಡಿದ್ರೆ ನನ್ನ
By you.
ಯಾಕಂದ್ರೆ ಅದೊಂದು
Petitioner.
ಯಾಕಂದ್ರೆ ಅದಾದ್ಮೇಲೆ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ಅವ್ರು ನಾವು ಆಲ್ರೆಡಿ 170
ಬಂದಾಗ ವಿಲ್ ಡೀಲ್ ವಿತ್ ಇಟ್. ಅವಾಗ ಹೇಳಿ ಇವಾಗಲೇ ಟ್ರೀ ಕಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ಬೋದು.
ಅಲ್ಲ ನಾನು I have undertaken that undertaking will hold good, my lord. But except to that lands which we are retained.
You have dealt with enough, you have sold enough. Rest of it, please maintain as a forest.
Yes, ma'am.
Next.
For dismissal, serial number 31.
Your Lordship, for respondent numbers 1 to 4 in this matter. Your Lordship, matter has become infructuous now because the work was completed in 2024 itself.
Despite the order dated 15/7/26, none appears for the petitioner. The submission of learned counsel for respondent that the above petition has been rendered infructuous was also recorded. It appears that the petitioner is not interested in prosecuting the above petition. Petition is dismissed for non-prosecution.
One submission, which are already been leased, that will continue as it is, my lord. From today, we are not going to lease anything. That will continue, my lord.
That is what we have observed.
Yes, my lord.
But cutting of trees is all.
Cutting of trees from today, cutting of trees, leasing, selling, all will just.
Even your lessees cannot cut.
Yes, we'll just instruct them. We'll just put them on terms onto that particular. But only thing that only my officer's apprehension was that what are already leased, that will continue as it is.
That is what we have observed.
Yes, ma'am.
P group matters, serial number 32, Imran Pasha.
On the last occasion upon hearing, Lord, a direction was given to the ADLR to survey the land with regard to the encroachment.
Yes, my lord, your lordship, may kindly pass it over, my lord. There was some confusion on last date of hearing. The ADLR Hassan was informed when it comes to Chikmagalur, that was rectified. I think it is completed. My lord,
It's complete.
This
Pass.
place it-
Survey is completed.
It's
I'll place the
completed and
report.
they'll get it. Pass over.
Obliged.
Serial number 33,
For the petitioner, my lords, this matter. Arising out of the order passed by the Assistant Commissioner, my lords, under Section 23 of the Act, my lords. Prior to this, my lords, in fact, the matter was referred to Lok Adalat. At that particular time, my lords, in fact, there was a conditional order passed by this honorable court, my lords, on 1/10/2024, directing me to deposit a sum of rupees 10,000. In fact, my lords, I have deposited at the very first occasion, my lords, before the Lok Adalat, just 2 months back, my lords. It has been asserted that the amount was deposited, but it was not encashed by the respondent. In fact, my lords, the direction, my lords, to file an affidavit to that effect, which, my lords, is not filed till date. In fact, my lords, I have the entire set of documents, my lords, to substantiate that I have honored the order, my lords, passed.
You're acceptable for 10,000?
My lords, no, my lords. Till today, my lords, not a single penny has been withdrawn or deposited, my lords. I filed an affidavit on 6/4/2026. I sent the WhatsApp, my lords, on the said day. To his
You have not received
junior, my lords.
the copy, my lords. ಯಾರ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
99020. My lords, a fraud has been paid on the father, my lord's son. My lords, under the guise of preparing a, my lord's, mortgage deed, my lords, he executes a sale deed. Gift deed, sorry, my lord. Gift deed. My lords, now he says that, my lords, he has paid, deposited the amount. My lords, I have secured my accounts in State Bank of India and Karnataka Bank, my lords.
Depositing where in the bank account?
In the bank account, my lords. I
Where
have
is
the
the-
entire set of.
Show us the account statement.
Yes, I do have.
This is my accounts, my lords, where I have.
This is the entire account, my lords, which I have deposited. They'll settle it on the settlement.
Copy.
This is Prashanta G. This is your account.
That's my account.
Yes. Which is the payment made?
My lords, you'll find it from November 2024, my lords, the transactions. Page
November
45, my lords.
45.
45, my lords. 22 November 2024, my lords.
They are considered.
You'll find, my lords, 10,000 deposited, Gopalappa. In the middle, my lords, 22 November 2024. That's deposited, my lords. The next would be, my lords, at page 53, my lords. Again, 10,000, December, 31st December 2024.
Which bank account? This is bank account
My lords,
ending
this
with
is the
335.
My lords?
The bank account of your father that you have deposited is 335. ending
Absolutely,
with-
my lords.
Yes. Where is your account for 335?
My lords, I have submitted 2 accounts where I am, which has been closed. I have no balance in that. State Bank of India and my lords, Karnataka Bank.
This is CNRB and the Canara Bank.
Canara Bank. That's the very account, my lords, which he holds. Let him produce a statement, my lords, as with regard to that
State
account.
Bank
is
of India
concerned.
and Karnataka Bank are not there. This CNRB Canara Bank.
Or she has no account in Canara Bank, my lords. That
Lords,
is
it's the very same account, my lords, wherein he's received the award from the LIC proceedings as well.
He'll just have to ask Mr. Vignesh Shetty to get us the bank account statement.
In fact, I have the acknowledgements also, my lords, for the deposit of.
He has no account in Canara Bank, my lords. That is the statement made.
Being of the considered opinion that the Canara Bank is required to be brought on record as a party, Canara Bank is brought on record as respond number 3. Shri Vignesh Shetty, Canara Bank Vignesh Shetty accepts notice for respondent. Mr. Vignesh Shetty, he is directed to, in a sealed cover, place on record the bank account statement of account bearing number 000037643335 hyphen ASC B 0002001. By next date of hearing. Everything is to this account only, right?
To that account itself, my lords. In fact, my lords, they were also directed, my lords, to give a fresh account details which is not furnished till date. So thereby, my lords, I'm giving them a check for the residuary amount, my lords, which was not parted post the Lok Adalat. In fact, there was a direction, my lords, asking them to give me a fresh bank account, which was not, my lords, furnished till date.
No, this is not the account number. This is a transaction number.
That is what, my lords, will be reflected in the.
What is the account number? Give us the account number.
I'll give the account number, my lords. I'll furnish it.
My lords, kindly refer to those accounts. Withdrawal, it is come under the withdrawals, my lords.
Withdrawal from his account.
Yes, my lord.
From my side, my lords.
His account has been withdrawn. But your name is there.
I'll provide the account details, my lords, right away.
Account number so and so at the better. Relist on 12th August.
My lords, the check, my lords, for a sum of 40,000. I'm paying, my lords. So that there's no discrepancy, my lords, as with regard to the fact that I have not ordered.
The petitioner is offered to make payment of a sum of rupees 40,000 by way of a check. Then counsel for respondent on instructions refuses to receive it. Clearly, Mate. On instructions refuses to receive it.
A fraud has been played here by the son.
That will consider.
Yes, my lord.
First contention that you raised is that the undertaking has not been complied with.
My lords, I have filed an affidavit, my lords, saying that.
You have filed an affidavit.
Yes, my lords.
Whether your affidavit is right or wrong will also have to be
Yes,
assessed.
my lords.
Because implications are there. If he can be wrong in this by filing an affidavit, he can be
Because
wrong in
what
everything.
happened, my lords? The entire accounts, whatever there, my lords, this is the 2 accounts which was operating by him.
Mr. Ramesh,
Yes, my lords.
if an affidavit has been filed wrongly,
My lords, I have specifically stated in my affidavit that there are 2 accounts which has been, my lords, operated by me and it has been closed.
let us find out this.
Yes, my lords.
Much
Interim order earlier granted is extended till next.
Sir, none copy.
Either ಕೊಟ್ಬಿಡಿ ಈ paper.
34, madam, I am to the petition, madam, PDS matter, madam. The petitioner brother running the spare parts shop, madam. After the death of the petitioner brother, madam, the petitioner approached the authority to file the application before the authority, madam. The endorsement, madam, annexure A, madam. The petitioner brother is unmarried, madam. That is the madam, she is not entitled for the compensation, madam. The endorsement, madam, annexure A, madam. It's covered by decision, madam.
Sister cannot claim compensation.
Sister. She is also, madam.
Sister.
She is a divorcee, madam. The petition father and mother, she is also look up the entire family, madam. Having 2 children, madam. After death of brother, madam, he take care of the entire family, madam.
Father, mother, wife and children can claim, not sister and brother, my lord.
Compassionate appointment is
It's very clear, my lord.
unmarried daughter has been extended.
Please,
Sister, how will it be?
sister, madam. She is, madam. The entire family, my lord, the only she also only take care of the family, my lord. The petitioner father also suffering from the spinal paralysis, my lord. She is only earning member of the family, my lord, having 2 children. She also divorced, my lord.
She is a divorced residing with the
Family, along with parents, my lord. She is a divorce, my lord. The Annexura E,
dependent on him.
page number 24, my lord.
Sister cannot claim, my lord.
Compassionate is for dependent people.
Depend, but sister will not come under that category, my lord. She's married and divorced side. It's admitted fact, but she can't claim compassion under the brother. Only father, mother, children, and wife, not the sister or brother, my lord. It's very clear, my lord.
Search and answer this point.
It's very clear, my lord.
Please.
Counsel for the petitioner seeks for and is granted 2 weeks' time to get ready and address his submission as to how a sister would be entitled for compassionate transfer of authorization.
Please.
Released on 19th August.
Please.
Serial number 35, adjourned. 36, Mohan KL.
Yes, Mr.
Seeking issue of writ of mandamus, directing the respondent number 2-4 to consider my representation for granting river raft.
There's a district tourism committee, my lord, that decides how many rafts can be given to each person who applies for it. Now, he has two lands in the between the Kaveri River. He wants to do the river rafting in that stretch of water. We've allowed him to do 2 rafts. That, my lord, is a policy decision which we have decided that everyone else also gets only 2 rafts.
Is this on an application basis?
It's on an application basis. He's applied for it.
Tender
And he's
basis,
got 2.
application basis. What is the basis of allowing this?
My lord, there are permissions sought, my lord, from the committee stating that he owns particular lands in that area. Anyone who owns lands in that area, my lord, can apply. Based on that, my lord, each person is given two rafts. He claims he has 10 rafts.
Consider the representation and give your reasons.
We are likely to reject it, my lord. Anyway, we'll consider it.
Millard,
don't keep.
We won't keep it pending. We won't
1 to 25 is submitted.
Yes.
If your reason may be right, may be wrong.
Please,
They
we'll
can
decide.
challenge it.
We'll decide.
Earlier, I was granted 8 rafting millards.
We can't ask them to give you. We can only ask them to consider.
On my own land.
That is
License millard.
the grievance of
Recently.
the petitioner is that the representation of the petitioner dated 1 to 25 for grant of permission to conduct river rafting in his land in survey number 21/5, Rasulpura village, Somarpet Taluk, Kodagu district, is yet to be considered by the respondent. Learned AGA submit that the petitioner has already been given permission to conduct 2 river rafting
Instead of
from the said land.
Instead of 6, instead of 8.
Even if that be so, the fact remains that the representation submitted by the petitioner has not been considered and orders passed. Whenever any representation is submitted by a citizen to a statutory authority, it is required for the authority to consider the same and pass necessary orders, either accepting or rejecting the same, in either case accompanied by reasons. In the present matter, the representation dated 1 to 25 is pending for more than a year, which cannot be said to be a reasonable period of time. As such, this court passes the following order. Writ petition is allowed. A mandamus is issued directing respondent number 2 to 4 to consider the petitioner, the representation of the petitioner dated 1 to 25 and pass necessary orders within 30 days from the date of receipt of a copy of this order. It's made clear that this court has not expressed any opinion on the entitlement of the petitioner. The same would have to be considered on the basis of the applicable legal framework.
Please. I may be permitted to put one submission, Willard. After my representation, 9 have been granted to some other persons. Similarly, I have been placed.
Per land, how much has it been granted?
Millard?
Per extent of land, how much has been granted?
9 persons have been granted.
9% have been granted. How many each?
Each
2.
The
limit is 2.
ಅಲ್ಲ ಅದೇ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಒಬ್ಬೊಬ್ಬರಿಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಒಬ್ಬೊಬ್ಬರಿಗೆ ಅದು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ.
ಎರಡೇ ಇರುತ್ತೆ.
ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್ ಆದ್ರೆ ಆಮೇಲೆ ನೀವು ಹೇಳಿ.
Limit is
Can't discriminate.
Because I am
Limit is-
entitled because I was handling 8.
If somebody has been given 4 and you are given 2, then there's a discrimination. Then you can always bring it up. If everybody has been given 2, you also been given 2. You can't have a grievance on that.
Time bound may kind.
30 days.
Oh, please.
Serial number 37.
Appearing for the respondent number 1 and 2.
State my lords directed KDB to produce the documents pertaining to the allotment of the.
We have sought an instructions from the board, my lordship. They have to file and give an allotment.
So
Kindly
when
have
will
this
you
matter
do?
after
1 month?
2 days. 2 days time.
2 days.
On Monday.
ಒಂದು ತಿಂಗಳಲ್ಲಿ ಬಂದಿಲ್ಲ, 2 ದಿನದಲ್ಲಿ ಬರುತ್ತೆ.
They have been set.
That council for respond number 1 to 61 is granted 10 days time finally to secure and place the file relating to subject matter before this court. Released 19th August. If the file is not placed on record by that day, the second respondent shall be personally present before this court.
Interim order, my friend.
Interim order earlier granted is extended till next date of hearing.
Much of it.
38.
Appearing for the petitioner, my lords. Previous date of hearing, my lords, your lordship directed me to give another fresh representation, my lords, to the bank.
You're challenging a notice.
Please, my lords.
Cooperative bank. A cooperative bank matter.
Please, my lords. Last time, your lordship directed to give fresh representation, my lords, for the one-time settlement regarding the one-time settlement.
That was when we were sitting in the cooperative roster, not, why is it coming up before us?
This matter comes under the Surface Act.
Then that also cannot come before us.
My lords, also, I have paid 40%.
It will have to go before the roster court. The above matter arises, the perusal of the papers indicate that the above matter arises under the Surface Act. Registry is direct place the matter before the appropriate bench. Interim order earlier granted is extended.
Interim order. Please.
39.
Yes, madam.
Appearing for the petitioner, my lord. My lord, I am the newspaper public, I'm the newspaper, my lord, Suddhigudga, my lord, in the district near Chitradurga, my lord.
You are
It's a writ for certiorari, my lord. Prayer A is for certiorari, my lord, but I do not want to press on prayer A. In fact, my lord, I've also filed amendment application, my lord, in the counter. But also, my lord, I would, if permission be granted, my lord, also.
Serve it on
Yeah,
them.
please, my lord, here's the copy.
What is the amendment that you are seeking for?
My lord, to add the prayer for mandamus, my lord, due to bona fide and inadvertent lapse on my side, my lord, I have added the pleadings, my lord, in the petition, but I've omitted to add the prayer in the prayer column, my
You
lord.
don't press prayer 1 now.
No, my lord.
So amendment you are seeking for a mandamus.
Please, my lord.
And what is the mandamus that you want?
My lord, my representation at Annexure H, my lord, has not been considered by the respondents, my lord. The matter, my lord, in the year 2021, my lord, at Annexure D, my lord, at page number 22 of the writ petition, my lord.
Annexure H, you have made reference to it.
Please, my lord. Annexure H, I've taken the pleadings, I've added the annexure, my lord. It's just that I've not added the prayer,
The
my lord.
prayer,
Therefore, application, my lord.
We'll allow the application, consider the matter.
Please. That
IA number?
it's a benefit that they wanted. Benefits the state gives for a 4-page newspaper. They are, my lord, even as of today, a 2-page newspaper. And therefore, that benefit cannot be accorded. Anyway, I'll consider the representation and.
Tell them that, please. Then, once you give the advertisement, they'll make it 4-page.
Please.
Please, my lord.
This is IA number 1 of 26. Sir. IA number 1 of 26 has been filed for amendment of the petition by introducing a prayer C. The submission of learned counsel for the petitioner is that the amendments in relation thereto, including the prayer, the annexure number as regard which the prayer has been sought for has been made in para 10 of the petition. On verification, it is found to be correct. Hence, IA 1 of 26 is allowed counsel for the petitioner to carry out necessary amendment and file amended petition.
Please, madam.
Petitioner is the daily order disposal. Petitioner is before this court seeking for the following leaves. Learned counsel for the petitioner submits a daily order in non-recording. Counsel for the petitioner submit that the petitioner does not wish to press prayer A.
Please, ma'am.
Hence, prayer A is deleted from the array from the petition. The said amendment to also be covered in the amended petition to be filed. The petitioner is before this court seeking for the following leaves. Only prayer B, C. It can't be C, madam. It has to be B1.
My lord, the amendment application also says that C will be renumbered as D and E, my lord. C and D will be renumbered as D and E, my lord.
Complicate the whole thing with that. It's all entered into the CIS. It can't be renumbering that. So
I'll add it as the next prayer, my lord.
B1 you make it.
Please, my lord.
The remaining grievance of the petitioner is that the representation which had been submitted by the petitioner on 6/1/23 for release of newspaper advertisement in the newspaper of the petitioner has not been considered for the last nearly
It's been
3.5
considered.
years.
It's already considered rejected.
Reason as to the rejection of my representation, my lord. In fact, series of representations from Annexure H have been giving to the respondents, my lord, but none of my representations have been considered, my lord.
Yes, where is 6/1/23 considered?
My lord, 6/1/23 is at Annexure J, my lord. Page number
In
31,
Annexure
my
A,
lord.
where is 6/1/23 considered? Not been considered.
So it's been rejected once already.
Where is the rejection order?
Annexure A, my lord.
Annexure A is just the government, sorry, my lord.
Annexure A does not cover it, does not refer to
Sorry,
it.
Annexure C, my lord.
Annexure C.
Sorry,
It's
sorry.
a 98.
Sorry.
Not been considered. Has not been considered and necessary orders passed. A representation I mean submitted on 6/1/23 has been pending for more than 3.5 years. It was but required for the respondents to have considered the said representation, pass necessary orders, either accepting or rejecting the said representation. Needless to say, in either case accompanied by reasons. In view thereof, this court passes the following order. Writ petition is partly allowed. A mandamus is issued directing the respondents to consider the representation dated 6/1/23 and pass necessary orders thereon within 30 days from the date of receipt of a copy of this order. It's made clear that this court has not expressed any opinion on the entitlement of the petitioner. The same would have to be considered in terms of the applicable legal framework.
My lord, my humble submission, my lord. My lord, liberty may also be given for me to challenge the reply given by the respondents, my lord.
You are assuming that they are going to reject. If they reject,
In
you
case,
always, you always have that as a new cause of action.
Please, my lord.
Amend. Serial number 40.
It's appearing for the
Yes, Anish.
the lien marking matter, my lords.
Ah.
In this 40 and 40.1, my lords, my instruction is that both the matters, my lords, in 40, my lords, the investigation is still going on. The lien has been directed to Marked almost 1 year ago. Still not reported to the Leonard magistrate, my lords.
Not reported to the magistrate.
Not
107.
106 also, 107 also not complete. But the money came through whatever it is coming from it, there's a loan repayment. It's not, we are not directly related to any of these transactions. Even if it is, they got a finding that it has to be
You are
reported.
getting stolen gold, you are getting stolen money also.
Yes.
Oh, my lords, it's a,
So it's a first layer transaction and also, my lord, reported on the NCRP portal. Therefore, my lord, there's no requirement for 1063 compliance is what I'm told.
NCRB portal.
Yes, yes.
it has to be,
To that.
So which police station had reported?
That, my lord, I'll have to
Within the
verify.
state or outside the state?
Bangalore, my lords. Respond number 2, my lords.
Whitefield Police Station.
But either, my lord, they have to comply 1063 or 107, my lords. Both is not complied. Then where is the relief I am here?
The guideline says no, not required as it. It's
Really?
automatic.
MHA guidelines will not say.
But in that case, my lord, it's a part of investigation conducted by the second respondent police. It cannot, they have to complete the process.
BNS is
Only two provisions, my lord. One is for going behind the proceeds of the crime under 107. 106, my lords, also mandates for 1063 for reporting to the landed magistrate. Both are not complied. There are series of judgments, my lords, which has been of the various high courts, which clearly say held that it has to be under 107. Otherwise, we will not have any relief, my lords.
Even if it is on the NCRB portal.
There's an MHA guidelines, my lord, I'll place that.
It will not override the BNSS, my lords.
It's only a
Exactly. Even if there are guidelines by the MHA, will it override 106? If there is a NCRB portal reporting, then there must be a crime number registered. If a crime number is registered, there is a jurisdictional magistrate. If there's, at the most, you can say there's no time limit for that, but you should report immediately so that it's available.
Well, I'll verify whether it's reported or not.
Why we are telling you this?
No, it
is-
automatically locks as soon as a call is made. It's registered, my lord, and we end up
correct
locking those accounts.
But now look at
Freezing
the
those
situation. If they have to get a defreezing order, we are now.
It's only a
doing this.
marking of a lien, my lord, it's not freezing of an account.
Even the marking of the lien, if they have to be lifted, if they have to approach any court, which court will they approach?
My lord, that crime number is already there, my lord. It's crime number 344 of 2025.
So if a crime number is there, then
They
there
are
must be a
notified.
magistrate under whose jurisdiction that particular crime, that police station would be.
Let me verify, my lord.
We had represented to annex that the second respondent with annexer D also, my lord, before filing the petition on September 2025. Still nothing has been done, my lords.
Shaman, there are 3-4 things. One is, okay, NCRB portal, something came up, lien was marked or debit frozen, depending on what it is. Once it is done, either under 106 or 107, those are the only things which are the attachment under 107, seizure under 106. The argument which is being advanced there is it's not attachment, it is seizure that we'll have to consider. Irrespective of either of them, once there is a complaint which comes on NCRB or otherwise, that would have to be 1030 NCRB, everything. Then there has to be a crime which has to be registered. That crime number would have to be informed to the jurisdictional magistrate.
The crime number is from the jurisdiction magistrate.
Correct.
Yes. It's been informed.
Anything in that crime number has to be informed to the jurisdiction, including attachment or seizure.
Please, ma'am. Please.
And if you once inform it, PF memo is filed, then they will have an option to approach that magistrate.
They've approached that magistrate.
No, my lords.
Which magistrate do they approach for?
Page
now?
30, my lord.
We haven't approached. My lords, what I produce is all other
Page 30
orders
they've
which has been
approached.
produced. Mine is not included in that. For that purpose only, I had produced all these documents.
Your seizure is not included.
Mine is not reported. It's 1 year now.
So if DA seeks fund is granted a week's time to ascertain and make a submission. That even in regard to complaints received on the NCRB portal, in furtherance of which either an attachment or a seizure is made, a seizure or attachment is made under section 106 or 107 of the Bharatiya Nagarik Suraksha Sanhita 2023, the jurisdictional police who had either seized or attached would have to report to the concerned magistrate about such seizure. If so, has a crime number been registered in the present matter? And the information as regard the seizure stroke attachment has been communicated to the magistrate having jurisdiction over the said crime number? If not, why not? Released on 19th August.
40.1, my lords.
Huh?
But this my lord, in matter, this charge sheet is already in file. The particular seizure is not part of the charge sheet. PF is not there. My lord, the crime, my lord, from the person whom I received the money, the crime is already stayed against that person. My lord, the charge sheet, my lord, also I produce along with
It
them.
does not take away the thing. This is not part of the charge sheet because of the stay.
No. Charge sheet is filed. After filing the charge sheet, crime is stayed against that particular person. And even the charge sheet, my lord, it is not that particular PF is not there.
Just pass it on.
40.1, the submission of learned counsel for the petitioner. Either lien on the account of the petitioner has been marked despite the said account
No, it's here.
not being part of the charge sheet.
I'm just placing extracts of the charge sheet, my lord, to your lordships.
This is again only, my lords, the intimation given to the bank.
Can you just?
It is part of the
It's-
charge sheet.
It's part of the charge sheet, my lord. Page number 805, 806 and 810. I've extracted that as well. His account is here.
The account may be there.
801.
Yes, please.
Marking of the lien is at page 805, my lord. Thereafter, my lord, it's charge sheeted at page 810.
Letter, where is it? There. It's a letter only. Letter is a part of charge sheet. My lords, may kindly
805
see.
is the letter 810.
My lords, may kindly see the memo, the document produced on 27/20/26, my lords. I had produced the entire charge sheet, the head of the charge sheet.
This is also extract of the charge sheet itself.
27/20/26, I had produced, my lords.
40.1.
We see page 5 of the writ petition.
Yes,
Well,
which
page number 2, my lords.
Hmm.
My lord, 1 PF, my lord, 86. This is some other, my lords. And page number 3, my lords. 1 PF 119 of 2025, 24, my lords. Again, some other articles. Page number 4, my lords. PF number 116. Again, some other articles, my lords. My lord, page number 5. PF number 98 of 2024. Again, some other, my lords. Then page number 7, my lords. PF number 153 of 2024. Again, some other, my lords. These are the only PF part of the charge sheet. It's reported. Otherwise, my learned friend provide the concerned PF number. I'll go for the land magistrate. It is been, my lord, the intimation has been given to the bank.
AG is direct secure inspection as to whether a PF memo has been drawn up as regard the seizure of the particular account of the petitioner. If so, to place the same on record. We list on 19th.
My lords, maybe at 2:30, my lords. It's a lien marking matter, short matter. my lords.
Take.
Interim order to continue in both matters.
Do one thing, you only start dictating everything.
My lords, maybe.
Yes, next.
41. Sriram T. Nayak, connected matter.
My lords, I'm appearing for the petitioner. I'm seeking for a short accommodation, my lords. Next week, any day, my lords, please. Some personal inconvenience today.
Yes. And counsel for the petitioner seeks fund is granted 2 weeks time, released on 19th August. Interim order earlier granted is extended till next date of hearing.
Serial number 41.2. You is there.
41.2. There is no 41.2.
41.1.
Only 41 and 41.1.
Oh, IO needs to be extended.
Interim order earlier granted is extended.
Serial number 42.
My lord, in serial number 42, I appear for respondent number 2, my lord, bank.
Yes, Sushant.
This is the case of placing the lien on the account.
Lien on the account. Lien or debit freeze?
As per the listing, my lord, lien imposed upon petitioner's bank account. That is what the prayer is. Prayer, my lord. Upon instructions of the first respondent, bank has placed lien of rupees 77,000.
There is no amount that you have mentioned. What is the extent of lien?
Extent of lien in the petition, they mentioned 77,000 in para 3 of the petition.
Sushant Pai. You are Mr. Sushant Pai.
No, my lords, I'm appearing for the same office.
You are going to appear in 42 or no?
43, my lords.
42
42.
is where his name is shown.
My lords, my bad, my apologies, 42 serial number. Because it was showing 43 on my cause list, so.
Where did you get your separate cause?
It was showing 43, my lords. Sushant Venkatesh Pai's writ petition 35243, if I'm not mistaken.
I don't know where you are getting your cause list from. What do you want to say in 42?
Lords. Lords, it's a matter of defreezing of the bank account where the first respondent has placed a lien of a sum of rupees 77,000.
So which
West Sen Police.
it's here only.
Your
In which
Lordship,
crime number is it pending?
Lords, there is no FIR that has been registered till this date. So I've been told that over an call, they have placed a lien. And this was placed, the lien was placed in year 2024, my lord. It's been more than a year, no formal investigation. If there is one, I have not been invited.
I did not ask you the question.
Apologies, my lord.
Yes.
Your Lordship, may kindly
Which
pass it
crime
over.
number is it pending?
I will settle. Your Lordship, may kindly pass it over. my lord.
Pass over.
Grateful.
Crime number and which court is it
Yes,
pending?
my lord, I will.
Serial number 43.
My lords are directed for the filing of an affidavit by the state answering the allegations. You sought for a mandamus for direction of an investigation, my lords.
The affidavit is filed, my lords, on
Affidavit.
1st of July, my lords.
Copy has not been
1st
served.
of July.
Yes, my
Don't
lords.
have a
It has not
copy
been
here.
I have an acknowledgement for having served, my lords. Madam, check ಮಾಡಿ ಒಂಚೂರು. 1st of July. I'm told
You
my
only have the
learned friend also
petition,
served.
only
Not
this.
been-
It says 1st of July. I'll make copies, my lords. My lords may have it tomorrow, day after, any time. My lords, I'll even give a beforehand.
No, day after Rajyanada, it goes for time. Pass over. That's it. Give him a copy also.
I'll right now provide it.
File that. That's it.
44.
Lord, I beg to appear for the petitioner, my lord.
Yes.
My lord, the petitioner is an auction purchaser, my lord. What is under challenge, my lord, is registration of a gift deed, my lord, in contravention of the SARFACI Act. My lord, your lordships have already protected the petitioner with an interim order, my lord, restraining that donee under the gift deed from dealing with the property. My lord, in brief, my lord, the property comes to be sold. I pay the money, my lord. Sale is confirmed. Sales certificate is registered. This borrower, my lord, loses before the DRT, comes before this honorable court. Writ petition is rejected, goes before the DRAT, and in the midst of all of this, my lord, sub-registrar permits him to register a gift deed in favor of his brother.
Prior to the sale or after the
After the sale, my lord, after having lost before the DRT, after having lost before this honorable court,
After your sales certificate was registered.
after it was issued, my lord, after issued,
When was your sale? Before the registration sales certificate or after registration?
before registration, but after issue. But all of this is after registration of a memorandum of deposit of title deeds before the same sub-registrar notifying that this property is mortgaged. And my lord, it's not only that, my lord, it's on conduct also. They go before the DRT twice, lose twice, come before this honorable court in a writ petition, rejected. Immediately, my lord, thereafter they gifted in the name of.
As regards respondent number 1 and 2.
Yes, my lord, as regards 1 and 2, my lord.
Yes.
1 is the borrower, 2 is the donee, my lord. And in similar circumstances, my lord, in the lordships have passed a detailed reported judgment, my lord, in case of Arsil, where sub-registrar, my lord, permitted all of this to
R2,
happen.
my lord. I seek a short thing. I have not received any instructions from R2. A week's time, my lord, so that I will file.
R2 is the donor or the donee?
Donee, my lord. R2 is the donee. R1 is
R2 is the donee, R2 has been
R2 is the
represented.
son of R1.
Brother.
brother.
Brother, my lord.
Brother of ours.
Son of Gangaya. Yeah.
Yes, my
Brother of ours.
Lokesh, Harish.
lords may only consider, my
So
lord.
I just want to place it on record, my lord. I just want to seek certain instructions. That's all.
My lord, in quite some time, my lord, and my lords may only consider the predicament of an auction purchaser who complies with everything.
We'll deal with that. But in this particular case, is there any allegation against the sub-registrar?
Yes, my lord.
What is the
My lord, my allegation is, my lord, that when the very memorandum of deposit of title deeds under which this property was mortgaged is registered in the office of the same sub-registrar.
Is not to look into those.
My lord, one is, my lord, some amount of, my lord, basic enquiry. The second is, my lord, under the amended Registration Act, under which it is now incumbent on the sub-registrar to refuse registration of a document which is in contravention of law. And the law, my lord, in this case, in my respectful submission, is that under the SARFAESI Act, the moment a notice is issued demanding entire payment, my lord, they are not allowed to
Brought
transact.
to the notice of sub-registrar.
My lord,
Has it been brought to the notice of the sub-registrar?
my lord, I can't say, my lord, that the bank would have to say.
You impose a duty on the sub-registrar without knowledge.
My lord, the MOTD, my lord, is registered, and normally that would be discharged. Normally that would be
MOTD
discharged. MOTD registered in
Once a
2000.
mortgage, always a mortgage, will continue with whoever is a donee. So that is not something that you can attribute to sub-registrar.
But he's a primary charge holder, my lord, that his rights will not be issued by executing a document which is a nullity under law. If at all, if he has a first charge.
He is
If he has
not
a
the first charge, he is a auction purchaser.
Auction purchaser.
Chat with me. That I beg to appear on behalf of
He,
Canada.
he is here. The first charge
Charge
holder
holder
is
is
here.
here.
My lord, after selling the property in favor of my lord, Mr. Arjun's client, my lord, the present my lord deed took place.
My lord, till date, I have not got possession.
If
also,
also
my
is
lord.
the injunctive relief not to do anything in future, but already this has been done.
Now, we have dealt with it. In these matters, we have to
Yes, yes.
intervene. Otherwise,
22B as per
there
the
won't be
new-
any value for.
No, my lord, the amended rule of the Registration Act 22B, my lord. That is what your lordship judgment is there on that point.
Yes.
Short accommodation.
He has to answer.
Nothing beyond. Short.
Nothing much to answer. That counsel for respond number 2 seeks for and is granted a week's time, released on 4th at 2:30 p.m. Please.
Grateful.
Vignesh, there is one matter
Please,
in the our serial number. We are directed to take notice.
33.
Huh?
33.
I'll take this.
33. There is a dispute as regard the payment.
I'll just.
The son has deposited money in the father's account is what he claims. Father says it's not come to my account. That bank account is in Canara Bank. In a sealed cover, produce the account statement in a sealed cover.
Grateful.
45. A. Ravi Shankar.
Yes, Mr. Vishankar.
Matter under senior citizen. Last time Tamunde Bantu, I made a submission that I am ready to take back my mother and pay about 20,000 rupees per month. My friend.
How much?
20,000 rupees. Tamge held. Amele, my lord directed him to respond. He has filed statement of objections in response to that. And I may be permitted to.
My lord, I encountered with my client, my lord. After the adjournment, my lord, they went to the spot and saying that threatened that, my lord, you have to leave or otherwise we will look after in the court. They said that that's why my party is not agreeing.
We'll look after in court, don't worry.
Ian
We'll look
Martha.
after both of you.
Yes, but that's I.
My lords can put some conditions on me. Atara ಏನು ಆಗಿಲ್ಲ. I am ready to take any conditions, my lord.
Shall we refer it to mediation?
ತಮ್ಮ ಮುಂದೆನೆ ಆಗ್ಬಿಟ್ರೆ faster.
One moment, kindly see the earlier gift deed as well as this gift deed, entire
ಅಲ್ಲ,
family
ನೀವು argument
property.
ಮಾಡಿದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ argument. If my lord were to suggest for a mediation, I am ready to take that order, my lord. My lord and friend wants to argue, I am ready.
I don't.
See, if that is the only difference, then
Yes,
it could be sorted out.
Yes, sir.
If it's only about money, it can be sorted out. If there's an issue about anything else, we'll have to decide.
Yes.
But if it's only about money, you can.
Money is my party is not agreeing money factor because she already gifted one property in Bangalore property is more than 6 to 7 crores, and she has attachment with the agricultural property. Since from the marriage, she's look after the entire.
So it's not about money.
Not about money because
Then
not
we'll have
about.
to argue.
Rejoinder.
Third counsel for the petitioner has filed a rejoinder to the statement of objection filed by the counsel for respond number 1. Copy thereof has been served.
Now I receive.
ನೋಡ್ಬೇಕಾ?
ಏನು ಡಿನೈ ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇ ನೀನು.
ಒಂದು ಇದಕ್ಕೆ ಪ್ಯಾರಾ 16 ಗೆ ಅವರು ಆನ್ಸರ್ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ ಮತ್ತೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
ಹೇಳ್ತೀನಿ.
ಇವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ರೆಡಿನಾ ಇಲ್ಲ ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀರಾ ಅಂತ ಅಷ್ಟೇ.
ಡೇಟ್ ಅಲ್ಲಿ ಶಾರ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ.
Counsel for respond number 1 seeks fund is granted a short accommodation released on 19th. Interim order earlier granted is extended till next date.
Great.
46. Sushant Tiwari.
We kindly pass over, my lords.
There's a sub-council engaged, my lords. So
You
Dhyan
are
is
here.
leading them.
So,
47.
Short point, Lord.
Lord,
We had mortgaged
47.
47. Property was mortgaged before the bank. Certain amounts were taken as loan. The loan stands discharged. We're only requesting for return of our documents. Not the bank
Loan is
side.
discharged.
The loan has been discharged. There's no dispute on that. The only
Lords,
reason
I've
why.
filed my statement of objections. Our only point is this, my lords. The loan was taken in the name of two people. There were two co-borrowers, one being the deceased Mr. G.S. Ramesh and one being his wife, some Srimati Yashoda. Now, we have no issues with, we put forth, my lords, we've put forth, we have no issues in handing over the title documents, my lord, but we don't want anybody else to come after us. There are, as per us, there are three known legal heirs to the deceased Mr. Ramesh. If all three of them come together, we are happy to hand over. If that Srimati Yashoda comes forward with an NOC, we are happy to hand over.
Yashoda is not a party to this.
Yashoda is the second wife, my lords. We've put forth proof in terms of a family tree, in terms of a wedding invitation. They have boldly refuted that she's a wife, my lords, legally wedded wife.
Where is the loan document?
Loan
Whose
document
name?
we have produced with our statement of objections on page 11, my lords.
Ramesh
We have
and
served it on by email on your council.
been filed on 8/7.
Sorry, ma'am.
The
Been
statement of
filed.
objections has
8/7
been.
has been filed.
We have not.
Through email.
We have
copy
served
and
it on email, my lords. I'll
Give him
share
another
it.
copy.
I'll serve a
The-
copy, my lords.
The deposit of title deeds has been made by Ramesh and Yashoda.
You can have a look at mine. I'll serve a copy.
But if your lordship were to see, if, in fact, if Yashoda is claiming to be my second wife, she has not impleaded herself in this petition. She
You
has
are, the,
we too.
you are the person who has filed.
They should have actually made party, my lords.
1 minute. Not just see what the prejudice, just see. Now, if the bank were to return the documents to me, ultimately, my lord, if she has a share in the property and it is transferred, it will not bind her in any case. Why are they sitting on the
Mr. Kamath,
document?
that is not the thing. The loan agreement is between Ramesh and Yashoda with them. You are not a party to that. If it was only your husband who had done it without Yashoda being there, yes, you could maintain this argument. But when Yashoda is a party to the loan agreement who has deposited it, this argument will not be available for you.
But we have not seen that. Your lordship
That
may have it
agreement.
on some short paper.
Give one more
I'll
copy.
serve them, my lords, on the next day.
Council for respond number 1, submit that that in terms of annexure R1, annexure in document number 1 to the statement of objection which has been filed, the loan was availed by Mr. Ramesh, son of Siddhalingaya, and Mrs. Yashoda, wife of Ramesh. Our submission is that the petitioners are not parties to the loan agreement.
No. The borrow.
Wait till we dictate. It is our submission, not your submission. The petitioners are not parties to the said loan agreement, but are claiming under Mr. Ramesh. Since Ms. Yashoda is also a party to the loan agreement, without Ms. Yashoda coming forward to offer her consent, the documents cannot be returned to the petitioner. The counsel for the petitioner seeks for and is granted
2 days. Look, the reason is.
a week's time to obtain instruction, make a submission. Relist on 12th August.
48, GS Venkata Subbarao.
I appear for the respondents, Your Lordship.
File amendment application, ma'am. File amendment application.
Amendment. Counter right.
Please, copy, sir, ma'am.
An amendment.
Notification.
In fact, this amendment may not arise for the reason that this
Notification.
has already been answered by Supreme Court. In seal number 18, in fact, Your Lordship, I was tempted to say that let there be extensive guidelines. I just didn't want to deprive the petitioner of a disposal. In this case, Your Lordship may consider.
Second, respond to issue a full validity passport. What are you challenging? What is the amendment application?
Notification.
What do you want to do? You want to file your objection to the amendment application or?
I'll file, Your Lordship, because this is covered by Supreme Court judgment. I'll file.
Place it on this.
The judgment is already on record.
ಎಲ್ಲಿದೆಯಪ್ಪ?
Mahesh Kumar Agar.
Mahesh. Lordship, judgment was filed on 20th of February. Mahesh Kumar Agarwal versus Union.
Mahesh Kumar Agar. ಇದೆಯಾ? What is the amendment now you are seeking for?
ನೋಟಿಫಿಕೇಶನ್ ಚಾಲನೆ ಮಾಡ್ತೀನಿ ಅದು 10 years ನೋಟಿಫಿಕೇಶನ್ ಅದು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಸರ್.
Your GSR 570E you are challenging.
Yes, madam.
That's been considered by Supreme Court.
Can you take up on after 2 weeks madam? Senior father death ಆಗಿದ್ದಾರೆ ಹಾಗಾಗಿ.
Counsel for the petitioner submit that he is filing amendment application. Copy thereof has been served on the counsel for respondent. Counsel for respondent is granted a week's time to file a statement of objection, released on 19th August.
49. Prashant Krishna Rai, party in person.
Your Lordship, I am the petitioner, party in person, my Lord.
Yes.
Your Lordship, in the previous occasion, Your Lordship was pleased to pass an order. So I just like to provide a brief submission on the facts, my Lords here. So this is matters related to an RTI application that I had filed 3 years back. That is on 10th of March 2023, which is annexed as Annexure 1, Annexure A in under page 10, my Lords. So in this, I've sought 2 pieces of information from the first respondent, so which is also mentioned in page 11 under here, which is available on their record. But I didn't receive any information, and hence, as stipulated, I also filed a first appeal on 11th of April 2023, annexed under page 14, my Lords. But even then, I did not get any response, and again, as stipulated, I filed a second appeal with the third respondent, and this copy was also produced to the first respondent, my Lords. But despite this, there was no response from either the respondent number 1 or 2. And in the interim, from the special DC's office, I received a notice asking them, even the response to be present. But again, there was no response. They didn't even attend the proceedings. And then the second appeal of mine came to hearing, that is after 2 years lapse, my Lords, from the State Information Commission on 6th of May 2025. Where the respondent number 1 and 2 were asked to appear in person and also make the submissions, which again they did not comply to. And in accordance to that, the State Information Commission, that is the respondent number 4, had actually then called for the final hearing on 5th of June 2025, and an order was passed owing to the non-compliance to the order of the Commission, my Lords. So despite that,
So
and it's been a lapse of so many.
Apart from penalty, there's no other execution proceedings under the KSC Act to take action against
disciplinary action. For disciplinary action, recommendation can be made.
Disciplinary, but to get that information.
To get the information, there is no any enforcement, specific provision for the enforcement of the order passed by the Commission, my Lord.
RTI Act.
Yes, please.
And why are you not
section
furnishing the information despite 3 orders?
Section 20.
Section
20, 20 subsection 1 and 2, where the Central Information Commission or the State Information Commission, as the case may be, at the time of deciding any complaint or the appeal, is of the opinion that the CPIO or SPIO, State Public Information Officer, as the case may be, has without any reasonable cause refused to receive an application for information or has not furnished the information within the time specified under subsection 1 of section 7, or malifiedly denied the request for information, or knowingly given incorrect, incomplete or misleading information, or destroyed information which was the subject of the request, or obstructed in any manner in furnishing the information, it shall impose a penalty of 250 rupees each day till application is received or information is furnished. So, however, the total amount of such penalty shall not exceed 25,000 rupees. Then they provided that subsection 2 under the my Lord, where the Central Public Information Officer or State Public Information Officer, as the case may be,
at the time of deciding any complaint or the appeal is of the opinion that the Central Public Information Officer or State Public Information Officer, as the case may be, has without any reasonable cause and persistently failed to receive an application for information or has not furnished the information within the time specified under subsection 1 of section 7 or mollifiedly denied the request for information or knowingly given incorrect, incomplete or misleading information or destroyed information which was the subject of the request or obstructed in any manner in furnishing the information, it shall recommend for disciplinary action against the Central Public Information
This
Officer.
does not answer his problem.
It's okay, Manoj.
His penalty is fine, his disciplinary inquiry is fine. He doesn't get his information.
Yes, please. Only this honorable court under Article 226 and he has got wide powers.
And sir, push this court, my lords.
Then there's a big lacuna.
My lord, I think there's some confusion with regard to the.
Para number 10, only there is a specific direction given by the Karnataka State Information Commission, my lord. Page number 29, my lord.
So now who do we direct to give the information?
No, my lord, I think there is some confusion, my lord. What has happened is, the lordship will kindly see annexure F, page 28. He has
Yes.
made the respondent, first respondent is the Bangalore South Tehsildar and also the Assistant Commissioner for Yelahanka.
First appellate authority.
Upavibhagadhikari, Bangalore Dakshina Taluk ಅಂತ ಹೇಳ್ತಾರೆ.
Yes.
But whereas the information sought is from the North Tehsildar. And the name of the officer is correct. At page 31, your lordship will kindly see. Shri Shreyas Sarvajanika Mahita Adhikari of Tahsildar, Bangalore, Dakshina Taluk, which is wrong. And also the name of the Assistant Commissioner of the Second Appellate Authority is also was the Assistant Commissioner of Bangalore South. It should have been Bangalore North.
But he was, okay. The information sought for is?
For the
From
land
the
which is in the North Additional, which is Yelahanka Tahsildar, Yelahanka Taluk. That's the reason maybe that they have not appeared.
So the array of parties is wrong.
Array of parties is wrong, but in the meanwhile, my lord, if your lordship gives us some time, I will pursue the matter with the North Tehsildar additional.
Get the information.
Right now, they are a little busy with the SIR. Now, 2 weeks time may be granted, a couple of weeks time may be granted.
And AGA submits that the reason why the order of the Karnataka, the First Appellate Authority as also Second Appellate Authority could not be complied with was that the information which has been sought for is as regards from the Tahsildar Bangalore North.
North Additional.
North Additional.
Yelahanka Taluk.
Bracket additional, whereas the Tahsildar of Bangalore South had been made a party. He seeks for 2 weeks' time to obtain the necessary information from the Tahsildar Bangalore North.
Additional. Yelahanka.
Additional.
It's now.
Office 2 and make available same to the petitioner. Released on 24th. Yavattu SIR, when will it get concluded?
SIR is on September 5th, my lord.
24th August.
24th.
Much obliged, ma'am.
At 2:30 PM. You can come at 2:30.
Yes.
Serial number 50, P. Prasad.
For the petitioner, respondent is challenging the fifth respondent as the National Highway acquisition of the property of the year of 2023. In annexure, yes, page number 137.
You are seeking for quashing of the award.
Quashing of the award annexure V, Your Honor,
Award nammunde barutte.
without determination.
Acquisition award.
Allah, Your Honor, it's a year more than 2022. Till today, they have not considered my representative, even email correspondence. They have to drag on the matter, Your Honor. They have not considered, only to a fresh consideration of my, only for writ of mandamus, for the fresh consideration. Already the Honorable Court has order to consider the rent damages
For
of
a
the.
certiorari, Mr. Counsel,
Yes, please.
You're asking for certiorari to quash Annexure V, which is
Yes,
an
please.
award.
Annexure V.
So an award challenge will.
It's not an award, Your Honor. Simply saying this, simply they are out of 40 lakhs to pay. Without determination of the value of the building. Earlier, the Honorable High Court has passed an order to to consider the acquisition of the subject of the Rectacular Act and resettlement of compensation, but rent damages of the compensatory relief, including the loss of the damages of petitioner. They have not stated only to reconsider a refresh consideration, maybe. So, representation go to, they have not, AW have not considered my representation. Building, I have the plan, photographs, I have to produce. Even building plan also approval.
Land acquisition court go back, illi barಬೇಕಾ? This is an award.
As award anತೀರಾ ಏನಂತೀರಾ? I'll read out Annexure V one. ಕಟ್ಟಡ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, ಅದನ್ನ they have not, I'll read out, please. Yes. WP ಸೋನ್ಸೋ ಇಲಾಖೆ ವಿರುದ್ಧ ದಾವಣಗೆರೆ ರಸ್ತೆ ಕಟ್ಟಡಕ್ಕೆ ಹಾನಿಯಾಗಿದ್ದು ಮತ್ತು ಕಷ್ಟ ಪರಿಹಾರ ಒದಗಿಸಲು ದಾವೆ ಹೂಡಿರುತ್ತಾರೆ. 9/11 ದಾವಣಗೆರೆ PB ರಸ್ತೆ ಕಟ್ಟಡಕ್ಕೆ ಆದ ನಷ್ಟ ಪರಿಶೀಲಿಸಿ ಪರಿಹಾರ ನೀಡಲು ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಆದೇಶಲಾಗಿರುತ್ತದೆ. ಆದರೆ ಭೂ ದಾಖಲೆ ನಿರ್ದೇಶಕ ಕಚೇರಿ ಸದರಿ ಅಳತೆಗಳ ನಿವೇಶನ ಕಟ್ಟಡದ ಹಾನಿ ಆಗಿರುವ ಭಾಗವನ್ನು ಗುರುತು ಮಾಡಿ ನಕ್ಷೆಯನ್ನು ಪಡೆಯಲಾಗಿರುತ್ತದೆ. ಆದರೆ ದಾವಣಗೆರೆ PB ರಸ್ತೆ ಅಗಲೀಕರಣ ಆಗಿದ್ದು ಸದರಿ 14 ಲೋಕಭಿ ಶಿವಮೊಗ್ಗ ದರ ಪಟ್ಟಿ ಅನ್ವಯ ಕಟ್ಟಡದ ಮೌಲ್ಯಕರಣ ಸವಕಳಿ ಕಳೆದು 40 ಲಕ್ಷ ಅಂದಾಜು ಪಟ್ಟಿಯನ್ನು ತಯಾರಿಸಿ ಅವಾಗಾನೆಗೆ ನೀಡುತ್ತದೆ. They are not a determination as the market value of the property.
How is this writ petition maintainable, Mr. Counsel?
Yes, please.
How is this writ petition maintainable? They have determined that,
Yes.
and they have said that this is what it is.
Yes.
If you are agreed by the quantification which has been made,
Yes.
can you come in a writ petition?
Yes, is ಅಲ್ಲ.
Yes ಅಂದ್ರೆ ಹಿಂಗೆ ಯಾವ provision?
ಅಲ್ಲ. Earlier there is ಅಲ್ಲ Rana.
Mandamus, yes.
Yes, mandamus.
Or ಮಾಡಿಲ್ಲ, we'll direct them to do it. Now that they have done it and you have challenged it.
ಅಲ್ಲ. Your Honor, one is
land acquisition matters ಮಾಡಂಗ್ ಕಾಣ್ತೀರಾ ನೀವು, so you should know where you have to go.
ಅಲ್ಲ. There is one what happened. One is blind. With already the Honorable High Court has passed an order to determine the market value and to calculate.
Consider your representation and do it ಅಷ್ಟೇ.
Yes.
That is what they have done, right or wrong? According to you, wrong.
According to you is.
According to you, completely wrong.
My completely is wrong by the.
Hopelessly wrong. ಆಯ್ತು, ಅದಾದ್ಮೇಲೆ where do you have to go?
ಅಲ್ಲ. Have to.
Acquisition under which act?
Of the National Highway 3G.
Section 3G ಅಲ್ಲಿ ಏನಿದೆ provision?
Sir, there is acquisition by the.
If you agreed by the determination made.
National Highway, the National Highway Act.
You have to do. We can't determine it here in a writ petition.
Alla.
Correct or wrong? How can we say
Alla. That earlier the two matters already they have filed this classification.
Mandamus, yes.
Yes.
After determination, no.
Alla. None, what my consideration, only the fresh consideration already.
For that we have to set this aside. We don't have the jurisdiction to set it aside in the writ petition. It is the nature of an award.
Yes, please.
Whatever, we can't advise you.
Yes.
We are stopping there.
No, Rana.
We'll reserve your remedies available under the NHA Act and you can avail of it. We can't determine or redetermine.
One submission, Your Honor. That is the annexure S and V, the same S and V. Page number 137. 137 and 143. The same we have filed earlier also. That consider my representative to consider the rectacular act in the National Highway.
Consider your representation, Ashte. Consider we can always do that.
Yes.
It's already been done.
It's already.
Now they have not considered it hopelessly bad.
Allah.
They have passed an order. In a writ petition, can you challenge it? The other things which you can challenge, not the award.
One more, I request this Honorable Court to be fresh consideration, at least I have given.
That requires us to set it aside, which we don't have the jurisdiction. We can't set it aside in a writ jurisdiction. If you are sitting in MFA jurisdiction, yes, not in writ jurisdiction. So, Land Acquisition Act will not apply, it will be 3G. You'll have to follow that. What has been challenged? Petitioner is before this court seeking for the following reliefs. What has been challenged is award passed by respond number 5. The acquisition having been completed under the National Highways Act 1956. The petitioner, if aggrieved by any award passed, can always avail of the remedies provided under said act.
Maybe the honorable please convert. It's very.
ಇದು ಕನ್ವರ್ಟ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. It won't be before this court.
I'll make it an
note reserving liberty to the petitioner to avail of such remedies are available under National Highways Act 1956. The petition stands disposed. Arbitration, we can't advise you. So
yes.
51. It is denied.
I make one submission, my lords. Petition copies, if they may be directed to give me a copy, my lords.
I furnish, this honorable court has directed me to take notice to Shri Pawan Kumar. I will furnish one more copy.
Shri Karnataka NBS has entered appearance for respondent number 1 to 4. Delete the name of Shri Pawan Kumar as that appearing for 1 to 4. You have given copies to Pawan Kumar?
Yes, I have furnished. I will
Don't
furnish
waste
one more
paper.
copy.
Collect it from Pawan Kumar.
Also, at my cost, I'll take it, my lords. At my cost, I'll take it.
Cost ಅಲ್ಲ paper waste ಬೇಡ ಅಂತ.
ಗೊತ್ತಾಯ್ತು, my lords. ಅವರು ಕೊಟ್ಟಿರ್ತಾರೆ ಲೀಗಲ್ ಸಲಹೆ ಅದು
ಹೋಗ್ಬಿಡುತ್ತೆ ಹಾಗಾದ್ರೆ ಇನ್ನೊಂದು
furnish.
Counsel for the petitioner is direct furnish one more set of the petition along with annexes on Shri Karthik NBS, who seeks for and is granted 2 weeks time to obtain instruction, make a submission. Released on 24th August.
Next, my lord. Earlier date may be given, my lord, because I'm challenging the communication. My name was blacklisted.
Just on blacklisted 11th August.
Much obliged.
52. Ashoka T.
Lord, I seek 2 weeks time to file objection, my lord. In this, the only issue is in the paper publication, the closing of the time is not mentioned, but in the electronic portal, it has mentioned. We have mentioned it.
Place it on. AG seeks for and is granted 10 days time to file a statement of objections along with the accompanying necessary documents. Released on 14th August.
My lord, interim order may be extended.
Interim order earlier granted is extended till next day.
Serial number 53.
Respond number 3.
Yes.
Lordship.
Lordship's counsel for the petitioner in 53.1 and 2. 53.1 and 2.
There are multiple matters. You are appearing 53.1 and 2.
Yes, Your Lordships. For the petitioners, 53.2 has been settled, Your Lordships. This is the settlement.
Vinay Kuttappa, same thing.
Your Lordships, mine is an NOC Wakalatnama.
You are appearing for whom now?
The petitioners. Instead of Vinay Kuttappa, mine is an NOC Wakalatnama.
53.2.
1 and 2, yes.
53.1 is settled.
53.2 is settled.
That is why we are dictating in 53.2. 53.2. Yashashvi Dasri has entered appearance for the petitioner. Delete the name of Shri Vinay Kuttappa as that appearing for the petitioner.
53, my lord, 53.2 I am appearing on behalf of respondent.
Settled?
Filed a vacating stay, my lord. They filed a joint memo, still they have not paid the amount.
Give us a memo. 53.2 they are saying is settled. 33779.
Settlement report.
Lordship,
53.1
for
is
53.
Just a moment, please.
53.2.
It is settled, sir.
Yaudappa 33779.
Yes, sir, that is settled. Here is the.
We have no knowledge. Please, I will go through it.
Memo idea adರಲ್ಲಿ. You are filing the memo now. ಕೊಡಿ. $53.2 ಕೊಡಿ papers. Pradeep Jadhav. Yes, Pradeep Jadhav has signed this document.
Please, please. Close.
Petitioner is before this court seeking for the following release. A memo enclosing a deed of settlement and full and final release has been filed.
Your knowledge ಇಲ್ಲ ಹೇಳಿ. They gave only this thing.
Payment has been made.
Your Lordships.
Where are the details of the payment? These checks have been handed over.
My lords, the joint memo is filed, my lords. I have to ascertain whether the check or DT, whatever.
That is why we are asking you.
Before this court only, my lord, they have submitted this. I have to verify with my party.
We'll pass over, get instructions from your
Please.
client.
My Lordship, one more submission.
53.2 Adu.
This may be connected with 53, Your Lordship.
We'll connect it later. Just a moment, please. What about 53?
For 53, Anusha, I'm appearing for Anusha on this.
53.1?
Your Lordship, it's me. Compliance is there, Your Lordships. Grant me 2 weeks, I will comply with the.
Counsel for the 53.1, counsel for the petitioner seeks fund is granted 2 weeks' time to comply with the office objection. If compliance is not made by 17th August, relist on 24th August for dismissal. 53.3. These are two different set of parties. At Domaraju Subramaniam, there is a Talkavari house building.
Well, as I beg to appear in this matter, one of these matters has been settled. My junior will place on record the settlement.
Yes,
deed,
the other side is sought for time to verify and make the submission if the DDs or checks have been received or not. We have passed
Certainly.
over 53.1.
Certainly.
Now, this Talkaveri and Domaraju matters are different people. It looks like the parties
They are
are
different, my lord. 53 has nothing to do
Why
with
is it
53.
connected?
I have no idea, my lords.
They only informed.
D-Link 53 and 53.3 and connect with
WP 198.
so and so. 53.3, 2 weeks' time is granted to comply with the office objection. If compliance is not made by next date of hearing, petition would be liable to it is not made by 17th August, relist on 24th for dismissal.
Well, as interim orders may be continued in both matters 1 and 2.
No, we are passing it over, 53.1 and 53.2. 53.1, 53.2 pass over.
Please.
Much obliged.
ಯಾವುದು? ಬರ್ಲಿ ನೋಡಿ.
54.
So Prashant?
Prashant R.
Lords, I'm for petitioner, my lords.
Yes.
This is a case against, this is about dispossession of myself from a shared household without following.
Can't hear you well, Mr. Prashant. Could you be little loud?
My lords, I'm petitioner. So I've been dispossessed from my shared household without following due process of law, my lords.
You're asking for a mandamus to execute an order.
Please, my lord, the point is, my lords, in the sessions court, there was an order to the police to put me back in the possession. And I have approached this honorable court in the last time wherein, this honorable court also directed the police to put her back in the possession if she was living there earlier. So the police has given a report stating to this honorable court that she was living in the present household, my lord. Last time my lords asked me to make the submission, but there was no time. So this time I am ready to make the submissions, my lords.
So there was a direction which had been issued to the jurisdictional police on 7/4/26.
Please, my lord.
Two reports. One is before the appellate court below, another one is before this court. And this property, my lord, as per the report, my client has sold this property to third party. Now third party is in possession. Now, my lord, they are seeking an order against a third party without making him as a party. But they have only produced, my lord, the selling.
You have sold the property.
Yes, sir.
When did you sell the property?
Sell, my lord, it's in the month of March. They are saying that, my lord, they are in house, but my client is saying that, no, she was not in house.
Who are you?
I'm the husband, my lord.
You are the husband.
She is also an employee. My client is also an employee. Between them, my lord, there multiple cases are pending, both in Bangalore as well as in Patna court.
Now this property has been sold to Uma KB.
Yes.
Please, my lord. I was dispossessed when I was inside the house, my lord. I just came out for attending one of the cases which I am fighting with my husband. And when I went back, to my surprise, the door lock was opened and someone else was sitting inside.
Now this Uma KB is related to your husband?
Not really, my lord.
Third
No,
party.
my lord.
My client is from Patna, my lord.
My lords, I'll just make submissions, my lord. My lords may decide the case on the merits, my lord. Please, my lord.
Yes, please go ahead.
Please, my lord. So, my lord, I married respondent number 4 on 12/6/2022. Page number 24, my lords. It's on 12th June 2022. I married to him. Then it was. I'm also earning, lady, my lord. I've been earning well. So there was constant demand from my husband to give me the money, my lord. So he was asking money for everything from me. My lord, I request my lords to look at page number 28, wherein I have attached my bank statement. My lords, in that row 6, row 4, 6, if you look at my lord, it says I have transferred 1 lakh to him. And again on 11/9/2023, I have transferred 3 lakhs. These are some of the samples, my lord. He understood that, I'm earning well, and he constantly kept on, forcing me to give the money. So this is one thing, my lord. And after, a certain point in time, I have refused to give him the money. That is when all these problems started happening, my lord. So on 24/1/2024, that is in page number 62, my lord.
Yes.
My husband files a case in the Subramanyapura police station, stating ದೂರುದಾರರ ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ನೀಡಿದ ಸಾರಾಂಶವೇನೆಂದರೆ 12/6/22 ಮದುವೆಯಾಗಿದೆ. ತದನಂತರ ಹೆಂಡತಿ ನನ್ನ ಜೊತೆ ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ಪ್ರತಿದಿನ ಸಣ್ಣ ಪುಟ್ಟ ವಿಚಾರಗಳೊಂದಿಗೆ ನನ್ನೊಂದಿಗೆ ನನ್ನ ತಂದೆ ತಾಯಿ ಜೊತೆ ಜಗಳ ಮಾಡುತ್ತಿದ್ದು, ವಯಸ್ಸಾದ ನನ್ನ ತಂದೆ ತಾಯಿಯನ್ನು ನೋಡಿಕೊಳ್ಳಲು ತೊಂದರೆ ಕೊಡುತ್ತಿದ್ದು, ಅವರನ್ನು ಠಾಣೆಗೆ ಕರೆಸಿ ತಿಳುವಳಿಕೆ ನೀಡಬೇಕೆಂದು there is a complaint given against me. This complaint is basically because I've stopped giving him money, my lords. So after that, my lords, my husband files a divorce petition, my lord, in which he himself says I am living in this household for which I have filed this particular petition, my lord. This is in page number 70. So in the cause title, my lord, this is in MC 864/2024, the divorce case filed by the petitioner. He says, between Kunal Anjani Kumar, he resides in Singapore Gardens, and that is in Serenity near Singapore Gardens. And my address is pleaded as Asmita Kumari, daughter of Arvinda Kumar, wife of Kunal, age 30 years, residing at flat number 311, third floor, DS Max Sista, Uttarahalli, Bangalore 6061. So this is filed on 15/4/2024 by my husband, my lord. This is in page number 68. After this, my lord, I pray my lords to look at page number 86, wherein I have, after filing this divorce petition, my lords, he left the house. He didn't come back. He stayed in the address which is given in the divorce petition. But he was troubling me, my lord. He was all the way troubling me. So I went to the police station and I requested them to help me in this case, my lord. So, my lord, if I can request my lord to look at page number 96, I just want to highlight only one problem, my lord, because otherwise it is going to be never ending, my lord. Page number 96, it says, ninth row, my lord. ಸದರಿ ಮನೆಯಲ್ಲಿ ವಾಸವಿರುವ ಶ್ರೀ ಅಸ್ಮಿತಾ ಕುಮಾರಿರವರು ಸರ್ವಿಸ್ ಸ್ಟೇಷನ್ ನಂಬರ್ಗೆ ಕರೆ ಮಾಡಿ ಅವರ ಪತಿರವರು ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ವಿದ್ಯುತ್ ನಿಲುಗಡೆ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಸೊ ಈ ತರ ಎಲ್ಲ ತೊಂದರೆ ಕೊಡಕ್ಕೆ ಶುರು ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. So, my lords, if I can request my lord to look at page number 97, ಇಲ್ಲಿ ಇವರು ಆಫೀಸರ್ ಬರೀತಾರೆ.
The issue is different. The issue is that he has sold it to somebody else.
ಅಲ್ಲ, I just want to highlight the troubles he was giving me.
He sold it to somebody else who is not his relative, who is not. It's not a transaction where there is any collusion.
Please.
That's why we asked you. It's third party. That third party is in possession of this apartment. Now you are asking to be put in possession of the apartment as a shared household. When the property is sold to a third party who you have not made a party, how can we pass that order?
My lords, here what has happened is, I did not know about this sale at all. I went to my house, my lord, where I was staying, which is called shared household. To my surprise, I see someone else is sitting. That is the time when he is saying, I have sold the flat.
Except that it is like overnight it will happen, or you went out and you came back and somebody else was there. It doesn't happen just like that.
It has happened, my lord. I have a proof.
Assuming it has happened like that, now it's a third party who is in possession of the premises.
Please, my lord.
We cannot pass any order against that person or that property without that person being a party, number one. Number two, even if you make them a party, you will have to show us in law as to how an order could be passed against such third party. We can pass an order against the husband, against the father,
Please,
against the father-in-law, mother-in-law, yes.
Please, my lord.
But how against a third party?
My lords, this issue in front of my lordship is, she was dispossessed without following.
You'll have to show us the law on the point, not your oral submissions only. It can't be on a oral submission.
My lords, I have case law, my lord. I am.
Yes. Pass over. We'll come back.
Yes.
Submission, my lord. There's one urgency. The matter was supposed to be listed before my lord. Since there was some objection, I had written my submission. Submissions have been overruled. May I request for tomorrow, my lord? Because day after tomorrow.
If compliance is made tomorrow.
Please. Seal number 16.
Sale number?
16.
16. Yes.
Necessary application to complete the bank.
So.
The name. One accommodation may be granted once I file application to complete the bank.
You want time? 16. Learned counsel for the petition seeks fund is granted.
1 week.
A week's time to file necessary application to implement the concerned bank. Released on 19th August.
Serial number 33, my lords. The bank details to furnish. Serial number 33, my lords.
Yes.
It is not Canara Bank, but rather, my lords, it's a cooperative society bank.
You
If
said
it's Canara Bank, my lords, would reflect my entries. As with regard to the deposit which is made, my lords, it's a cooperative society bank, my lords. Canara Bank is fine, my lords, but I think we'll have to also summon the cooperative society bank.
You're transferred it to which bank?
Cooperative society, Bangalore District Central Cooperative Bank, my lords. Yelahanka.
Standing counsel error either. So and so is brought on record. So and so is directed accept notice. to produce ಆಗ್ಲೇ ಏನ್ ಹೇಳಿದ್ವು ಅದೇ ಸೇಮ್ ಥಿಂಗ್ ಬರುತ್ತೆ.
Much
ಸೀಲ್ ಕವರ್.
ಹೇಳ್ಬಿಡ್ತೀನಿ ನೀವೇ ಅದು.
ಆಮೇಲೆ ಹೇಳ್ಬೋದಾ?
ಅವ್ರ ಹತ್ರನೇ ಮೆಮೊ
ಅಲ್ಲ,
ಕೊಡಿ.
ಆರ್ಡರ್
Office
ಒಂಚೂರು
objections are complied ಅಂತ ಬರೀ.
62.
ಅಲ್ಲ ಅವ್ರಿಗೆ
Sir,
ಮೆಮೊ
memo.
ಯಾರೋ ಕೊಟ್ಟಿರಲ್ಲ.
Yes.
ಅಲ್ಲ ಅವ್ರು ಕೊಡಿ ಅದಂತ.
ಒಂದು ಲಿಬರ್ಟಿ ಕೇಳಿ, ಲಿಬರ್ಟಿ ಕೊಟ್ಟಲ್ವಾ? ಡೈರೆಕ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕನ್ಸಿಡರ್ ದ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತ ಅಷ್ಟೇ. ಅದನ್ನ ಕೇಳೋಣ ಅಂತ. ಅವಷ್ಟೇನೋ.
ಹೌದೇನು ನೋಡ್ಕೊಡ್ತಾರೆ ಈ ಫಾರೆಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ರೆ
ಒಂದೇ ಒಂದು ನಿಮಿಷ. ಬ್ಯಾಂಗ್ಳೂರ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಎನ್ ಶಿವಕುಮಾರ್. ಎನ್ ಶಿವಕುಮಾರ್. ಸರಿ, ಎನ್ ಶಿವಕುಮಾರ್. ಇಲ್ಲ ಇವತ್ತು.
But continuation.
ಆಮೇಲೆ ಪಾಸ್ಟ್ ಅವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ನಾನೇನ್ ಮಾಡ್ಲಿ ಇದಕ್ಕೆ? ನಾನ್ ಸೀರಿಯಲ್ ಆಗೇ ಕರೆಯೋದು. 53 ಪಾಸ್ ಅವ್ರು ಮಧ್ಯಾಹ್ನ. ಮಧ್ಯಾಹ್ನ ಗೊತ್ತಿಲ್ಲ ನಂಗೆ. 73 ಇದೆ ಸರ್, ಇದೆ. ಅದ್ ನೆನ್ನೆನೆ ಬರ್ಬೇಕಿತ್ತು, ಇವತ್ತು ಇಷ್ಟ ಇದೆ. 4 ಗಂಟೆ ಮೇಲೆ. ನಾನು ಯಾಕೆ ಮಾಡಿ ಫೋನು? ನನಗೆ ಇಷ್ಟ ಆಗಿದ್ ಕೇಸ್ ಅಷ್ಟೇ ಕರಿತೀನಿ ನಾನು. ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರು? ಮಧ್ಯಾಹ್ನ ಇದೆ ಸರ್ ಅದು. ಮಧ್ಯಾಹ್ನ ಇವತ್ತು ರೀಚ್ ಆಗುತ್ತೆ ಇವತ್ತು. 85 ಇದೆ. ಮಧ್ಯಾಹ್ನ 4 ಗಂಟೆ ಆಗ್ಬೇಕು.
73 2:30 ಬರ್ತಾ ಇತ್ತು ಮ್ಯಾಮ್. ಅದು ನಾರ್ಮಲ್ ಲಿಸ್ಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
73 ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಲ್ಲ, ನೆನ್ನೆ ಬಂದಿರ್ಲಿಲ್ಲ, ಇವತ್ತು ಬಂದಿದೆ.
ಅದೇ ಅದು 2:30 ಇತ್ತಲ್ಲ, ಅದಕ್ಕೆ
ಮಾಡಿ ಸಬ್ಮಿಷನ್. ಅಲ್ಲಮ್ಮ, ನೀವು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಮೆಮೊ ಕೊಟ್ರಿ. ನಿಮ್ ಮೆಮೊ ನಾವು ಕಳ್ಸಿದೀವಿ. ಲಿಸ್ಟ್ ಮಾಡೋದು ಬಿಡೋದು ಅವ್ರಿಗೆ ಬಿಟ್ಟಿದ್. ನಾನ್ ಯಾಕೆ ಹೇಳ್ಬೇಕು ಅವ್ರಿಗೆ? ಇವತ್ತು 200 ಕೇಸ್ ಲಿಸ್ಟ್ ಆಗಿದೆ. 200 ಫೋನ್ ಮಾಡ್ತೀನಿ ನಾನು ದಿನಾಗ್ಲೂ, ಇಲ್ಲಾಂದ್ರೆ ಲಿಸ್ಟ್ ಆಗೋದೇ ಇಲ್ಲ. ನಾನ್ ಫೋನ್ ಮಾಡಲ್ಲಪ್ಪ. ನಾನು ಫೋನ್ ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ ಊಟ ಮಾಡಕ್ಕಾಗಲ್ಲ ನಾನು.
Attempt to murder was made on the advocate, my lords. Till today, there was no action taken by the respondent police, my lords.
When was it?
On 9/7, my lords, FIR was registered.
Tomorrow.
Please, my lords.
Request, Your Lordship. Serial number 90, Your Lordship, may be taken at least at the end of the list, Your Lordship. It's for.
If it reaches, it will be taken up, madam.
Pertaining to external proceedings, wherein the petitioner is age old 72 years. No cases since 2013.
Petitioner is age 72. 72 and extend. You extend a 72-year-old person.
72, since 2013, no cases. Tomorrow.
Tomorrow. Serve a copy. Yes.
See, number 50, matter is disposed. So that I want that a liberty as court has given to give a representation to the deputy commissioner. See, number 50.
Representation will not be of any value. There's already an award passed. You have to challenge that.
Oh, that is.
ಅದಿರೋವರೆಗೂ ನಿಮ್ಗೆ ಏನು ಸಿಗಲ್ಲ. Follow the procedure. Get it enhancement ಗೆ file ಮಾಡಿ.
Enhancement of the before the.
Enhancement ಗೆ file ಮಾಡಿ.
Yes.
Yes, madam.
Serial number 71, my lord.
Hmm.
This matter was filed to finalize the tender process as though letter of intent was issued, work order was not issued. Now work order is issued by RGOH.
So what do you want to do?
It will stand disposed of since work order is issued. I'm placing the work order.
One memo has been filed. Accepting the memo, petition stands disposed.
Please, oblige.
230 matters. Number 2, serial number 1. Yes, Sergeant Reddy.
This mistake is. Really.
When this order was passed, my lord, my main ground on which, my lord, I had.
You won't get the backside property. That much.
Sure.
That you are sure, Alva.
No, my lord, I will make only 2 minutes submission, my lord.
If you succeed, you will get everything.
Please, my lord.
If you fail, you won't get the backside property.
Please, my lord.
Because we'll direct them.
No, they say that front and backside. My property is in middle is what they say, my lord.
We'll direct them not to consider your application. Because you have tried to, if you succeed, fine. If you don't, yes.
My submission is this, my lord. In counter affidavit, my lord, along with which I filed. Annexure R3 is the order passed by this honorable court, which is in review.
Yes.
Now, Lord, this order was passed on the ground that, my lord, we had produced one sketch before this honorable court, which now they say that it is not a part of the allotment letter, what is there. Other than this also, my lord, my writ petition is there. Kindly take, my lord.
For the writ petition,
page number 31. Alla petition copy no hakidine adar jotege affidavit jotege.
Page 31.
Page number 31. There were other grounds also. Para number 26 and 27, my lord, where I had claimed that in the boundary, if it is calculated, it comes that much measurement. And not this 40-60 boundary is one of the contention, my lord. In support of that, now they have the other document that I have is in the original, my lord, original file that they have produced. There is a approved layout plan approved by the case IDC itself. Clearly, my lord, the principles of estoppel is applicable.
Not
While this honorable court passed an order,
allotment made was only for 60-40. It remains at 60-40. You cannot claim more than that.
when this honorable court passed an order, at that point of time, KSIDC did not take up any of these contentions contrary to my stand. Now, in the review petition, my lord, there is a change in circumstances.
Yes.
In KSIDC,
we had only directed to consider as a mandamus. And when people come to the court misleading, we'll need to handle that. That
all
was misled before them, that you went to the corporation and sought for the khata, misleading the corporation.
I have not misled, my lord.
That is why they came up.
Going to the extent of filing a contempt petition also against the BBMP.
I am not coming, my lord, in the way of allowing the review.
You cannot come in the way of anything. We'll
review petition, but
deal with you.
But, my lord, all I am asking, my lord, before this honorable court, that even if this review petition is allowed, because of the stand now the KSIDC has taken, my petitions, my lord, what I had filed the petition, there are additional documents, my lord, which now it has come on record before this honorable court. Those documents, along with other sale deeds where, my lord, the adjacent landowners, everyone in this entire scheme that is layout which is formed by the KSIDC.
They had paid that amounts, and that is why it has been done. You wanted to get something free of cost, which is not acceptable.
Insofar as my contention is concerned, I am a subsequent purchaser, auction purchaser. KSIDC filed objection before the executing court, filed an objector application. That objector application came to be rejected. Detailed order is passed regarding that, saying that their contention was that sale deed is not executed in favor of the borrower. That's why that property cannot be auctioned.
Different reason altogether. That's a different reason altogether. Now we are concerned with the measurement and the extent.
If an opportunity is given to me in to establish that aspect.
Any more opportunities you want, Mr. Shetty? We have given you 4, 5 every
I'm
time
not
that you have been
saying-
seeking time.
I'm not saying opportunity is not in the sense, my lord, here. In the review petition, my lord.
Not for a dishonest litigant.
Lord,
Sorry.
then, my lord, I may be permitted to.
Sorry, we gave you the option.
No,
You
my lord,
want
I'm
to
not asking for a time.
argue. If you argue, we'll pass our orders. If you are acceptable, fine. You argued. Then you will have to face the consequences.
My submission is review petition. I am not coming the way, my lord. All I'm asking is that in writ petition, my lord, an opportunity be given to me to produce the additional documents. These documents.
Be dismissing your writ petition by allowing the review petition, by imposing costs and directing them not to look into it. They made a concession. That's why we told you they are making a concession. You want to accept the concession. No, you did not want to accept the concession by making payment. You wanted it again free. You took time to confer with your client, get instructions. Even after that, you came back saying, no, I want the entire thing without payment.
I have paid
That's
14 lakh
dishonest.
rupees, my lord, for this.
Lord.
Lord,
Petitioner is before this court.
Lord, two
Seeking-
submissions, Lord.
Yes.
After that, my lord, if that is.
We'll deal with all your submission, any submission you make.
Lord, my contention is before this honorable court, my lord, that the entire extent, what they had allotted to me, what was allotted in favor of the allottee. As per the allotment letter itself, my lord, what is there? 40 into 60 was the 40 into 62 was the
But you
area of the
already
shed.
argued. Any additional thing you can argue.
The additional argument, my lord, other than it, only 3 points, my lord, I want to place.
One is 40 into 60, boundaries.
Boundaries, the measurement comes to the entire extent.
Yes.
And
One.
so far as in support of my contention that what I have been put in possession, what not the auction purchaser, not just the auction purchaser, my lord, what the original allottee was himself was put in possession was not just 14 to 62.
There is
but
nothing on record for that. They have denied it. They have documents otherwise.
no, my lord, my content, the original allottee was put into possession of the entire extent and not just 14 to 62 shed. My condition is 14 to 62 is the shed which they had constructed and given it to the original allottee. Along with that, there was an adjacent land on the northern side and the southern side of the property. Because two sides roads will come, my lord. Their contention is in between what property shed is there. Only that much we had allotted. Towards the northern side and towards the southern side, where one side road is there and another side another property comes. That portion of the property we had not allotted is their contention. Against that contention, Lord, towards that contention. Kindly take, my lord, in the original documents that they have.
You've seen it already thrice. Why are you repeating things?
Only that one sketch. I am relying on that sketch is what I am saying. Approved layout plan of 1991. which is approved not by the BBMP or some other.
Kodi madam file kodi. ನಿಮ್ ಜೊತೆ ಇನ್ನೊಂದ್ಸತಿ ನೋಡಿ.
ಅದೊಂದೇ it is
ಸತಿ ತೋರಿಸಿ ಆಯ್ತು.
my
ಯಾವ್ದು ನೋಡ್ಬೇಕಪ್ಪ?
my lord, that sketch, if it is seen, my lord.
Sketch or plan sanction?
Plan sanction, that is the plan sanction.
Yes.
The plan sanction is for the entire extent.
No. Yes. Nearly.
Lord, the plan sanction, if in 1992, it is approved by the KSSIDC. Much before I purchased the property in the auction.
Yes.
In the plan sanction, kindly take, my lord, the overall extent what is mentioned. Shed being 71, it comes in between. Proposed extension of the property.
Yes.
Certain portion proposed extension is there, my lord. Thereafter, there is an existing toilet and washman shed. And on the other side, on the other hand, that is on the southern side, there is an open yard next to the road. If allotment letter is seen, the boundaries what is mentioned there and boundaries what mentioned here matches. Now the contention of KSIDC is in between the shed number B71 what is written. Only that much is allotted. On the northern side, the proposed extension what was given to my predecessor, that is not allotted to him, but what they have approved. There is a compound wall also, my lord, surrounding the entire property, approved by them only in 1992. And open yard, what they say, my lord, towards the road, that portion is also not allotted, is what their contention is. That is my second contention. The third, my lord, insofar as the auction purchase is concerned, they had filed objection regarding the execution of sale deed itself, annexure R7, page 82, in the executing, before the execution court. Execution court dismissed their objector application that attained finality, against which they have not filed any appeal or anything. On these three grounds, my lord, I am.
These three grounds you argued 5 times.
Apologies, no.
Don't waste the time of the court. When people are waiting, you are entitled to make any additional submissions. Please consider it.
Only these 3 points.
But if you do like this, it is not fair on the other counsel.
Only these 3 points.
The other counsels have heard you. Some of them have heard you 5 times also, including the government advocates. Don't do these kind of things. Petitioner, BBMP is before this court seeking for the following reliefs. The BBMP is seeking for review of the order dated 8/12/23, passed in WP number 12210 of 23. WP 12210 of 23 had been filed by respondent number 1, seeking for quashing of endorsement issued by the BBMP, denying the issuance of kata on the ground that the document which had been submitted indicated a lesser extent of land which had been allotted by Karnataka State Small Industries Development Corporation, bracket KSS IDC, to one Mrs. Rana Enterprises. And the documents did not disclose the extent of land to be 524.66 square meters, when the allotment made was 290. Na? What was the allotment made, madam? Give us that 5. 40 into 62 is in square meters, yes, to square.
200.
290 or something.
It comes to 230 square meters.
230 square meters.
Was 2,000?
2,480 square feet.
480 square feet, bracket 40 into 62 feet, and 230 square meters. along with the papers which had been produced by the respondent, by the petitioner in that writ petition, a sketch had been appended to a lease cum sale agreement executed in favor of Rana Enterprises, detailing the property to be to measure north to south 34.95 meters, east to west 12.75 meters, total area being 445.61 square meters. It is in that background that this court, by the aforesaid order, had directed the BBMP to consider the application of the petitioner in terms of the certificate of sale and the boundaries mentioned as per the sketch appended to the lease cum sale agreement and the certificate of sale. When the submission of Sri Mallikarjun Reddy, learned counsel for the petitioner, BBMP, is that on verification document, there is no such sketch which had ever been appended to a lease cum sale agreement
Or to the certificate of sale.
or to the sale certificate. The sale certificate, the petitioner in the writ petition has fraudulently enclosed a sketch along with the said document as if to contend that the entire property was subject matter of the lease cum sale agreement. And on that basis, it was contended that the petitioner in the writ petition has obtained an order from this court by playing fraud, suggesting false facts, requiring this court to review the order, recall the order, and take such action as may be deemed fit in the matter. It is in that background that the KSIIDC was called upon to place on record the file, original file relating to the allotment. A perusal of the original file indicates a copy of the deed of lease
From 176, your lordship, relevant portion on 166 page number.
under hire purchase scheme made on 18 November 1982 between the Governor of Karnataka as a licensor and Mrs. Rana Enterprises as a licensee. The plot is being clearly defined as B71, Industrial Estate, Pinya First Stage, Bangalore 58. The schedule indicates factory building number B71, situated in Industrial Estate, Pinya First Stage, measuring 40 feet, measuring east to west 40 feet and north to south 62 feet. There is no sketch which is appended to the said lease deed of lease under hire purchase scheme. A plan is also found in the said file relating to the aforesaid property, which indicates that the said plan was sanctioned on 16/11/1991 and relates to a shed in the said plot bearing B71. With the full details of the said shed. On the basis of the said documents, learned counsel for respond number 2 makes a categorical submission that it is only plot measuring 40 by 62, which had been allotted to Mr. Rana Enterprises. Subsequently, the petitioner, as regards which there was no sketch appended. The sketch which was appended to the lease is not part of the records of the KSIDC. Hence, Ms. Manjula Tejasvi, Learned Counsel for KSIDC, also supports the submission of Sri Mallikarjun Reddy, Learned Counsel for the BBMP, and submit that due to suppression, due to suggestion of false facts, the order having been passed, this court ought to exercise its powers under Order 47 for review of the order. Sri Rakesh Shetty, Learned Counsel for the auction purchaser petitioner in the writ petition, firstly submits that the allotment which has been made to Rana Enterprises, firstly submits that the petitioner is a purchaser in an auction and not the original allottee. It is the plot number B71 which had been brought for auction. Where is the auction notification?
Auction notification is not.
It's not part of the records.
Court auction.
We had asked you to produce the auction notification. Where is the auction?
Court. No, auction, court auction, my lord, is what?
Court auction notification iratallappa. What is being sold and
That schedule is there, same schedule, my lord. What allotment schedule, same schedule is.
and measurement is also there.
Measurement same, that is only.
That is why we asked you to produce it so that we could record that also. Idea ilva? We'll have to say you did not produce despite being asked upon.
Auction,
Purchase and auction. Though he had been called upon to place the auction notification, the said auction notification has not been brought on record. But our submission is made that the auction notification had the very same schedule as that under the deed of
sales certificate.
lease under hire purchase scheme.
Schedule of the sales certificate, my lord.
Auction notification.
It is sales certificate, same, my lord. Same as the allotment.
This is not the same.
Measurement is, they have not, measurement same, they have.
ಇದು ಬೇರೆ page ಅಲ್ಲಿ ಇದೆ.
Auction sales certificate.
But he refers to the auction sale certificate where the schedule is mentioned as under. Schedule 1. Is it part of this records? Schedule 1, page 32, 34, 36. Sorry, added line. And as such, he submits that the petitioner being a writ petitioner being a bona fide purchaser for value in an auction, there cannot be any malafide attributed to the writ petitioner. His submission, by referring to the schedule to the deed of lease under hire purchase scheme, is that the boundaries would prevail over the measurement, inasmuch as the boundaries have been indicated as bounded on north by B-type factory, south by Second Cross Road, east by shed number B72, and west by Cross Road. And thus he submits that there is no open space which has been shown to be existent on the which side is north?
North and south.
On the northwest of the property. Therefore, he submits that the entire property within the said boundaries are covered under the lease and as also under the sale. His submission is also that Rana Enterprises had been put in possession of the entire property, including the portion on the northwestern side. And as such, the sale which has occurred is as regard the entire property. The submission of learned counsel for respondent as regards boundaries prevailing over measurement at first blush appears to be inviting. However, this would have to be considered, taking into consideration the other documents which are available on record. Firstly, the petitioner is a third party who has come into the picture subsequently in the auction. It is rather strange that a submission is made by the auction purchaser that Rana Enterprises had been put into possession over the entire property when the petitioner was not at all in the picture at that time. The verification of the area can only be done by reference to the auction notification. Though the auction notification has not been produced, the boundaries to the sale certificate has been placed on record. The sale certificate would only indicate that the factory building B71 is bounded on north by B-type property, south by second cross, east by shed number B72 and west by crossroad, and clearly indicates, even at the time of the auction and the sale, that the area is 40 into 62 feet. If at all Rana Enterprises had been granted possession over the entire property, that entire extent would have been mentioned in the sale certificate. The sale certificate at an undisputed point of time provides the measurement of 40 into 62 feet. Insofar as the plan sanction is concerned, the plan sanction speaks of the plan of the existing of the shed in plot number B71 and earmarks an area for proposed extension. Though a earmarking is made for proposed extension, there is no plan sanction in the proposed extension. It has only been etched in the said plan. Thus, the said plan cannot inure to the benefit of the auction purchaser, inasmuch as, even as per the said plan, the KSIDC has not sanctioned any plan in respect of the disputed area. What remains also to be considered is a sketch which has been produced by the auction purchaser. The origin of the said sketch has not been explained except to state that it was part of the sale certificate which has been issued. When there is no such sketch appended to the lease, the question of preparation of a different sketch with a different measurement, which is contrary to the contents of the deed of lease under hire purchase scheme, cannot be countenanced in law. The last submission which has been made by Mr. Rakesh Shetty is that the KSIDC, having opposed the execution of a sale deed in the execution proceedings file and their application having been dismissed, cannot now re-agitate the issue before this court. A perusal of the papers indicates that the opposition on part of the KSIDC in the execution proceedings was not as regard the extent of land, but on the ground that there was no sale deed which had been executed in favor of Rana Enterprises, only a lease having been, only a license having been executed. Rana Enterprises could not have, on default of Rana Enterprises, the said property could not have been brought for sale. That again does not inure to the benefit of the auction purchaser, inasmuch as the issue in the present petition is different from that in the execution petition. In view of all the above factors, it is clear that the writ petitioner had approached this court not only by suppressing facts, but by suggesting false facts, by producing a document which was never in existence. The sale having occurred only for 40 into 62 feet, the writ petitioner seeks to assert a right over a larger portion of the property by making use of an order passed by this court obtained on such suppression, which also resulted in a contempt petition being filed against the BBMP, which woke up the BBMP to these facts and for the BBMP to approach this court. Since the order would require the BBMP to do and perform an action which is not authorized under law. Taking into consideration all the above facts, the submission of the submission of Ms. Manjula Tejasvi is, in on the last submission. One other submission made by Sri Rakesh Shetty is that as regards other plots also, the said portion situated on the backside of the property, a plot allotted, has been conveyed to the allottee. Ms. Manjula Tejasvi, on instructions, submit that conveyance had occurred on payment of the due allotment value for the remaining extent of land. The remaining extent of land having an alternate access, it could have been allotted to a third party, since even as per the schedule to the page 76. Schedule to the deed of lease and hire purchase indicates that on the west there is a crossroad which is an access to the back portion. Though a concession was made by Ms. Manjula Tejasvi that even if the writ petitioner were willing to make payment of the due amounts, the KSIDC would transfer the said land, allot the said remaining land, would consider the allotment of the remaining land. The same was not acceptable to the council, to the writ petitioner, inasmuch as the writ petitioner continued to contend that the entire property having been allotted, there was no requirement for making payment of any further amounts. Last, in that view of the matter, this court passes the following order. Review petition is allowed. The order dated 8 December 23 in WP number 12210 of 2023 stands recalled. Writ petition WP number 12210 of 2023 stands dismissed by imposing cost of rupees ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು 45 lakhs ಕೊಟ್ಟಿದ್ರಾ
14 lakh my lord in 2002 my lord.
That is for half of the property, so you wanted the other half free. Cost of rupees 5 lakhs payable to the Karnataka State Legal Service Authority within a period of 4 weeks from the date of receipt of a copy of this order.
5 lakh.
If the payment is not made by 31st August 2026, the member secretary would be entitled, member secretary KSLSA would be entitled to recover the said cost as arrears of land revenue from the writ petitioner. The concession which had been made by the KSIDC not having been accepted by the writ petitioner, KSIDC would be free to allot the said land to any third party by inviting necessary applications.
In that view of the matter, may I am not sure.
Hmm?
Khata may be entered regarding that extra place in favor of.
If an application is made by KSIDC to the BBMP for entry of the Khata in the name of KSADC as regard the said land, BBMP is direct consider the same and pass necessary orders.
As far as cost,
We told you, your case is false and theater and you killed.
client,
There is a delay in
Delay is controlled.
414 days.
cost, my lord.
The application for delay of 414 days has been filed. The submission of Sri Mallikarjun Reddy, KS and counsel for the petitioner, is that the delay was occasioned on account of the petitioner not being aware of the facts of the matter. The facts came to light only on a contempt petition being filed, and thereafter the review petition is being filed. Accepting the said submission, the delay of 414 days is condoned.
Cost published.
ಎಷ್ಟು ಮಾಡ್ಬೇಕು?
5 lakhs.
ಎಷ್ಟು ಮಾಡ್ಬೇಕು ಹೇಳಿ? ನಿಮ್ seeks for reduction to so and so, we reduce it to that much.
Kindly reduce the cost.
Yes, next.
Serial number 2,
And
HIS,
my lord,
14%.
in the order, my lord, Rakesh Shetty is type, Rakesh Bhatt, my lord.
Rakesh Bhatt, sorry. Sorry.
May I collect the file?
The original file is returned back to Ms. Manjula Tejasvi.
Serial number 2, Satish IS, 14%.
My lord, the Tahsildar was supposed to give those documents. Tahsildar was present on VC on the last day. Can I just take your lordships to page 29 of the writ petition for a moment? Annexure F. This is his RTI application. Point number 3, my lord, in between that, my lord, provide all
29.
documents.
Page 29.
Page 29 of the writ petition.
Yes.
My copy, my lord, page 29, Form A, if your lordship finds it. Page 30, page 36, my lord. My copy is incorrectly numbered. Page 36, Annexure F.
Page 36?
Yes. Is that correct, my lord?
Form A, yes.
Form A, my lord. In the middle, my lord, it says, provide all documents obtained, communicated, processed regarding the above application in Taluk Office of Koppa and Deputy Commissioner's Office of Harapura, internal communications, notices, survey department sketches, reports, notices, Kata Mahaza reports, witnesses, reports, communication and other governmental documents regarding this, etc. Time period, my lord, is from 2018 till date. First of all, my lord, what the backdrop of this application is, my lord, that he claims that his uncle, one Ganesh, my
Why is
lord,
that
makes an
relevant? There's an
application
order
to
passed
the.
by the KIC.
I understand.
Which
It's
is
already
attained
adjudicated.
It's attained
Your
certain finality. I won't say anything.
Two competent authorities have been adjudicated with all the necessary commissioner's
disputing
orders.
that.
It all been
One
recorded.
What is your submission?
My
Wasting
submission.
the time of your
My
honor-
submission is, my lord.
honorable court time is there.
If the Tahsildar, my lord, has not got an opportunity to present himself. Second is, my lord, this is in the backdrop of, my lord, an application made by his so-called uncle, my lord, one SS Ganesh Murthy, says, my lord, that documents are destroyed in a particular survey number, my lord, which is survey number 98. Now, my lord, thereafter, after this application was made, my lord, the deputy commissioner would be the competent authority.
Is being directed to recreate.
Assistant commissioner
Recreate
is
the
the
documents, yes.
hierarchy in the.
If an application is made now to the Tahsildar, Tahsildar either should have, my lord, forwarded it to the deputy commissioner, who is the appropriate authority, to, my lord, give these documents.
Where is the application made to the Tahsildar?
The application is made to the Tahsildar, my lord, it's not made to the deputy commissioner.
After 9 years, they are telling.
This is not something that you can raise now.
No, I'm not saying this.
They have not disputed it.
Just a moment, please. Don't be interrupting every minute.
All I'm saying is, my lord, now before the first appellate authority as well as, my lord, the commission, the Tahsildar was made a party.
If you are going to give the papers in a week's time, we'll
My
give
lord,
you a week's
these
time.
are the only documents that I have. I'll place them, my lord. I have the ILRR, my lord, as well as the Ketawar register, my lord, and
Whatever you have,
RTCs.
you give it to him,
I'll
let him
place it.
examine it.
I'll
If
hand
it is
this over.
found to be short, then we'll again take action.
It is short, my lord. This is all the documents that I have.
We are supposed to recreate as per the order. That attained finality.
That, my lord, the
We
deputy
are
commissioner.
virtually in executing court now for
Your
this.
I
Honor,
understand.
we are asking for mandamus from this, for two authorities.
You want the papers, Ashtitane. You
Yes,
want the
sir, but
documents.
they have destroyed or hiding it from last 9 years, Your Honor.
We'll try
They
and
are
get
95
you.
years,
Wait,
legal
Mr.
heirs, Your Honor.
Satisha, wait. Please don't interrupt in between, then you may lose what you are getting. Please wait.
I understand, my lord.
So
Sir
when
is
the
a-
court is with you.
I understand, my lord, the sir is a party in person. Could I just get 2 days' time? I'll ask the Tahsildar to come with the entire records before this court, my lord, and let him examine whatever he wants. And if there's anything that he wants to do, we'll photocopy it, attest it, and give it to him. If it is found. Now, our cases, my lord, these documents
It is not
are
a
not.
question of if it is found. The order is very clear. The order is directed to recreate from the well-known, from known sources within the office and furnish information. The order is very clear. You cannot still go back and say, I don't have it. Recreate until then.
They told last at the time of the commissioner's hearing, Your Honor. They have not disputed anything in the RT
According to
application.
me, the deputy commissioner has not started the process itself of recreating, is what I understand.
Assistant Commissioner has made the order to hand over the
There's no
soft
power, my
documents.
lord, to recreate a
7 days
record.
within us.
You want
Only
to
for the
take it
deputy
up with the
commissioner to
deputy
recreate.
commissioner, you want to take it up with the regional commissioner, you want to take it up with the principal.
Simply
secretary,
they are
you can
dragging
take-
without any reason, Your
The
Honor.
direction is to the Tahsildar.
I'll place the records, my lord. I'll place the
Under
records.
section 20, we'll initiate disciplinary proceedings.
I'll place the records on Monday, my lord.
We'll have it on
Yes.
Monday. If you don't give the papers,
Friday, my maximum Friday, Your Honor.
in Friday, in Murta Chanagidi out.
Stay.
Monday, if you don't give it, we'll initiate disciplinary proceedings under section 20.
Also, my
So
record.
it's a 22 order. You can't be sleeping over it for 4 years.
9 years, Your Honor. It's already been.
This order is 4 years. And AG seeks for and is granted 4 days time to place on record to furnish all the documents,
Also record, my lord, disciplinary proceedings because let them know the
all the documents to the petitioner, all available documents to the petitioner. Such a submission cannot be accepted in light of the order which had been passed by the State Information Commissioner, categorically directing the Tahsildar Koppa to recreate the file with known sources within the office and furnish information to the appellant. Once such a direction has been issued, the Tahsildar cannot be heard to say that he will only furnish the documents which are available. And AGS seeks for 4 days time, relist on 3rd July at 2:30 p.m., 3rd August at 2:30 p.m. It is made clear that if compliance is not made with the order of the KIC and that of this court,
FAS.
necessary proceedings would have to be initiated under necessary recommendation would have to be made under clause 2 of section 20 of the Right to Information Act. But that also doesn't answer. We'll have to find some other way of getting these papers.
This order be uploaded today, my lord.
They told that is lost, Your Honor, surprisingly. Then they ordered to
History
reconstruct
is
it, that
directed
they are
to
not.
hand deliver a copy of this order to the AG.
Much obliged.
Despite the earlier orders, the Tahsildar is not present today. If he is not present along with the entire file on the next date of hearing, necessary orders would
He
be.
was present on video conference on the last day.
Contempt is also there.
He was not present. First time he sent his deputy
She was
Tahsildar.
present on VC on the last date.
Second time, she said, I don't know anything.
That
Contempt
is
is always in person.
After appearing, she said, I don't know anything.
yeah, that I understand.
Third time, she is not appeared.
He'll be physically present on Monday.
Let her appear with the file she has to.
Yes, sir.
Much obliged.
Serial number 3, Praveen HP, unconnected matters.
Let's heard this matter for some time. The streamlining of the RERA applications and the orders.
My lord, my instructions are, my lord, we require a little bit of time, my lord, for the drop down.
Michael.
we require some time, my lord, regarding the drop down on the website, my lord. And now the authority is considering that, my lord. We are,
How long do you need? 1 day, 2 days?
at least 2 weeks, my lord. We require some time. my lord.
That is why we started with 1 day, 2 day, not that kind. See, the more you delay, more people will get into
Yes.
trouble. If it was something which has to be done beside, we understand.
Yes.
But each filing which is happening every day,
Yes.
there'll be an issue.
That's why, my lord, because of the large scale nature of it, my lord, all the even regarding the last query, my lord, which wherein if the both the case and counter case, if it happens in that form, whether it has to be now they're also discussing with the adjudicating officer, and they have to commit a conclusion, my lord.
The time is too much, Mr. God. We already have given you 2 weeks.
Yes.
Another 2 weeks is too much. We'll give you a week's time. Please do this fast.
Yes, my lord.
If the interest
My lord,
of
one judicial order may be given to us, my lord, so that
in judicial,
my lord, so that the officers will.
it is their job that they are
Try to
supposed to
summon
do.
them and then will not discuss. Otherwise, the order will not. It's a technical issue, so they should come and assist your lordship.
We did not want to record it because it will reflect very poorly on your organization.
I will just
Once we put it in writing, it is there.
regarding this aspect of case and counter case, my lord. Only that aspect I'm requesting.
We don't mind recording everything,
Not
but it reflects poorly on your
then, my
organization.
lord, I'll seek one more week, my lord. I will just.
Better you get it done that way so you can explain to them.
Yes, my lord.
If you want us to make an order, we'll make it.
My lord, I'll seek.
But some technical person can.
But after 1 week, don't tell us make an order.
I'll write it.
Want us to make an order, we'll make it today itself.
My lord, it may be in such a way that will.
Anything will reflect badly.
So that even the general public.
Errors which have been pointed out
Yes, my
could
lord.
not have been there.
Yes, my lord. I'll just place it.
My lord, one submission can I make? My lord? The issue what lordship has raised, my lord, has relevance. But insofar as the present case is concerned, my lord, at the first instance, when we uploaded the complaint, section 18 was invoked, my lord. It says refund. Thereafter, my lord, both the parties were notified by the authority. Both of us have appeared. Before the authorities, my lord, that is the commencement of the proceedings. We have been asked to give the memo of calculation for delay of interest. And thereafter, they have responded. That is how the annexure F, the order sheet has been placed before the court. So right from commencement, the understanding was that, or the memo of calculation for delay of interest was given, and they have responded to that.
It should have gone to the adjudicating authority.
So we were before the authority. We were before the authority. We were, my lord, when we uploaded the complaint, it went for refund. Basically, lordship may kindly see for a moment the annexure F what they have placed along with the writ petition in the first writ petition, my lord, 3427. My lord, it all depends upon how the parties have proceeded with the case. My lord, the authority has granted for.
Can't be like that.
I'll try to point out
The
this.
authority itself is different.
No, what relief has been granted, this authority was competent to grant that relief. Kindly for a moment see page 59. For a moment, lordship may have 59.
Mr. Harish,
Please.
we can't say we'll grant a specific performance and take RFA jurisdiction. Can we?
These are all
Because the
party
relief is
persons,
given
my
as
lord.
that. It's not on the party in person, it's on the authority. This authority exercised jurisdiction on which it did not have jurisdiction.
My lord, the streamlining the system, my lord, I understand, my lord. That
This
requires
order
some
is
kind of a
without
correction.
jurisdiction.
That requires some kind of a correction in the official website for uploading the complaint. But insofar as this case is concerned, how it has proceeded, my lord.
That is
I think
why
I
we
wanted to point
asked Mr. Basuraj, try and sort it out. So that this matter, you can try and sort it out. And going forward, that will happen. Otherwise, if we have to go by this, we'll have to set it aside and remand it to the adjudicating authority.
That's what I suggested.
No, my lord, it has to go before the adjudicating officer as per the petitioner's case. My lord, I'm only pointing out page 59, my lord. How
You've
it has
seen that.
commenced.
You
How-
want
what
us to
has
see it
transpired.
again, we'll see it.
Lordship may after whatever my learned friend submits.
Your petition is for so and so, specific performance.
No, my lord, what has happened here basically?
all along. There was no formal written complaint. It was only by uploading of the information.
That is the complaint under the Act.
That is the complaint under the Act. But thereafter, my lord, how the commencement has taken place, the proceeding, both parties were notified. Page 59th, one second note for my side.
ಒಂದು ನಿಮಿಷದಲ್ಲಿ ಮಾಡಬಹುದು to consider your this one and remand it. It won't serve the purpose of your client.
It doesn't serve, my lord. We have been litigating,
That is why
my lord. This is
sit and discuss, if it is possible, discuss it and close it.
2022 we have been.
But instead of wasting the time, what I suggested is, the complaint is for the compensation, it should go before the adjudicating authority. Adjudicating authority under section 72 has to consider 2 or 3 parameters. So let even the other issue can be considered later.
Sit and
My friend
talk,
is
if
not
it doesn't
agreeable
talk, then
for-
come back, but
My lord, in the
our
meantime,
hands
we
are
will
tied.
sit with them, my lord.
Even now it can be remanded back to the adjudicating authority. We are ready. There it is a
Remand, my
judicial
lord, I will
officer.
make
It's a
Remand, I will
judicial.
make my submission and. leave it to
Then
your
my lord,
lordship, my
this
lord.
is the problem.
Remand, I will leave it to your
And
lordship.
you are stuck for another 6 months, at least.
That's the problem.
My friend is seeking 2 weeks' time. I will take my chance before lordship. Then if there is lot of
Yes.
court is of the opinion that
Sri
it has to
Gautam
be
Desi
remanded.
Ullar. Sri Gautam Desi Ullar seeks for and is granted 10 days time. Released on 7th August? 7th August, Friday.
Obliged.
Serial number 4.
Notes.
Request for
It's
a
a-
short pass home, my lord. She's on
ED
apply.
pass.
Apply.
Serial number 5. T. Rajaram.
Petition this case, my lords.
Yes, Mr. Rajaram?
But
Who
petitioner
appears?
is the temple priest. Also, Beluru temple, the temple, my lord. There, my lord, Halevuri was the.
Illy.
Not there.
Where is he?
India, one out. Your worship. Can you pass on?
Pass over.
Lord, Annex D is the
Pass over,
suspension order.
AJ
Lordship,
AJ
can
is
say.
not here.
Hello, Annex D is the suspension order, lords.
AJ
Please,
is
Lord,
not
please.
here. Pass over.
Serial number 6. S. Rajshekar.
Pass over. Yes, Rajshekar.
He's here.
Mr. Ashwatthappa.
They're here. Everybody's here. They're here, man.
Le idhar. Yes, Kodi. Yes. Was that in furtherance of inquiry?
Petition.
Make sure R. Page 247.
My instructions, my lord. I received it now. My lord, what had happened was, my lord, that was not an inquiry. It was not an inquiry, my lord.
Under section 25.
That's not an inquiry. Correct.
You're filing an
My lord,
affidavit?
what happened was,
You're filing an affidavit or what are you doing?
no, my lord, affidavit, my lord, I just received this, my lord. I will file it with along with a memo. But I have marked it so that for the I can file the affidavit, my lord, but I will just explain before the court, my lord.
Explain everything in the affidavit. We'll take it on record and pass orders.
Yes.
Very well, my lord.
Can't be adjourning for the sake of it. Yavag file ಮಾಡ್ತೀರಾ?
My lord, tomorrow, my lord.
And the request of learned AG released on 31st.
ಇಲ್ಲ ಇದೆ.
Serial number 7.
Your lordship's kind.
Friday.
Friday.
But yesterday, your lordship said.
Papa, don't want to pressure him.
Your lordship said, get the information. Now your lordship saying that affidavit. That is what he is.
File ಮಾಡ್ಬಿಡಿ.
ನಾಳಿದ್ದಕ್ಕಾಗತ್ತೆ.
Have it
Has all the
tomorrow.
information.
Tomorrow itself, my lord.
Don't put so much pressure on him. He has to sit here from morning to evening, get ready for next day's file. Give him a day's time.
Please.
7. Darshita DJ.
7, you're supposed to file an affidavit. Decision has been taken, my lord, so to go for a retender. So we'll be filing that affidavit. Affidavit has left the Chamarajanagar, my lord, so it could not reach here tomorrow or day after. I think for petitioners.
Additional Advocate General is making the submission, we'll record it. What
No,
is
Lord,
it?
sir, let it be an affidavit, my lord.
You
Tomorrow-
want it to?
Tomorrow, day after tomorrow. Or pass over, my lord.
Pass
Will
over.
it reach? Lords, Lords, it might.
We'll be here till 5:30. Chamarajanagar is not.
No, my lords, but no argument, my lords. It's only to place
Chamarajpeta na Chamarajnagara?
Chamarajanagar.
Nagar.
Nagar.
And it's
Not
outside.
Chamarajpet.
Yeah, the Paksal. So you'll file it day after tomorrow.
Day after, day after 2:30.
At the request of, no, you are not appearing as the AG.
No, my lords, I'm appearing as a senior counsel for R3.
At the request of Shri Ruben Jacob, Senior Counsel appearing for respond number 3, pre-list on 31st.
Please, ma'am.
Lord, if retender is going to be done, my lord,
No,
then
but-
the writ petition would not serve.
No, therefore, my lords, but it requires the,
He doesn't want it to be on his submission, he wants it to be on the affidavit.
please, my lords, and we'll place it on record, because what happens.
He is appearing as
there
a
cannot be a
Senior
tangential.
Counsel, not as the additional advocate.
Please, ma'am, not only there could be a tangential litigation, so it is better to have the blessings of the court. So please,
As the AG, then we would have said, we'll
Please.
take it as that.
please,
But you are
Let-
appearing as Senior Counsel.
please.
My lord, interim order may.
Interim order earlier granted is extended.
My apologies, my lord. Sale number 3, my lord, interim order was not extended. It may kindly
Serial
be.
number 3, interim order earlier granted is extended.
Great.
Serial number 6, as the interim order to be extended.
6, interim order.
Serial number 8, Sarvanaya.
Three sentences if I can, because it's a.
Yes.
Lots, the order is not considering each one of the charges. It says that since I have not contested the proceedings, therefore, without giving specific findings on each one of the charges, the administrator could not have been appointed, number one. Not secondly, they said that as on the date when the writ petition was filed, administrator is appointed is not correct, because we filed the writ petition even before the appointment of administrator. At any rate, not after the filing of the writ petition that the guesting has taken place. The order comes into force only after the writ petition is filed. Now, what is very important is this, one thing which they never disputed is the contents of that letter which I read to your lordships. They are permitting unauthorized persons to sit. We went with the document, 1,300 pages, 400 pages documents we went. We tendered the documents, they did not take it. It's essentially what we have said in our objection statement. Once we have taken the photographs of that, may I just pass it on, because no, the reason is there is something more than what the eye meets. If they are quasi-judicial officers who are undertaking this expropriatory exercise where an elected body is required to be displaced. Lords, we have the pen drive also, my lords, of course. Lords, your lords will find, my lords, in the first photograph itself, that we have this the person who is on the left hand side corner, my lords, is the president. In front of him, those papers are kept. These are the volumes of papers which we gave it to him. Then next page also, my lords. He's taken it. We are referring it to it. He gives it back. We are requesting him to look through the papers. We are requesting him to go through the papers so that he can give a finding. He doesn't do anything. Lords, the reason why I am submitting this is that paragraph which I read, my lord. Whoever is there in the inquiry, my lords, at page number 10. Lords, unauthorized persons are there. There are two of them, my lords, are Congress workers holding some office bearer positions in Congress party. They sit in front of the register and the inquiry is being conducted. Registrar holds the documents in his presence. We have given this complaint to the inquiry officer. Along with the photographs, we have given this complaint to the inquiry officer.
Yes.
And this is the objection which we had filed, my lords. Kindly have a look at page number 13, 1-3.
Yes.
Each one of the points which we have, which there is an allegation which was made, we have given a specific reply to each one of the points. Paragraph wise, because they say that we have not given. This is the manner in which they are doing it.
This is on 4/2/26.
Yes, when the inquiry was in force, was in vogue.
Where is the acknowledgement?
That was the date of hearing.
Where is the acknowledgement?
Lords, that's the reason why I said, no, he is not giving it. This is what we have complained even before the registrar. In the objection, we have stated. If your lordships were to turn to page number 66, paragraph number 6 in the writ petition, we have specifically stated.
Para 6 and 7, yes.
Yes, my lords. Lords, whatever we have taken and given it to him, he is not taken. On the contrary, inquiry report says we have not cooperated, we have not given in a single document.
Where are these 400 and 1,350 pages?
Lords,
here?
that first volume, we have all the documents here, my lords. 450 pages, that volume is in the office. I can just show it, my lords, please.
Order sheet sign ಮಾಡಿರೋದು. Order sheet sign ಮಾಡಿರೋದು.
As a matter of fact, we had carried these files when we had when the matter came up for consideration for the first time.
ಅವತ್ತು ಕೇಳಿದಾಗ ನೀವು ಕೊಡ್ಲಿಲ್ಲ.
ಅಲ್ಲ, ಫಸ್ಟ್ ಡೇಟ್ ಬಂದಾಗ ನಾವು ತಂದಿದ್ವಿ.
ಇವಾಗ ಇದರಲ್ಲಿ ಏನಿದೆ? 400 plus 1,350 or what is there here?
Petitioner ಹೆಸರೇನು?
400 pages volume is with the administrator because he has taken charge and it is in the office. If they permits him, we can easily take out it.
What is this?
Not this. Not this. These are the documents which is substantiating each one of the contentions which we have raised as an objection to the charges made against
This
us.
is 1,350 pages.
No, it's the paragraph number 7.
1,350
Page 66. 400 and 1,350 pages.
So what is this that you are showing us?
Lords, this is the 1,300 pages, my lords. These are the supporting documents of vouchers, construction materials having purchased, everything. These are the supporting documents.
Those 3 volumes are 1,350.
Yes.
And those are supporting documents.
These are all the supporting documents.
400 pages
are there with them.
Yes.
He has appeared every day in the order, inquiry officer. He signs the order sheet. Has he filed any saying that I am signing what I have said is not recorded? And he is not an uneducated person. He is a qualified person who signs the order sheet on
All
it.
these are there now.
My lords,
All these are there. Which can be
they should
considered.
have produced it. My lords, it is like I can cure the defect at any point of time. We kept on giving them time, 45 days, 90 days. Finally, such a huge amount of misappropriation.
We will not disturb the administrator.
Please,
If they have all these documents, you consider it and then pass orders.
on the
Lords,
inquiry,
can I-
my lords.
On the inquiry.
Let the administrator continue, my lords.
Lords,
Do that.
We will-
But
we'll-
we'll give you 15 days time or 20 days time to do it.
Lords,
and
can I
place
say
the
this, my
inquiry
lords?
report before us.
Lords, can I say this, my lords? The complainant is a member of the Bangalore Development Authority as nominated by the government and also holds an office bearer portfolio of the ruling party. He is one of the complainant. He is the one who is sitting in front of the inquiry officer when this decision is being taken. Now, wasn't I entitled to file my objections, and at least there was a requirement of giving an opportunity so that, the reason why I am saying this is administrator has to come after an inquiry worth its name is concluded, my lords, not before that.
Then if you don't want that to be done, we'll pass orders on this. No issue.
I leave it at that, my lords.
you
If an
want-
administrator is to be appointed in this fashion, my
We don't
lords,
know where it
to
will go, we'll
dislodge.
see. But if you want, now that the documents are there, last time we asked you if we had the documents, you have the documents.
Yes.
If those want it to be considered, we can direct them to consider and place the report.
Lords,
before
but the administrator can't continue till then, my lords, because the administrator.
Then we'll pass orders on it.
I leave it at that, my lords.
ಅಷ್ಟೇನಾ? ಸರ್ವಣ ಹತ್ರ ಕೇಳ್ಬೇಕು ಫಸ್ಟ್. ಎಸ್ ಅಷ್ಟೇನಾ ಅಂತ.
No, because
Last time you were saying nothing much ಅಂತ ಹೇಳಿ ಇಲ್ಲ, senior will come. Heard, reserved.
Please.
Heard reply arguments of Shri D.R. Ravishankar. Reserved.
My lords. Administrator ಇಟ್ಕೊಂಡೆ inquiry ಇನ್ನೊಂದ್ಸಲಿ.
A memo with list of documents has been filed by the petitioner, same is taken on.
Lords,
Division bench judgment of-
ನಿಮ್ದೇನ?
One judgment of the
last
division
time
bench.
judgments I was laid upon, ತಾವು ಮೆಮೊ ಕೊಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ವಿ ಅದಷ್ಟೇ, ಬೇರೆ ನೀನು
Memo along with decisions filed by the council for the impleading respond in IS 6 of 26 is taken on record. Yes.
Serial
Just
number
one
9.
division bench judgment, I'll just place it for your lordship's consideration. Para 14 and 15, my lord. So division bench has taken the view
14 and 15.
and 15. Once oral hearing is mandatory, if there is no reference in the order sheet of a oral hearing, then the order stands vitiated. Nothing further comes out of
Where are
it.
you reading?
Not para 15. The reading of the above portion of the order sheet would not record nor disclose the hearing provided to the petition upon receiving the documents. It is not clear from the above order sheet whether the proceedings are concluded or whether the proceedings are posted for orders on submitting a report. A careful perusal of the order sheet gives an impression that inquiry is abruptly adjourned without showing the next date or state of. When Rule 8(4) of the rules requires inquiry to provide oral hearing, it is absolutely necessary for the inquiry officer to record hearing provided to the society or the aggrieved person. When the society or the aggrieved person submits explanation or not, Rule 8 of the rule mandates oral hearing during inquiry. Since the order sheet records that inquiry would not disclose providing of oral hearing of the petitioner, we are of the view that report submitted by the second respondent is in violation of Rule 8(4) of these rules. Lords, even the inquiry report was not communicated, Lords. That is one judgment which we are.
No, it's communicated.
Lords, the inquiry report is required to be communicated by the inquiry officer. That is a view taken by your lordships, Lords, in the other matter.
Yes, para.
Lords, this is
again a reference to Gauss Mohammed.
yes, Lords. Para 4 is the submission recorded. Then Gauss Mohammed is referred, Lords, and then Gauss Mohammed principles is reiterated. That it is mandatory that 7.7 and 7.8 of your lordships earlier order is reiterated in Gauss Mohammed's case. This one more judgment, Lords, of a coordinate bench regarding the findings. Para 7 of this judgment, Lords. It says the requirement under Rule 8(4). It is evident that the district registrar, respondent number 2, while submitting the report, has not considered the objections preferred by the petitioner, and no finding has been recorded with regard to contents of the documents filed with the petitioner. Register has also not recorded a satisfaction whether or not evidence is recorded as provided under Rule 8(4). Therefore, it is evident that the impugned order has been passed in violation of Rule 8(4).
Yes.
None of them.
The report
One-
is sent to them and they have made a note of it in their reply to our notice also.
Just one thing which I just wanted to say, my lords, there should be of course, subject to what your lordships would feel, my lords, while passing the orders. This exercise of powers which is given under 27A is completely restricted only in public interest.
A1C.
Yes, 28(1)(c), my lords. 27A(1)(c) is only in public interest, nothing else. No such reasons are not there. They have not said that. But whenever charges are made, for an ordinary delinquent who may be even warned and let off, articles of charges are issued. I am given a chance. The mandate under the service law jurisprudence, which I could not find, my lords, with reference to this society's requirement, is that every charge will have to be read out. Every charge will have, on the basis of every charge, the inquiry is required to be conducted. Findings is required to be returned in respect of every charge. Lords, if some holistically they draw out some 50, 60 charges against me, then they say whether I have filed objections, not filed objections. Assuming I have filed the objections, you have filed objections, I have considered all the objections. There is nothing forthcoming in the objections which would falsify the statements which has been there in the allegations. Therefore, all the charges. This cannot be the nature of findings. Lords, that is the reason why I read to your lordships, not the requirement under Rule 8, which says, number 1, first they will have to tell me what are all the charges. 2, findings on those charges. So if these two things are not there, then the question of it being regarded as an inquiry itself would not arise. Otherwise, it becomes a very farcical exercise, more particularly when there are political overtones which is likely to influence the exercise of powers. It is likely. I will not say that. It is very likely. I don't say, because I have not made that the complainant himself want to come on record. I know my restrictions, but I'm just indicating, that whenever there is a possibility of a misuse, my lord, some procedural safeguards within the parameters of the law provided may have to be provided. This is the first of the judgments, if at all it comes, as to how an inquiry, the notice which is sent alleging the charges, how it should be responded back, my lord, or how the findings is to be written. Probably this will be the first judgment we made.
We'll have to apply the law as is. We may make recommendations, but law as is what is going to be applied.
Please, I'm just saying, my lord, that probably one aspect which your lordships may consider, my lords, when your lordships is considering the matter on merits, is what I said.
What we are telling you is that we'll apply law as is.
Yes, my lords.
Not on what it ought to be.
If in case I can lay my hands on any of the judgment, we are also trying to find out. my
Want
lords,
to file your written submissions?
I'll file it.
You're filed.
I'll file.
You're filed. So
I have
We have
already
not
placed,
filed minutes.
I've already placed on the
you're
last date.
placed.
I'll also file a written.
This one is limited. You want to file?
I'll file it, my lords. By the end of this week, by Friday, we will file it.
Rejoinder.
Sorry.
Adjourn ಮಾಡಕ್ಕಾಗತ್ತೆ, ಸರ್ವಣ
No, no,
ಮಾಡಲ್ಲ ಅದು.
your lords.
When will you,
Monday.
when will you prepare it?
Monday.
Heard rejoined arguments of Sri D.R. Ravishankar, learned senior counsel for the petitioner for purpose of filing of written submission on part of the petitioner, relist on 3rd.
My lord, one reply to my learned friend's arguments. The non-acceptance of the fair proposal by my lordships itself shows and proves and falsifies the case of the petitioner.
It's an option which is available. It's not.
That itself, my lords, it was very fair proposal. That
He
itself-
doesn't want the administrator to be there. It is a choice that he has made.
That's true, my lord.
Great.
Number 9.
That's, I asked for instructions from my client. That's, client wants me to place certain things, but he is also willing for a mediation, but time limit of 10 days, because, my lords, it's a VC mediation. I'll tell why. That's why, my lords. This document.
Don't make those kind of things. We can't put the mediator.
That's why I want to submit few things. If your lordship just sees one memo, we want to file.
We'll refer it to mediation. The mediator will decide how it is.
No, but my lords, I'll tell your lordship.
We can
knows.
request for expeditious. That's all.
Lords, I'll only say this. Your lordship may kindly have a look. From the page 4, my lords, that is on 5th September 2025, to all the family members, he has addressed the mail, including, this is not the, lords, I'm not talking about the JDA, but if your lordship sees in page 4, my lords, bottom, the price was indicated, sale deed was indicated, we have even sent the sale deed, but what happens after that? From London, the sister's husband communicates with him, sister communicates with him, but please come to page 8. The trouble started only at page 8. If your lordships have 8, my lords.
Yes.
One more builder is put across to them. And that lady contacts that builder saying that so and so has got. After that also, please see communications from up to June. Up to June, my lords. In fact, we have enclosed the sale deed. I want to show your lordships. They were put, the family members knew. If your lordship kindly turn to
Sale deed attachment will be there. These are not matters that we are going to consider.
No, I am only saying everyone, the sale deed also was shown to them. They were all in terms. That is only the uncle and the sister. Somebody puts one more developer. That is how it started going down. Then, my lords, to say that I tried to enter without thing. Now, please come to page number. Just for a moment, I want to show, my lords. Running page 23.
Yes.
Lords, this is, if your lordship sees down, writ petition also was sent to them, to the sister, because they were in talks with us. Even the writ petition was sent. It is not as if somebody went in a back door and got this.
We are only considering the impleading application.
Lords, our concern is only this. The problem today has occurred.
We are not deciding any of your dispute in this matter.
But mediation andre V-seal madba. Avaru obru London, obru Singapore andre.
Can I just
V-seal.
respond, my lord? My
Hello, one
client is
nimsha,
willing
let me
to come.
complete.
So he's willing to come in person from Singapore and London next week. No question of VC.
Your client is here in Bangalore?
He is here in Bangalore, my
Very
lords, and even otherwise, even now, my lords, whatever was paid to the sisters, same amount is being offered to them also. That is the offer.
Can we tell them accept it? We can't.
Allala,
For
helakala.
them to accept it.
My lord, only showing our bona fides
In this page
and the
number
sale
8,
deed,
my
if your
lord.
lordship sees, consent is given by the father.
Panindra, mediation is by consent. You are always free to say no. We have heard you, we'll pass orders. If you want to go for mediation, Mr. Ajesh is saying that your clients
Yes, they will come.
next week.
Next
they'll
week.
be-
Yes, my lord.
Next week, if
Don't-
they're
And
here,
I agree with,
if both of you choose a
petitioner's
mediator,
advocate.
we'll appoint a mediator, Mr.
Yes, my
Dailo
lord.
Olapalli
My
or
lord,
Mr.
I also agree with the petitioner's advocate that it be for 10 days because they're coming here only for this purpose.
Even better. So you are tied down to 10 days.
Please.
Yes, no
That is-
difficulty. But I want to just clarify one thing, my lord. While allegations are being made, this
Well-
gentleman Rizwan is supposed to be the partner of the so-called purchaser. My client asked me who is the purchaser. So I gave them the name of Mr. Rizwan, who is the supposedly the partner of the proposed purchaser represented by the petitioners.
That
That's
no
all.
one knew. It is not there on record. He is a builder by himself. Let's not get into that,
We should get into it.
please.
We are not going to get into any of your.
No. A new builder is brought in between.
Lords, I just have to say this, my lords,
Hmm.
in view of this memo. Prior to all this, the same builder came, gave the document, I vetted it, I settled it, and they said we will get you all out. This was in the month of October.
Correct.
Now suddenly, they just went and they did a deal with them.
My lords, let's
My lords,
not
I
get
should
into
also
it.
I should also be in the mediation only for
No,
this
no.
reason. For some reason, if they want me out, then I will go out. If they want me to be in it,
Yours is the second stage.
no,
First stage
whatever
is
it is,
this.
my lords, whatever it is, I will not interfere in so far as that discussion.
Let that first
First,
settle.
that ugly.
Let that first settle. If it settles well and good, then it goes to your stage 2. If it
Lords, then
doesn't
again,
settle,
there will be another round, my
then
lords, and if it doesn't.
if it doesn't settle, then this litigation will go on
It
for a
will
long
go
time.
on.
It's not going to end.
Lords, at least let me be out, my lords. Let it, after they do it, I will get in.
Who is going to settle you, Mr. Joshua, until they settle?
My lords,
You
my lords,
are-
ultimately, my lords, ultimately.
You are like an unsecured creditor. You are much later.
How
No,
would-
lords,
my
I would
lords,
say
I don't know, I
I'm
don't
the
want to
first
say. They would have got settled, but somebody got greedy. That's all I will say.
Please don't
Somebody,
make-
I'm not talking about the councils. I'm talking about somebody. Ellaru settle ಆಗಿರೋದು.
I am ready, my
ಅದಕ್ಕೆ
lords.
ಎಲ್ಲ-
I am ready to sit down and
ನಾವು-
resolve it. Once and for all, I'll resolve
What
it.
we can only tell all of you is
My lords, your lordship may
this family apparently has gone through a lot. It's time that they enjoy their property.
Lords, I am willing to, my lords. I've been holding on to it for the last
All of
32
you
years.
try and solve
first
this
we will
issue.
sort out amongst ourselves, please.
Solve this issue. It's not, nobody will get anything. This generation, the earlier generation did not get anything. This generation will also not get anything.
That's 32
That's why I
years, my
suggested
lords.
to them to come to India, my lord.
32 years, my lords. At least let me be a part of it.
No, not in.
No, not with regard to that discussion. I will never get into that discussion.
Let them settle, otherwise it will go for another 32 years.
That's all.
Please.
Can only request one, my lord. The mediation between the petitioner 1, 2, 3 and my clients, my lord, not with the sisters. But they've already signed some.
No.
They already signed the sale.
So
deed.
what?
The sisters have signed
That's
the
1,
sale
2, 3. I don't think they will come. I to 1, 2, 3. 1, 2. Very well, my lords. No, they should not raise any objection. Our barlila anta ashte. I have no issues.
No, no, our mediation, if at all. is
1,
between
2, 3
us.
is fine.
Your
1, 2, 3
mediation,
is
if at
fine.
all, is for sale.
Negotiation.
Only sale
It's
consideration.
not mediation, it's negotiation.
It's only sale consideration.
ಅಷ್ಟೇ ಆಗೋದು.
You are happy.
1, 2, 3, my lords. Very well, my lords.
This is
1, 2,
even
3.
better for you.
1, 2, 3 only has been communicating. All the communications are from 1 to
He'll
3.
come from London in a week's time, my lord.
This is even better for you.
Because his video, my lord, will not.
Very well. Very well.
Okay, you have any choice of mediator?
Subject to what my lord say, I just asked Learned Senior Advocate Pramod Nair if he's.
Lords, mediation center or your lordship. We don't want anyone to be suggested. Your lordship may have from the mediation center has good ones. Your lordship knows.
Yeah,
So please.
but if you have any,
No,
both of you agree on anything, you let us know.
Or you
I
Justice,
can't suggest. But
Ravindran.
Ravindran, time iralla. I don't mind ಅವ್ರಿಗೆ ಟೈಮ್ ಎಲ್ಲಿರುತ್ತೆ?
We'll have to seek for his
ಅವ್ರ
consent.
ಕನ್ಸೆಂಟ್ ತಗೊಬೇಕು.
We'll have to seek for his consent.
No, the only thing is, my lord, if it's a mediation center, it'll take a little. If it's outside, we can, because they're coming
Lord,
here only for.
I can request the council who was referred to talk to him and
We'll pass over or we'll have it tomorrow.
morning.
You can
Illa,
speak.
2:30 early. I'll ask Mr. Munraj whether he can talk to.
Any other option also, because if we send it to mediation center, the whole procedure has to be followed.
Lords, I'll find out from Mr.
Then it won't be in this 10 days. That would be difficult.
They'll come only for
Lords,
this purpose and.
Very well, my lords. Allah, Justice Ravindran, if he is willing, that is the best option. I'll find out. Unless he is also disabled, I don't know. Yakandre, this is a long drawn.
Mediation.
If there is a possibility, that's why we asked Mr. Joshua, is there a possibility? Please, any matter, all councils, please, and we can't remember whom we appeared 7 years ago. Some regular clients we remember, others we don't. It is up to you to bring it to our notice, otherwise we won't know. And many times the name of the company is different, that one is different, authorized signatory, we don't know. So if there's a, he is also a person who will never take anything without.
No, let's tomorrow 2:30. I'll find out.
If there is a conflict, you can look at anybody else also
Lords, I will find out.
and see who it is.
Or even Mr. Prashant Chandra.
Mr. Prashant Chandra is there, Ms. Laila Vallapalli is there
No,
outside.
Even Ms. Laila.
What is that other, this one?
I'll find out from Mr.
No,
Munraj.
your choice. We'll record that both of you consent.
Please, my lord.
Lords, I have filed a section 9. So if they are discussing, then let it be, let all proceedings be kept in abeyance.
They will have to come to you.
Lords, I understand, but I'm just saying that even if I'm a part of it, I will not interfere in their negotiation. But let it be done.
Not required.
Lords, your lordship.
Lords, I only feel.
At least they have come forward to try and talk.
Lords, tomorrow, if for some reason, if they settle, again, there is a prolonged litigation.
Mr. Panindra has made a submission that they step into the shoes of the owner. That's all.
We'll file a memo also.
Step into the shoes of the owner.
Lords, then again, I'll have to fight another builder. I'm a builder, I'll have to fight another builder.
As long as the owners get their money, builders,
No,
both of you
stay.
can fight for.
No, Lords,
Till
it
kingdom
should
comes.
be, it should be an.
You can afford to fight.
No, Lords, my only thing is.
Let us record it so that.
Lords,
there's no.
Yes.
Counsel for the petitioners, as also counsel for respond number, for the impleading applicant in
Impleading.
IA 3 and 4 of 26, submit that they are willing for a mediation, for the matter to be referred to mediation to try and resolve the dispute between them.
It's time-bound mediation, both of us.
For time-bound mediation to resolve the dispute between. ಅದಕ್ಕೆ ನೀವು ಇರ್ರಿ ಅಂತ ಹೇಳಿ. Sri Joshua Hudson Samuel and counsel appearing for the impleading applicant in IA number 1 of 26 submit that the impleading applicant in IA 1 of 26 also wants to be part of the mediation. The impleading applicant in IA 1 of 26 is a person who claims that there is a joint development agreement which has been entered into with the owners. Whereas petition number 1 to 3 in WP number 15824 of 26 claim to be the purchase, claim to be persons in whose favor certain of the family members have executed a sale deed which is required to be registered. The categorical submission of Sri K.N. Panila and senior counsel is that even if the sale deed were to be executed in favor of, were to be registered in favor of the purchasers, they would only be stepping into the shoes of the landowners. And as such, the claim between the purchaser and the joint developer would continue, with only the purchaser substituting the landowners. Taking into consideration the in the above circumstances, there are two sets of disputes between the parties. The first set of dispute is as regards the purchase of the property and all the owners agreeing to sell it to the petitioner 1, 2, 3 in WP 15824 of 26. And the second set of dispute is by the joint developer, by the developer who is impleading applicant in IA 1 of 26. Without the disputes between the owners themselves, as also the purchaser being sorted out, the dispute with the joint developer being the impleading applicant in IA 1 of 26 cannot be sorted out. In that view of the matter, at this stage, this court is of the considered opinion that the first stage of mediation could be held. First stage of time-bound mediation can be held between the petitioners and the impleading applicants in IA 3 and 4 of 26. The submission of Shri Ajesh Kumar, learned counsel for the impleading applicant, is that since it's only an issue relating to the consideration to be agreed upon,
And the documentation.
consideration and the documentation to be agreed upon, the mediation could be with only the petition number 1 to 3 and the impleading applicants. There may not be a requirement for petition number 4 and 5.
Petitioner 4, respondents 4 and 5. In my read, petitioner number 4.
Number 4 and 5 to be part of the said mediation. They seek for a day's time to confer among themselves as regard the choice of the mediator and make such submission before this court. Read list tomorrow at 2. The submission of an apprehension exhibited by everything by Mr. K.N. Panindral and senior counsel is that since the impleading applicants are residing in Singapore and London, a mediation through video conferencing may not.
ಅಲ್ಲ ನಾವು ಮಾಡಬಹುದು ಅಂದ್ವಿ ಅವ್ರು ಬರ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರು ಲೇಟ್ ಆಗುತ್ತೆ
Video conferencing would have to be carried out. Shri Ajesh Kumar, learned counsel for the impleading applicants, submit that the impleading applicants are ready and willing to travel to India and stay in India for a period of 2 weeks at least during the course of mediation. His submission is placed on record.
You know that Namazi, because he's an elderly gentleman, will be represented by his son, who is before my lord. He will come in person.
As long as he has
the
the necessary documentation.
Yes.
Necessary documentation.
Document.
They have no problem in speaking to.
We have communicated to him also.
Mad Mooks. Release tomorrow at 2:30.
2:30, please.
Yes.
Serial number 10.
My lord, serial number 10.1 and 10.2, my lords. I appear for the respondent number 5 and 6, my lords.
Yes, madam. What has happened?
My lords, I need some time to secure instructions and to file the affidavit, my lords. We were directed to file an affidavit. I need some time, my lords.
CJC, how much time do you want?
Lords, at least 2 weeks, my lords.
CJC seeks for and is granted 2 weeks time. Relist Ms. Reshma KT seeks for and is granted 2 weeks time. Relist on 14th August.
Great, Simi.
Serial number 11. P.N. Nanja Reddy.
Appear for the fourth respondent.
Lordship directed bill on 10/7/2026.
The appearing for respondent number 1, 2, and 3 BBMP, my lords. My lords, on the last occasion, your lordship are directed to file the photographs wherein the complete building would be visible, my lords. But however, we have not yet received the photo. I request for 2 weeks time, my lords.
You can produce it, Mr. Nanjare.
ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಅದು ನೋಡಿನೇ ತಾವು
ಅದು ಫುಲ್ ಇಲ್ಲ ಅಲ್ಲ, ಅದು ಅರ್ಧಂಬರ್ಧ ಹಿಂಗ ತೆಗೆದಿದ್ದೀರಾ.
ಎಸ್ ಐ ವಿಲ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ ಸರ್.
As well as
Counsel for
with regard
respondent
to
1 to 3 seeks for 2 weeks time to produce photographs.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋ.
as well as measurement of the property also, ma'am.
ಅದು ಅವರೇ ಕೊಡ್ತಾರೆ. It seeks for and is granted 2 weeks time to comply with the order dated 10/7/26. Relist on 11th August.
Grateful, my lords.
Serial number 12.
Well, my lord, a report was supposed to be filed. We've initiated an inquiry. We've issued notices to everyone concerned, including the medical superintendent. She was on leave that day, the person in charge and the person who ended up giving the report. All of them are now, my lord, submitting their replies. Also, my lord, what we've done is the department has directed the medical superintendent to sensitize the SOP. She's also issued a letter within the hospital itself and, brought to light what the SOP is, and she sensitized that issue. So far as an order with regard to the inquiry, my lord, will be completed within, I think, another 10 days. We'll submit that.
Is one part, but sensitization across the state.
That is,
is the
it
most
happened in that particular hospital that day.
Very good.
The entire state, my lord, the ACS is present on VC, my lord.
The other day we had a child who was 28 years suffering from anemia. We had to reject it because the report was, you had only up.
Yes, Lord. Yes, Lord. Yes.
Gives rise to a lot of issues.
17, my lord, she was anemic, I remember.
Because the medical board said there's a risk to her life.
Yes, Lord.
Could not do anything.
Admit, Martha.
Yes, madam. Ms. Shobha.
Yeah, Shobha B.
Ms. Shobha B. K9.
But this particular report, my lords, is only insofar as it relates to the report being handed over directly to the petitioner. This court has also taken notice of how the other authorities, my lords, 20 weeks she was pregnant. I've made my representations. They've
That is why we have
retained
directed the inquiry.
to the Bal Bhavan authorities, my lords. Even this.
That is the inquiry report which is going to come. But thankfully you came at least in little time, otherwise. Yes, madam.
ನಮಸ್ತೆ ಸರ್.
Namaste.
ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇಂದ ಎಲ್ಲ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ತಗೊಂಡು ಗೌರ್ಮೆಂಟ್ ಬಂದಿದೆ ಸರ್. ಈಗ ನಮ್ಮ ಹಂತದಲ್ಲಿ ಅದನ್ನ ಫೈನಲ್ ಮಾಡೋದಕ್ಕೆ 1 ವೀಕ್ ಟೈಮ್ ಬೇಕು ಸರ್.
Nodi, you can only give them a warning on it. We are not looking at any this one. It's only sensitization.
Yes,
because
sir.
periodally they should take immediate action. Not only Vani Vilas Hospital, Bere Bal Bhavan alli idide. Apart from that, the other hospitals, your childcare workers,
Yes, sir.
all the concerned and CWC under the Juvenile Justice Act. If there is any this one, that immediately the test has to be done as regard pregnancy,
Yes,
and
sir.
counseling has to happen so that they can take their decision at that time. Because they'll try to hide, the victim will try to hide. Not hide, and she will not know what it is at that
Yes.
age. And it virtually ends up in hiding and no action can be taken immediately. So NIM officers, if they are a little proactive and sensitive on what is to be done, it will be a stitch in time.
ಸೆನ್ಸಿಟೈಸ್ ಮಾಡ್ತೀವಿ ಸರ್. ಅವಾಗ ಅಲ್ಲಿ ಪ್ರಭಾರ ಇದ್ದಿದ್ರಿಂದ ಈ ತರ ಆಗಿದೆ ಸರ್. ಬಟ್ ಎಲ್ರಿಗೂ ನಾವು ಸೆನ್ಸಿಟೈಸ್ ಮಾಡ್ತೀವಿ. ಕಂಪ್ಲೈನ್ಸ್ ಇದಾಕೋದಕ್ಕೆ 1 ವೀಕ್ ಟೈಮ್.
No, because it has a lot of serious implications.
Yes, sir.
Some lives could also be saved on that.
Put the steps in 2 weeks.
Ms. Shobha B, ACS.
No, my lord, she's
No,
the-
sir. Additional secretary, sir. Additional secretary, medical education.
Additional Secretary, Medical Education, has appeared to video conferencing. She submits that inquiry is being conducted and will be completed within 2 weeks' time. Insofar as implementation of the SOP, submission is made that within 2 weeks' time, the sensitization program would be taken up, and implementation of the SOP would be taken up at all levels. That submission is placed on record, released on 24th August to enable the AGA to place the compliance report.
We'll conduct some kind of a VC training for everyone there.
You decide all those.
We'll do.
They need to know.
Yes.
How you do it is left to you.
Please.
It should not happen like this.
I understand.
That they've gone into the Bal Bhavan, mentioned about this, no action is taken for 6 weeks thereafter, 6 weeks.
Please, my lords. My lords, this court has even directed the Director General of Police to take necessary action because it was upon the instructions of the SHO Bal Bhavan retained the minor victim, my lords, saying we have to conduct mahazars, please keep her there. For 6 weeks, my lords. ಅಲ್ಲೇ ಇಟ್ಕೊಳ್ಳಿ ಮಹಾಜರ್ ಎಲ್ಲ ಮುಗಿಸ್ಬೇಕು ನಾವು ಅಂತ ಹೇಳಿ.
Person who has suffered already such a violent act.
The order was only in respect to that report which went.
Already
It was that aspect which I was addressing today. So far as the other aspect is concerned, my lord, I'll address in 2 weeks.
This is only to tell them
I understand,
that
my lord. It
you are
doesn't
looking
happen
at
again.
it. Don't take any serious action.
Please. I'll let them know.
But once they know that they have to do this, We know, we only need to remind people. Please remind them. That's all. Please.
Last four matters. List number 1, serial number 1, Kardi Sadashivappa.
My lord, serial number 1, kindly have it on third, my lord, because the similar issue is also listed on that matter. A matter with the similar issue is listed on that day, my lord. My apologies. Filed by them, the petitioner counsel only, my lord.
That is not.
Then is only whether it is gazetted or not.
Whether that amendment of 2018 is gazetted.
The similar issue is on the third. We are yet to receive the instruction, my lord. Kindly have it on third.
Yet to receive instruction. And AGA seeks fund is granted. When is that matter?
Third, my lord.
Seeks for 2 days time. Released on 3rd August.
Please.
Serial number 14, Prakash T. Hebbar.
Kindly have it on Friday.
If it gets adjourned to 19th August.
19th August.
Request of counsel for the petitioner released on 19th August.
Serial number 25.
Yes, what is the offer, Raghuram?
Sought instructions, my lord. They can of course stay, my lord, with us for, my lord, and in terms of maintenance, my lord, 25,000 per month.
Yes, but he may not stay, but it's 25,000 if he is.
Your lordships may make it an order, my lord, of the court.
We'll restrain both of you from alienating the property till next day.
Very good.
At least you will get some safety net. 25.
Please.
What is the value of the property?
Lord, 1.5 crores is what I'm told, my lord, market value.
50,000.
In fact, my lord, rent that they are getting in respect of half of that property is 10,000 only, my lord.
In Elanka.
My lord, that I specifically put that question, my lord. The lordships may.
We also live nearby there.
Lord, I know that, but would your lordships?
1.5 crores, 50,000.
May I request some reduction? I know that.
Now,
I'm sorry.
How much reduction?
Lord, I don't negotiate. I don't. That's why I'm leaving it to your lordships, my lord. Would your lordships make it 30,000, my lord? Would your lordships consider? I'll leave it at that. I don't want to.
Submission of land counsel for the petitioner is that a sum of rupees 35,000 would be paid per month as maintenance for respondent number 1 during the pendency of the above matter. The said amount being transferred to the bank account of respondent number 1 on or before the 10th of every month. The bank details to be provided by the counsel for respondent number 1 to the counsel for the petitioner. In view of the said submission, the respondent, both the petitioner and respondent number 1 are restrained from any manner alienating, dealing with, encumbering, changing the character of the subject property till the next date of hearing. Objection, land counsel for respondent number 1 seeks fund is granted 3 weeks time to file a statement of objection. Objections, if any, by 21st August, released on 27th August.
Lord, the order would have to be stayed.
Restrained.
Restrained from alienating, but because it says that we must leave possession and vacate possession to that extent.
Insofar as the handover of possession by the petitioner is concerned, the same is stayed. So far as the direction to hand over possession by the petitioner to respondent number 1 is concerned, in view of the maintenance amount being paid, the same is stayed.
Obliged.
28, Shruti C. Let's kindly pass it on. She's on her legs in court or 12, my lords.
Not thrice.
And the same.
Mentioning stage.
Either ways, my lord, what submission we made last date was, but there was another petition relating
Want
to
this adjourned by 3 weeks.
3 weeks, my lord, because
Anyway, if you have to adjourn, it will be that. The Santosh M has appeared for respondent 6. Shurudappa Shatkar as that appearing for respondent number 6. And AGA has also counsel for respondent number 3 to 5. Submit that coordinate bench of this court seized of another issue relating to the
same matter,
same list, has now posted the matter for, has reserved the matter.
Reserved the matter.
Hence, relist on 24th August.
Serial number 32, Imran Pasha.
So this matter, my lord, yesterday they have completed the survey, my lord. They have also prepared, but because it's Chikmagalur, my lord, they could not travel today. Lordship may kindly have it on Friday 2:30, my lord, then it's a submission of the report, because only I cannot have it tomorrow because if it doesn't travel.
And AGS submits that survey has been carried out.
Yes,
and report prepared, given 2 days time, we'll place the same on record.
Yes.
Relist on 4th August
My lord, if
at
it is
2:30 p.m.
Friday, my lords, Friday afternoon, my lord,
If it
submitting of
doesn't-
report, my lord.
If it doesn't come, it will get adjourned. That's why let's give him a day's time. Tuesday, by that time it will come.
Serial number 42.
Lord, this, my lord, my instructions are, my lord, there apparently there is a FIR that is filed in Basaveshwar Nagar police station, my lord. Since it was related to a cyber crime, they have referred it to Sen Police, West, Bangalore West, my lord.
What is the crime number and
That details, my lord.
which court is it pending?
My lord, that they said because the normal police station, what happened was they filed an FIR with the normal police station, that's the Basaveshwar Nagar police station. Basaveshwar Nagar police station has transferred the matter to the Sen Police. So the FIR is still with the Basaveshwar Nagar police, my lord. The Sen Police who made the party here, I spoke to them and they have said that they will collect the information, place it before the court.
When will they give us?
Tomorrow, day after, any time, my lord.
And AGS 6 fund is granted 3 days time to place on record the crime number which has been registered.
Yes.
As also the court before which the
Yes,
matter is pending. Relist on 4th at 2:30 p.m.
Wait for it.
Serial number 43.
My lords, I've been furnished with a copy of the report and some documents regarding the investigation. I need time to secure instructions.
Report has been filed.
Yes, my lords. The
Morning you filed.
Yes, my lords. No, it was filed on first itself. Copy ಇರಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. Please.
And AG,
The affidavit of the
additional
deputy commissioner has been filed. Affidavit of the deputy commissioner along with the report also.
Copy thereof has been served on the counsel for the petitioner who seeks fund is granted 2 weeks time to go through the same and make a submission. Relist on 20th August.
Great.
Serial number 46.
Saying that write a letter to the DC.
The council is on his legs, my lords. I request for next week, my lords.
Entire matter ಸ್ವಲ್ಪ
No, no, my
pressure
lords.
ಇದೆ ನನಗೆ.
Interim order we won't extend.
No, no, my lords, my lords. This council is on his legs, my lords.
Again,
Not after twice.
Then may I request to pass over, my lords. He's in quote number 4, my lords.
If it doesn't read, it won't get extended.
My lords.
That's the risk you take. Yes.
Pass over, my lords.
Pass over.
Serial number 53.
53, 53. Yes, settlement.
I appear for R3.
In which matter?
53.
53.2. Mr. Rajesh Rao.
So that he to report settlement.
What happened?
Well, the settlement deed itself shows that the case has been withdrawn by them. It's been closed. And the checks are post-dated checks. Already RTGS has been made of 2.5. And another 3 checks are given to them physically of 2.5.
That is what he
each.
wanted to verify if those checks had been given. He wanted some time to,
Please,
because he was not aware of it. Where did he go? Mr. Rajesh, idhar hai na VCL na? 53.1 and 2.
53.
Sorry, 53 and 53.
0.2, man.
53.1 and 53.2. Relist on 3rd August at 2:30 p.m.
Melissa may kindly extend the interim orders.
Interim order earlier granted is extended till next year.
Much obliged. Thank you.
54. Prashant R.
My Lordship, I am filing a memo with the case law. The case law which I would like to refer is Satish Chandra versus Sneha Ahuja, my lord.
Yes.
In page number 43. 117, the last para, my lord.
Yes.
It says, in case the shared household of a woman is a tenanted, allotted, licensed accommodation where tenancy allotment license is in the name of husband, father-in-law, or any other relative, the Act 2005 does not operate against the landlord, lessor, licensor in initiating an appropriate proceeding for eviction of the tenant, allottee, licensee qua the shared household. However, in case the proceedings are due to any collusion between the two, the woman who is living in the shared household has a right to resist the proceedings on all grounds which the tenant, lessee, licensee could have taken in the proceedings. So the embargo under section 17, subsection 2 of the Act 2005 of not to be evicted or excluded save in accordance with the procedure established by law operates only against the respondent. That is one who is respondent within the meaning of section 2Q of the Act 2005, which is husband by law. So similarly, in this case, there's a collusion between the buyer and the husband.
You have not made that buyer a party.
My lord, I request my lord to give me permission to include him in, as a party now. But my constraint is, my lord, he has entered the house without due process of law. All my things are there inside, my lord.
Can we pass any order against a person who is not a party?
I understand where my lord is coming from, my lord. I seek my lord's permission to include him as a party.
Counsel, when will you file the application? You could have done it now.
I should have done it now, my lord. I'll do it tomorrow itself, my lord.
Counsel for the case. No, there is a different owner and there is a different tenant. So both of them you need to make a party.
Please,
you won't succeed in this.
My lords, the issue is, my lord, if I can request my lord to look at the memo filed by SPP, my lord. The sale deed is annexed there.
Yes.
The date of sale deed is, just allow me a moment, my lord, please.
Mr. Counsel, please examine it properly, see where your client stands, and then take a decision.
Please, my lord. I'll just take one moment from my lords.
Please.
My lords, in the memo filed by additional government advocate, the sale deed is annexed in page number 9. The date is 4th day of March 2026. And the rental agreement is in page number 25, which is entered with the tenant on 10th March 2026. This incident happened on 26th March 2026. And the tenant, when this memo is filed by, the report is of police, my lord, who established that only I was staying this in that household till 26th March 2026, my lord. That is where I feel the due process of law is not followed. And, I'm aggrieved that, all my belongings are there. And it also sets a bad precedent, my lord. In the divorce case, if everyone sells property like this and, make the women go out of the house, then the object of the DV Act itself is compromised, my lord. That is what is my humble submission.
Counsel for report having been filed. Counsel for the petitioner seeks for and is granted a week's time to file necessary application to bring on record the purchaser as also the tenant of the subject property. Released on 6th August.
Obliged, my lord. Great.
Past over matters. List number 2, serial number 4.
Pass over.
Abhishek Marna.
No, it's on the last day they have
Yes.
relied upon that there is a predicate offense which has been stayed. Now, my lords, I may be permitted to produce the judgment of Vijay Madanlal.
Yes. Told.
Lords, Vijay Madanlal says that FIR itself is not required to proceed under section 5. May kindly come to para 162, my lords.
162.
Please, my lords. Page 223, my lords.
Yes.
As a matter of fact, prior to amendment of 2015, the proviso acted as an impediment for taking such urgent measures, even by the authorized officer, who is no less than a rank of deputy director. We must hasten to add that nuance distinction must be kept in mind to initiate prosecution for offence under section 3 of PMLA. Registration of scheduled offence is not prerequisite, but for initiation of action of provisional attachment under section 5, there need not be a pre-registered criminal case in connection with the scheduled offence. This is because the machinery provision cannot be construed in a manner which would eventually frustrate the proceedings under 2002 Act. Such dispensation alone can secure the proceeds of crime, including to prevent and regulate the commission of offence of money laundering. The authorized officer would thus be expected to also, in a given case, justified in acting utmost speed to ensure that the proceeds of crime is available for being proceeded with appropriately under 202 Act, so as to not to frustrate any proceedings envisaged by the 2002 Act. In case the scheduled offence is not already registered by the jurisdiction police or complaint filed by the it is open to authorized officers to still proceed under section 5 of 2002 Act, while contemporary sending information to the jurisdictional police under section 66(2) of the 2002 Act. Now, my lord, the Vijay Madanlal is very clear that there is no link with the predicate offence with me provisionally attached. Now, my lords, may kindly take the synopsis what they had filed.
Synopsis?
Yes.
Bharti.
Code of
Synopsis. Yes.
My lords, at page 16, this is Pavana Dibur, my lords.
Yes.
Lords, para 8.
16.
Para 18. Para
18.
18. In a given case, if the prosecution for the scheduled offence ends in the acquittal of all the accused or discharge of all the accused, or the proceedings of the scheduled offence are quashed in its entirety, the scheduled offence will not exist. Therefore, no one can be prosecuted for the offence punishable under section 3 of PMLA, as there will not be any proceeds of crime. Thus, in such case, the accused against whom the complaint under section 3 of PMLA is filed will benefit from the scheduled offence ending by acquittal or discharge of all the Similarly, he will get the benefit of quashing the proceedings of the scheduled offence. However, an accused in PMLA case who comes in the picture after so and so, my lord, this may not be relevant, only to an extent that unless and until it is quashed in entirely, he can take the benefit of that.
They are relying on decisions of the coordinate bench of this.
My lord, that is for value thereof.
As regards stay also, you cannot proceed is what they are contending. You will have to show us a decision.
My lord, I am
despite the
relying upon
stay,
Supreme Court judgment. Lord.
the Supreme Court doesn't say that it's irrespective of stay, it should proceed. The first judgment and Vijay Mohanlal says even without a complaint, it
FIR,
can go.
you can proceed.
Here, it only says it could be quashed.
Hmm.
We are speaking of in between of stay.
Yes.
Both of them are not covered under these two decisions.
My lords, what they are saying is that if the petition is quashed, my lords, if the petition predicate offence is quashed, the judgment of Vijay Surana, my lords, which has been confirmed by the Supreme Court, Madras High Court judgment, still I can proceed with the provisional attachment order, because my lords may kindly see the
Which judgment
synopsis
are you
what I have filed on 28th July.
28th
My lords,
July.
if it is quashed predicate offence, then also my lords have to look into the judgment as to on what grounds that has been quashed. My lords, on 28th of
what
July.
is it? They produce so many. Please mention the para numbers that you want to rely on. Just don't produce the judgment.
My lords, I have produced a judgment also.
You're not mentioned which para number that you want to rely upon.
My lords, I have prepared one note.
There's nothing with this.
Plus on
20th July.
My lords, there is a note on the first page.
Only this much.
No, not that document.
20th July is this.
There is one more, my lord.
24th or 20th July.
No.
There's nothing else on
8. Not 28. 20. 28.
28.
28.
Yes.
In that, my lords, the note is there, my lords.
Yes.
My lords,
How many compilations?
my lords, what to do? Lords, just because predicate offense is state, it has not attained, not even finality. May kindly come to my lords. Vijay Surana's judgment at page 7. Page 15, my lord. The relevant paragraph is at page 27.
27.
Para 27, my lords.
Yes.
ECI is born from FIR, but once the ECI is born, the umbilical cord that connects the ECI with the FIR loses its relevance, and the ECI becomes an independent document in itself. Consequently, a new life in the form of ECI emerges, which can breathe on its own without the support of the FIR. So the FIR and the ECI are two different documents, and both tend to take the shape of its own, independent of each other. Proceeds of crime is the focal point of the ECI, whereas the schedule offense is dealt with under the FIR. Further, the reliance is also placed with the aid of judgment delivered by Honorable Supreme Court in Vijay Madanlal. 29, my lords. Vijay Madanlal Supra, the relevant portion of the relevant portion to support this contention is as extracted. Suffice to observe that there being a special legislation providing for a special mechanism regarding inquiry investigation of offense of money laundering, analogy cannot be drawn from the provisions of 1973 code. In this regard, to registration of offense of money laundering, and more so being a complaint procedure prescribed in the 2002 Act, further the authorized referred under section 48 of the 2002 Act alone are competent to file such complaint. It is different matter that the material evidence collected by the same authorities for the purpose of civil action of attachment of proceeds of crime and confiscation thereof may be used to prosecute the person involved in the process of activity connected with the proceeds of crime for offense of money laundering. Considering the mechanism of inquiry investigation for proceeding against the property under this act by way of a civil action, attachment and confiscation, there is no need to formally register an ECI, unlike registration of FIR by jurisdictional police in respect of cognizance of offense under the ordinary law. There is a force in the stand taken by the ED that the ECI is an internal document created by the department before initiating penal action or prosecution against the person involved with the process of activity connected with proceeds of crime. Thus, ECI is not a statutory document, nor there is any provision under 2002 Act requiring authority referred to in section 48 to record ECI to furnish copy thereof accused, unlike 154 of 1970. The fact that ECI has not been recorded does not come in a way the authorities refer to in section 48 of the Act to commence inquiry investigation for initiating civil action of attachment of property being proceeds of crime by following prescribed procedure in that regard. My last 31. When there is a finding arrived that independently in both the FIR and ECI, can the court completely disregard those findings and bring the proceeds to an unjustified end just because one of the proceedings was quashed on the procedural technically without due imputes to the substantive grounds? My lords, may kindly turn to 36, my lords. The court's observation above hold that where a person is acquitted or absolved of a criminal activity relating to a scheduled offense, and on establishing in a code of law that the crime property is legitimate ownership, such property cannot be termed as property and in consequence of PMLA offense loses its significance. Hence, to warrant a quashing of an ECI, mere quashing of the FIR on technical grounds by itself does not make the ECI liable to be quashed. This is not the observation set out in the Vijay Madanlal case. Rather, in proceedings pertaining to quashing of an FIR in a scheduled offence, the court must have dealt with not mere procedural irregularities, but something more in the nature of substantive grounds. The exact wordings of the court culls out the object that the accused person should have been acquitted or absolved from the allegation of criminal activity relating to a scheduled offence, and that the crime properly should be rightfully owned and possessed by him. So the essence of the observation made herein is that accused person should be exonerated from the charges leveled against him. Then my lord 39. Further, when the PMLA proceeding is set in motion and prima facie findings have already been made, including completion of filing of charge sheet, then the FIR quashed after this stage cannot be a viable ground to quash the ECIR also. More so, the PMLA requires the presence of a scheduled offence to initiate proceedings under the Act. So it also becomes a mandate that the grounds on which the scheduled offence was quashed is thoroughly examined before rendering the PMLA offence ineffective. Then my lords, 10 lines from the bottom, but a reading of relevant paragraphs in Vijay Madan Lalti clearly showcased that this is not the object behind the judgment. The final summarization, when read in tandem with the observations set out in paragraphs of the judgment and also keeping in light with the explanation of section 44 of the Act, this court comes into irresistible conclusion that the cases where FIR pertaining to scheduled offence is quashed, it does not automate exoneration of the accused from the predicate offence. Rather, FIR quashes on the grounds of mere technicalities or procedural irregularities in the FIR cannot by itself from a basis to grant an automatic quashing of ECIR. Also, in the aforesaid instance, there needs to be a case-to-case examination of the offence registered under PMLA before the offence is rendered ineffectual. Hence, the moot point for consideration whether all the cases where the FIR has been quashed can pave way for quashing of FIR. This court feels that each case must be tested in its own, in consonance with the Vijay Madan Lal judgment, and a blanket application of the principle without due regard to the facts of every case shall render both the judgment and the object of the PMLA ineffective. Then, my lords, 44, 4 lines from the bottom, when the FIR was quashed purely on technical or procedural issue and not on substantive grounds, and has not made any finding to the offences or the prima facie allegation in the FIR, therefore, quashing of the FIR shall not warrant an automatic quashing of ECIR. All the more the predicate offence under section 447 of the Companies Act, which also scheduled offence under PMLA, still stands good and requires further investigation. Therefore, in view of the above, ECIR is not liable to be quashed. Now, this was challenged, my lords. That is at page 22. That has been dismissed. Then, my lords, may kindly turn to the next judgment.
Dismissed as withdrawn.
Dismissed after arguing for some time, it was dismissed as withdrawn.
Yes.
Then, my lords, the next judgment is Manik Bhattacharya. This is with respect to arrest when the predicate offence is stayed. Page 42, my lords.
Yes.
My lords, this is a case of arrest, my lords, where predicate offence was stayed at page 43. While this last line at the bottom, my lords, while testing the legality of an arrest made by an agency otherwise empowered to take into custody a person against whom agency considers subsistence of prima facie evidence of money laundering, we do not think a general protective order directed at another investigating agency could have insulated the petitioner from any coercive action in another proceeding started by a different agency. Even if there are factual similarity vis-a-vis allegations, under the PMLA, money laundering is an independent offence, and in the event there is any allegation of the Enforcement Directorate having acted beyond the jurisdiction or the act of arrest is not authorized by law, the petitioner would be entitled to apply before the appropriate court of law independently. But that question could not be examined in a special petition arising from the proceedings in which the question of money laundering was not involved. Then, my lords, the same has been held by Punjab and Haryana High Court, my lords, at page 45. My lords, relevant paragraph is at page 68. 67, my lords, para 15.
Yes.
While the schedule, my lords, two lines from the bottom. While the schedule offence is a pivotal to the accusation of money laundering, as has been held by Honorable Supreme Court in Vijay Madan Lal case, the proceedings under pre-MLA are distinct and independent. Therefore, a stay of criminal proceedings in a FIR initiated by respondent number 1 CBI would not extend to the proceedings for offences under PMLA, and they would have to wait to the outcome of the writ petition independently. Furthermore, the case of so-and-so concluded that Enforcement Directorate is not bounded by the protective orders passed in FIRs of scheduled offence. Hence, in the light of ratio of law laid down by the Honorable Supreme Court and Division Bench of this Honorable Court, the case laws relied upon by so-and-so on this issue would not advance his case, and this court respectively would disagree with those judgments. Then 18, my lords, before parting, it needs to be emphasized that the offence under PMLA constitutes a category of their own, must be viewed with utmost seriousness, as such offences not only pose a serious danger to the economic health of the nation but also impede the progress of the country. Such offences are committed with intense planning and calculation and camouflage, necessitating the investigating agency to go through the material collected with a fine comb so as to uncover such scams which, if left unaddressed, would without doubt to be fatal to the economic health of the country. Thus, the rigors of Section 45 of PMLA, which lay down an exceptionally high yardstick for grant of bail. Therefore, my lords, unless and until that FIR is first of all, my lords, the moment ACIR is filed, we are separate. Our money laundering prosecution is completely different and independent of any investigation which has been carried out in the predicate offence. Now, my lords, here is a case where the predicate offence has been stayed. We have initiated independent proceedings by registering the ECIR. We have issued the provisional attachment order in due compliance with Section 5. Therefore, that predicate offence stay will have no impact in this particular proceedings. Yes. And my lords, one paragraph of Vijay Madan Lal, my lords, had asked me with respect to value thereof, which I have explained, my lords, with Nava Nirvan as well as Pavana Dibur. The same is also, my lords, has been held in the Vijay Madan Lal as well, my lords. My lords, at 235, my lords.
Para 235, page 235.
Page number 226.
Para 235.
Yes, 235, my lords. The definition of proceeds of crime properly in PMLA are broad enough to allow confiscation of property.
Which para?
My lords, 235.
This is again in Vijay Madan Lal.
Vijay Madan Lal. My lords, that value thereof which I have already.
Again in Seema Silks and Sarees. Para 235 is again in Seema Silks and Sarees.
No, my lords, Vijay Madan Lal I have given separately. Yes, my lords. At page 223, 226. Top the page number is there. It's a booklet.
Para 226.
Page 226.
Is para 228 there?
235, my lords.
235, what we have is again in Seema Silk and Sarees. That is at page 230.
Yes, my lords. 172 also can be looked in. That is also explained, my lords. Page para 172.
172.
Yes.
It was also urged.
It was also urged before us that the attachment of property must be equivalent in value of proceeds of crime only if proceeds of crime are situated outside. This argument, in our opinion, is tenuous. For the definition of proceeds of crime is wide enough not only to refer to property derived or obtained as a result of criminal activity relating to a scheduled offence, but also of the value of any such property. If the property is taken or held outside country, even in such cases, the property equivalent to value held within the country or abroad can be proceeded with. The definition of property as in Section 2(1)(v) or is equally wide enough to encompass the value of the property of proceeds of crime. Such interpretation would further the legislative intent in recovery of proceeds of crime and vesting in it the central government for effective prevention of money laundering. We find force in the stand taken by the Union of India that the objective of enacting the act was the attachment and confiscation of the procedure of crime, which is the quintessence so as to combat the evil of money laundering. The second proviso therefore addresses the broad objective of 2002 Act to reach the procedure of crime in whosoever name they are kept or by whosoever they are held to buttress so and so, my lords. And my lords, 174(3), the order passed in section 5(1) of the Act is only a provisional in nature. The life of his provisional order passed under 5(1) is only for 1 page, subject to confirmation by an independent adjudicatory authority. Now, my lords, it's very open for them to appear before the adjudicatory authority who had issued a show cause notice and adjudicate or put across all the points what they are placing before this honorable court.
Yes.
Senior has already completed his argument, my lords. Only ground is, my lords, the 2U is not attracted in this specific.
Don't
case.
repeat anything. Yes,
Please,
already argued. If you
argue.
want to say anything in addition, you can say.
Addition, no, because he has
Heard. What is it? Rejoinder argument. Sir, rejoinder arguments. Heard,
Sir.
Heard, sir, rejoinder argument of Ms. Annapurna. Resolved.
Yes.
Serial number 5.
Yes.
I'll appear. I'll appear.
Is the one which is an appointment order which gave paid 21 years.
21.
21. Then, it's appointment order which is paid with
28.
21.
21 is your
28. 28.
petition.
Annexure.
ದುಡಿಗಳ ಬಗ್ಗೆ ರೀತಿಯ ಮನೆ ಅಂತ ನಿಮ್ಮ ಮನವಿ ಬಗ್ಗೆ ಸಂಬಂಧಿಸಿ ಹೋಗಲಿಲ್ಲ ಅದರ ಉಪದೇಶದಾರರ ವರದಿ ಮತ್ತು ಕಚೇರಿ
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ಮಿಸ್ಟರ್ ರಾಜಾರಾಮ್? ವಿಷಯ ಓದ್ತಾ ಇದ್ದೀರಾ? ಕುಣಿಗಲ್ ತಾಲೂಕು.
ಕುಣಿಗಲ್ ತಾಲೂಕು ಹುಲಿಯೂರು.
ಹೋಬಳಿ ಹಳೆಯೂರು ಗ್ರಾಮದ ವಾಸಿಯಾದ ಎಚ್.ಎಸ್. ಮಹದೇವ್ ಅವರಿಗೆ ಈ ಮೂಲಕ ತಿಳಿದುಬಂದರೆ ನೀವು ಹುಲಿಯೂರು ಹೋಬಳಿ ಹಳೆ ಗ್ರಾಮದ ಶ್ರೀ ಹುಲಿಯೂರು ದೇವಸ್ಥಾನದ ಅರ್ಚಕರನ್ನು ದೃಢೀಕರಣ ಉಲ್ಲೇಖ ಒಂದರಿಂದ ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತೀರಿ. ನಿಮ್ಮ ಮನವಿ ಬಗ್ಗೆ ಸಂಬಂಧಪಟ್ಟ ಹೋಬಳಿ ಪ್ರದೇಶದ ವರದಿ ಪಡೆಯಲಾಗಿದೆ. ಉಪದೇಶದಾರರು ವರದಿ ಮತ್ತು ಕಚೇರಿ ಲಭ್ಯವಿರುವ ಬೃಹತ್ ಸ್ಥಿತಿ ಕರೆದಲ್ಲಿರುವ ದಾಖಲೆಯಂತೆ ಎರಡನೇ ದೇವರು ಹುಲಿಯೂರು ದೇವಸ್ಥಾನದ ಭಾಗವಾಗಿದ್ದು ಈ ದೇವರ ಉತ್ಸವ ಮುಕ್ತ ಆಗಿರುತ್ತದೆ. ಸದರಿ ದೇವರ ಪೂಜೆಯನ್ನು ನಿಮ್ಮ ವಂಶಸ್ಥರು ಪೂಜೆ ಮಾಡುವುದು ಶ್ರೀ ಹುಲಿಯೂರು ಆಮೇಲೆ ದೇವಸ್ಥಾನದ ಒಂದು ಭಾಗವಾಗಿದ್ದ ಪ್ರತ್ಯೇಕವಾಗಿ ಸಸ್ತಿಪತಿಯಲ್ಲಿ ನೀಡಿದ್ದು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಹುಲಿಯೂರು ದೇವಸ್ಥಾನಕ್ಕೆ ನಿಗದಿತ ಸಸ್ತಿಪತಿಯಲ್ಲಿ ನಿಮಗೆ ಸಸ್ತಿಪತಿಯನ್ನು ಪಾವತಿಸಲಾಗಿಲ್ಲ. ನಿಮ್ಮನ್ನು ಹುಲಿಯೂರು ದೇವಸ್ಥಾನ ಒಂದು ಭಾಗ ಎರಡನೇ ದೇವರ ಉತ್ಸವ ಮೂರ್ತಿ ಅರ್ಚಕರಿಂದ ದೃಢೀಕರಿಸುತ್ತಾರೆ. I am the architect of the particular temple. That is the position degree. The second is one the second document which is produced before the court. It is not again it is an appointment order. Not my H.S. Mahadev, Lord, you worship is 31, page 30. The last paragraph, that is the H.S. Mahadeva, when next Sannappa, ಇವರಿಗೆ ಈಗಾಗಲೇ ಹಕ್ಕು ಬದಲಾವಣೆ ಆಗಿರುವುದಿಲ್ಲ. ಉಲ್ಲೇಖ ಸರ್ಕಾರಿ ಪತ್ರ ಆದೇಶದಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಪೂಜಾ ಕಾರ್ಯವನ್ನು ಈ ಮೂಲಕ ತಿಳಿಸುತ್ತಾರೆ. Now is the subject of the particular temple. Not when registration Lord. They see all the ornaments particular with the deity below is to kept in the house of this particular petitioner. The Lord should say, page 31, annex C, my Lord. Where is my Lord? It is clearly stated that all the ornaments pertain to the deity below, which is kept under the custody of the petitioner. Lord, there, my Lord, there is an order from the executive officer. Can you transfer all these ornaments Mahadeva. H.M. Mahadeva, my lord, this is he said, no, I am not the temple priest, I am the temple priest. That H.B. Mahadeva, my lord, is not a temple priest. That ornament cannot be transferred.
You are H.S. Mahadeva. H.M. Mahadeva transfer.
Mahadeva is different.
Where is that order?
Your lordship can say, that order, my lord, the Annex D.
Hmm.
Annex D is the lordship can say, shall I read, my lord?
Yes.
Lord, Annex D, page 32, my lord. Political ಹೋಗಿ ಹಳೆ ಮಾತು ದೇವಾಲಯ ಮಾಡಿಸಿ ಹಳೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಮರ ಉತ್ಸವ ಕರಡಿ ದೇವಾಲಯ ಉತ್ಸವ ಮೂರ್ತಿಯನ್ನು ಭಕ್ತಾದಿಗಳು ಮನೆಯ ಧಾರ್ಮಿಕ ವರ್ಷಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋಗುವ ಪದ್ಧತಿ ದೇವಾಲಯದಲ್ಲಿ ಪ್ರತಿ ವರ್ಷ ಶಿವರಾತ್ರಿ ವರ್ಷಕ್ಕೆ ಬರುತ್ತೆ ಸರದಿಯಲ್ಲಿ ಪೂಜೆ ಮಾಡಿ ಈ ಕಚೇರಿಯ ತಿಳುವಳಿಕೆ ತಿಳಿಸಲಾಗಿದೆ 19 ಸಾಲದಲ್ಲಿ ಎಚ್.ಎಸ್. ಮಹದೇವ ಬಿನ್ ಸಣ್ಣಪ್ಪ ಈ ಸಾಲದಲ್ಲಿ ಎಚ್.ಬಿ. ಮಹದೇವಯ್ಯ ಗೋರಯ್ಯ ಹಾಗೂ 21 ಸಾಲದಲ್ಲಿ ಎಚ್.ಬಿ. ಪ್ರಭಾಕರ್ ಬಿ ಹುಲ್ಲೂರಯ್ಯ ಮರಿಯಪ್ಪ ಕಚೇರಿ ತಿಳುವಳಿಕೆ ನೀಡಲಾಗಿದೆ. ಎಚ್.ಬಿ. ಮಹದೇವ is not a temple priest at all. Not this election clearly indicated that he was one of the temple priests, but it is not. In lordship, you can say other page which I have read, that is page 30. They said it's only 3 priests were appointed. That is one is Mahadevaya, Yogana, and Manjesh. Only 3 priests were there.
You are challenging Annexure D.
Annexure D only has challenged.
You have not made them parties to this petition.
But there this is where they not the wife kept in suspension. There is a
Mr. Rajaram, they are going to be affected by any order passed.
No, absolutely no. No other after suspension.
ನಿಮ್ಮ ಸಸ್ಪೆಷನ್ ಹೋದ್ರೆ ಅವ್ರ ಕೆಲಸ ಹೋಗುತ್ತೆ. You may be absolutely right for the sake of argument, but without making them a party, how are you maintaining this petition? You have to make H.B. Mahadeva and H.B. Prabhakar parties.
He has specific allegations against him.
You want to make them, or we dismiss the petition after? Without making them a party, how can you ask? The affected party.
Pass an order. That's on 3/11/25. Then AGA accepts the notice to respond. Then AGA seeks the for and is granted 2 weeks time.
Had been appointed.
This is the thing that they have not been objection. Wait and suspension.
3/11/25.
5 years back. Absolutely, there is no inquiry at all. In such a do not subsistence such as not can be directed to issue subsistence as well.
That subsistence allowance for it. Anyway, KCSR rules allowed 6 months.
The submission of
subject.
counsel for the petitioner is that the petitioner has been kept under suspension from 12/2/2021 and no inquiry is either commenced or completed. Any inquiry, a person can be kept under suspension for a period of 6 months without salary. After 6 months, it is required that subsistence allowance stroke wages have to be paid. In that view of the matter, learned AGA is direct secure instruction make a submission as to whether such subsistence allowance stroke wages are being paid. Learned counsel for the petitioner seeks for and is granted 2 weeks time to implead Sri H.B. Mahadevaya and Sri H.B. Prabhakar, whose rights have been dealt with in Annexure D, which is under challenge in these proceedings. Released on 19th August.
ನೋಡಿದ್ರ ಚೆಕ್ಕಿದ್ರ ಓಕೆ ಬರಲ್ಲ
You don't know if it has come for signature, we have signed. We'll see if it we can't direct like that. We will sign the order and it will get uploaded. We might have signed it in the afternoon, so we signed this much.
230 mood matter, Gaurav DK.
These are the connected matters, my lord, that 40 wires of 41 of the Consumer Forum Act, which is challenged, that one was left out, I'm told, my lord, it has to be connected with that.
What is that serial number?
Serial number 1.
Hmm? 53 ಅಲ್ಲ.
The serial number.
Again, he has not made the union a party.
Again, here also, again, he is not made union a party. That he has to impede. Serial number 11, my lord, in the morning. In that, he filed an impeding application to make the union as a party.
11.
11. Serial number 11.
And AG accepts notice for respond number 1. Notice to respond number 2 and 4 is dispensed with. Notice to respond number 3 is deferred for now. Released on, what is the date of that matter?
15/9, sir. 15th September.
Released on 15th September.
Which has not been reached. There is an urgency.
This occasion also it did not reach.
My lord,
If
Madam,
you have
list-
not heard it, it can't come in 2:30, only after hearing.
my lord, list number 1, serial number 58, my lord. I'm appearing as a party in person.
Yes.
So can it be listed by tomorrow's date, my lord?
It'll come in, dates will be given. Yes.
Please, my lord, thank you.
Serial number 81st list.
ಏನಪ್ಪ?
May I have it next week?
Date ಕೊಡ್ತಾರೆ.
Serial number 6.
Dates will always be after 19th of August.
Serial number 62, my lord. This pertains to blacklisting the RTA applicants. The difficulty is, my lord, there is an interim order operating against us. All these applicants, some of them have filed 14,000 appeals.
We had heard you in that. It should have come at
No, it was
2:30.
not heard. If it could be had at 2:30, my lord,
cases are there.
on the day which is convenient to the court at 2:30.
62 released on 19th at 2:30.
My lord, serial number 158.
Serial number 53, 53.2, my lords.
ಏನಾಯ್ತು?
I'm for respond, ಅದು acknowledge the receipt, please, please, hold, sir.
53.2 adjourn ಮಾಡಿದ್ರು.
My lord, my lord.
A memo has been filed enclosing settlement ಬೆಳಿಗ್ಗೆ record ಮಾಡಿದೀವಿ. Learned counsel for respond.
My lord.
Can you please wait? You want to dictate? Counsel for respond number?
I'm for only one respondent.
Respond number 2 confirms the settlement
Please,
which has been
confirm.
arrived at, as also receipt of the
Please,
post-dated checks. In that view of the matter, the above petition is dismissed and settled out of court.
Great.
Serial number 56, my lord. Wherein matter is, my lord, there's a tender matter. There is an interim order is operating, my lord.
Yes.
If matter will, my lord, taken up, it is because both of the successful bidder, my lord.
You are the petitioner, interim order will be extended.
But however, my lord, work order is already commenced, my lord. So that, my lord, kindly have it on Monday, my lord, it will be settled for one year in terms of the judgment of this honorable court.
One day, 182 matters are there.
231
Yes.
minute, within 1 minute, I will finish of this matter.
ಯಾವುದು 1 minute?
So,
Interim order to be extended.
my lord,
ಯಾವುದು?
62 point.
ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Serial number.
ಏನಿಲ್ವಾ?
Serial number 46, man.
ಹಾ.
In the morning, I am waiting for twice call. It is a tender matter. Pressure on me, my lord, by the authority.
Yes, Mr. Chinnappa. Please address arguments.
Worship.
46. Padi.
One small issue. If your lords want to take tomorrow morning, first matter.
Now only. Wait. 5 minutes you have.
Yes, 5 minutes is more than enough.
2 minutes actually.
Please see the interim order that is granted. Lord, may I just explain?
Yes.
The interim order, my lord, is for them to inform us that they'll abide by the purchase order of 5.25 lakh ONTs.
Release tomorrow at 2:30 p.m.
Yes, it's 1 minute only. Interim order is different.
Interim order is extended till tomorrow.
One small submission. In the morning, I had made a request. There are 3 days remaining in the time allotted to me, my lords, for the Archata rights. He has a statutory remedy available.
Is it listed today?
It is listed today, my lord.
Serial number
86, my lord.
86 release tomorrow.
Lordship,
There are 3
Lordship,
days
serial
remaining,
number
my lord.
90.
3 days is there. If I succeed tomorrow, I'll have 2 days.
Our time is up.
My lords, it's a very small issue, my lords. There is an existing statutory remedy.
You don't want it tomorrow?
My lords.
If you don't want it, we'll have it on another day. We can give it to you tomorrow, Ashte.
Well, it's my request for 2:30 tomorrow.
Yes.
serial number 84, my lords, that is actually for premiering fresh matter, my lords, that has been coming for B group, my lords. I know why is it coming for B group, my lords.
84, how will it go
84,
from
my
B
lords. I
group
made
after?
them in the previous date. I moved the memo, my lords. The date was given today, my lords.
Okay, B group can go give you.
It's a fresh matter, my lords. Note is also not been given per
84
contesting
for
party, my
consideration of
lords.
interim relief on date could you?
Malats,
Obliged,
this is
my
the
lords.
fifth day. Malats, this is the fifth day, Malats. It's getting listed, but not reaching the bench, Malats. It's being listed the following day. Aidne dina.
Same here, my lords.
We'll do one thing. From tomorrow, we'll list only 50 matters.
Malats, I just request for 2/3.
Please don't make these kind of submissions.
Malats, the reason is
Please, from tomorrow, we'll get up at 4:45. Not a minute more. We are sitting till 6 o'clock to take up the matters. Whatever reaches will be taken up at before that time. If that is a submission, then why should we sit till 6?
Serial number 78.
Sir.
20th August ಯಾವ್ದು ರೀಚ್ ಆಗ್ಲಿಲ್ಲ 20th August ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್
84
ಆಗುತ್ತೆ
mark
ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಇದ್ರೆ ಇಲ್ಲ ಇರಿ ಡೇಟ್ ಕೊಡ್ತೀನಿ ಅದೇ ಇವಾಗ ಹೇಳಿದ್ನಲ್ಲ ಡೇಟ್ 20th August 20th August 84 ಈಗ ಮಾಡಿದ್ರ ಅದು 20th ಬರುತ್ತೆ ಅವ್ರಿಗೆ ಡಿಕ್ಟೇಷನ್ ಆಗಿದೆ ಮಾಡ್ತಾರೆ ಅವರು 20th August ಎಲ್ಲ 20th August ಟ್ಯೂಸ್ಡೇ ಯಾವತ್ತು ಸರ್ ಅದು 4th ಅಲ್ಲ 20th August ಅದು ಅಷ್ಟೇ 20th August 20th August 58 ನಾಳೆ
ಮೇಡಮ್ ಎಲ್ಲಾ ಸ್ಟೇಜನ್ನು 20th August.
ಹಾ ಎಲ್ಲ 20th August ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ
ಮೇಡಮ್
ಒಂದೊಂದು 10 ಕಮ್ಮಿ ಆಗ್ಬೋದು
ಮೇಡಮ್ 86 ನಾಳೆಗೆ
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ
ಹಾ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್
4
ಅಲ್ಲ 28 28